1, 2, 1, 2. We're going to get started. Welcome to the Touro Law Review Conference, Jewish Law and American Law, a Comparative Study. For those of you who don't know me, my name is Michael Morales, and I'm the current editor-in-chief of the Touro Law Review. We're very excited to have you all here today to discuss the various aspects of Jewish and American law and compare and contrast the two legal systems. I hope and I'm sure that you will find the presentations interesting, thought-provoking, inspiring, and much more. Many of you have traveled far, some coming from across the country and others coming from across the world. We thank you for participating in this conference. Without your help and individual contributions, this event would not be possible. I would like to thank the law school and the Touro College University system, especially Provost Salkin and Dean Ballin, for allowing us to have this conference and host some of the most renowned legal scholars throughout the world. I would also like to thank our managing editor, Megan Mulholland, and our articles editor, Alexandria Tomanelli, who many of you have spoken with, who sent out hundreds of invitations to make this event possible, so thank you. Finally, and certainly not least, I'd like to thank Professor Levine and the Jewish Law Institute for co-sponsoring this conference. Professor Levine approached us a few months ago after the publication of his books with the idea of publishing a special issue in the Law Review on various topics of Jewish and American law. We did not hesitate to support him in his idea and publish a special issue, which we'll be publishing in March 2020. Any speakers or moderators that would like to publish an article in our special issue, I ask that you just please let us know so that we can follow up with you so that you do not miss the opportunity. Without further ado, I'd like to pass it over to Dean, I think Provost Salkin, if you would like to have some brief opening remarks, and then Dean Ballin thereafter. Thank you.
So I'd like to thank Michael and all of the students from the Law Review and our faculty advisor, Professor Seplowitz, for agreeing to host this symposia. I want to tell the speakers, besides thank you for not just being here today, but for your work in preparation and hopefully the submission of your articles. For those of you that are new to Law Review Symposia, don't be put off by the size of the audience. This is actually pretty typical, and I want to share with you a story about why it's important beyond what's in the room. On Friday, I had the opportunity to have lunch with a woman attorney by the name of Shirley Adelson Siegel. She's 101 years old. She was the first woman, the only woman in her law school class at Yale, the first woman hired at Proskauer, the woman first in just about every job that she ever had. And what was remarkable, I went to see her because I had read a book that just came out in 2018 about trailblazing women lawyers, and she's been written up in lots of books, but her story was interwoven in this book in a remarkable way. It led me to write to her again and to go visit her and bring her the book and share passages from the book with her. But the most important part of that day was on her table was a volume of the Touro Law Review when we did the symposia on Justice Cardozo just a couple of years ago. And she had it marked up, and she showed me how she has been methodically reading through the articles. I was amazed that she even had a copy of that volume, and I said, "How'd you get this?" And she said, I was on some list. She said, "There's very interesting articles, and I love the Law Review." And so, her connection with Touro through the Law Review, I thought that was remarkable, and it reminded me of the importance of the work of the Law Review in recording the scholarship and recording the thoughts of the people that participate in the symposia, and how this work actually has a very, very long lasting life. And so I want to thank the students to reminding them again how important this is, and thank the speakers for, again, your time, your effort, and remembering that your work and your thoughts, your writings live on, and we appreciate that you are choosing to do it through the Touro Law Review. It makes a difference. So thank you, and I look forward to hearing the presentations today.
Last night, the visiting scholars who traveled from out of town, and I had dinner around a conference table and began a conversation of some very rich and interesting topics. I have 20 minutes to continue that conversation and explore some other dimensions of it. And it should be easy in 20 minutes to cover the question, what is a code? What is Maimonides' code as compared to the US code? What is a restatement if Maimonides' code is not a code? Why did Justice Warren cite Maimonides in the most famous Supreme Court case of the Warren Court, the Miranda case in 1966? These are modest questions, right? So we can address them in 20 minutes. Well, in fact, these are questions that it would take a lifetime to address. And I want to say that last night, to sit around a table with scholars from as far away as Pepperdine to the west and Jerusalem to the east was a tremendous pleasure. Kevin used the word electric. There really was electricity in the room because we were gathered together around this subject that all of us love with questions that are unanswerable. I deliberately, those who know me and who got to know me last night, like to be provocative and ask unanswerable questions. We have a Talmudic word, teku, which means we leave it here, there is no answer. So in 20 minutes, I will say teku because there is no answer to the questions that I'm about to pose and the questions that I'm about to raise and to put to you. Last night, we were also privileged to have members of the Law Review, and I want to repeat what Provost Salkin said. The participation of each one of you, both students, professors, speakers, is deeply appreciated by us. I expect that the Touro Law Review volume that comes out of this will be sitting on many a table and will be provoking and inspiring scholars for generations, because that's the quality of scholarship that is present in this room and that was present last night. So thanks again to everyone involved in sponsoring this and for the support of many. So let me just put some questions out there, because there are some in the room who will appreciate that what we are doing in part is an exercise in comparative law, Jewish law and American law. It's in part a historical exercise because there's an archaeology of uncovering what it is that Jewish law says. But there's also a definitional question. Is Jewish law law in the same way that American law is law? So I just want to begin, for those who think about this question, there is a touchstone. It's the 1966 case in the Warren Court, 5-4, in which the question of confessions is addressed by the Supreme Court of the United States, and Justice Warren, in saying that we are skeptical of confessions, cites Maimonides. He goes back 900 years to cite a code of Jewish law, and it plays, one could debate this point, but I'm going to say it, it plays a critical role in the reasoning of the court in a case that every child knows from watching television. You have a right to remain silent. Anything you say can and will be used against you in a court of law. That originates, you might say, 900 years ago in Maimonides. And in a moment, I'll try to explain how and some of the questions that it raises. If you look at definitions of law in the early modern, starting in the early modern period, let's define that as the 16th century. You look at definitions of law in the West. They invariably include references to institutions of government or of the state or of society. The most famous definition is probably H.L.A. Hart's, in which he talks about a rule of recognition. There has to be some means by which you recognize that something is law. And in Hart, he talks about the difference between law and custom, and he talks about the rule of recognition being that something was passed as a statute by Parliament. And the book is extremely rich. It's called The Concept of Law by H.L.A. Hart, and has been the point of departure really for modern discussions of this question. When I say modern, I mean not in the sense of the 16th century or early modern, but I mean sort of within our lifetimes. And I recommend that to you. So let's just think for a second about what Justice Warren did in 1966 and the way in which he uses, you might say, Jewish law, in particular Maimonides, as a source for what it is that he wants to say. The question of confessions was a live one in the post-war period. It was very troubling to members of the court and to lawyers and other citizens that confessions were being obtained in ways that many thought unscrupulous, unwarranted, unconstitutional. And many people don't know two things about Miranda. One, it was a 5-4 decision, so it was not like Brown v. Board of Education or some other landmark cases. It wasn't a unanimous decision. It was a 5-4 decision. And many people also don't know it was a consolidation of a number of cases from across the country, both federal and state. And many people don't know that the case was remanded, that is sent back to Arizona. And Miranda actually was convicted. The conviction was sustained. So the case is very important to us as a case about evidence. It's very important to us as a case about confessions. And what is it that Justice Warren does? Exactly how does American law meet Jewish law across a gap of 900 years? The question is put where are the origins? Where do we find the origins of our prohibition against self-incrimination that's embodied in the Fifth Amendment in the Bill of Rights? Remember, not a part of the original 4,000 words of the Constitution, but adopted subsequently in 1791. Where do we get this prohibition against self-incrimination? Where does it come from? And there is a historical discussion. For the court, Justice Warren talks about the Star Chamber already in the modern period, 1637, and asserts that the roots of the privilege, quote, go back into ancient times. Go back into ancient times. He refers to Maimonides as a 13th century commentator. By the way, how many think of him as a 12th century and how many as a 13th century? We could take a vote. He spanned the two. I think of him as 12th century. So, Justice Warren, I disagree with you on that one point. I agree with the rest of the opinion. 13th century commentators found an analog to the principle, to the privilege grounded in the Bible. And of course, he's not clear about what he means by that. He does quote Maimonides, who says that we don't accept confessions. And then the next sentence is, it is a divine decree. Period. End of quotation from Maimonides. I owe Professor Sam Levine the following reaction to that. Sam said, would Justice Warren have said, suppose it was a prisoner who demanded kosher food. You must provide kosher food. It is a divine decree. Suppose the question put were, everyone has to observe Shabbat. Would Justice Warren have decided and quoted Maimonides and said, it is a divine decree? Well, Maimonides had a lot more to say. And the more that he had to say is not quoted by Justice Warren. And the more that he had to say is not something that one would necessarily associate with a code of law. In a sort of a companion case, Garrity, Justice Douglas, again cites Maimonides, and again for the proposition that we don't accept confessions. Both Warren and Douglas cite, in addition, Rabbi Norman Lamb, who was for many years the president of Yeshiva University, who was a great, as we say, a Talmid Chacham. He was a very learned man who comments on Maimonides. But even without Rabbi Lamb's commentary, I will just note this for the record. Maimonides doesn't stop at saying it is a divine decree. And by the way, the divine decree that he is referring to, I believe, I think there's consensus on this, are the rules against, the rules pertaining to witnesses. And we require 2 witnesses, and they have to satisfy a number of requirements. And you cannot be a witness for a relative, nor can a relative be a witness for you. And of course, you are related to yourself, therefore you can't be a witness for or against yourself. And Certainly you can't be a witness against yourself because that would be a related party witness, and that's the source of the prohibition biblically. Is that fair, Sam? So I think that when he says it's a divine decree, that's what he's referring to. But that's not what Maimonides says. This is the part that is not quoted. What Maimonides says is some people are self-destructive. Some people are depressed. Some people confess for psychological reasons. And so he sets forth, he sort of unfolds in this thing that we're calling a code, a view of what it means to be human, a view of the human condition, sets forth some questions about the reliability of evidence that actually pertain more broadly to everything that we do in a court. It applies to testamentary evidence, it applies to documentary evidence. It's actually much, much more than a rule. It's a rule and a rationale for the rule, and that rationale is what? Is it something that would happen if you had law in the sense of American law? So let's take American statutory. Let's take the U.S. Code. If you want to do something in the U.S. Code, you start in the House, you go to it starts in committee, it goes to the floor, you get a chairman's mark, then it's passed by the House, it goes to the Senate. There's this analogous bill in the Senate that comes out of committee, and it goes to the floor. There's a reconciliation process, it's signed by the president, and it's applied by judges. So there is this tremendous sociality of law and the promulgation of law that is connected to its legitimacy over the centuries. And that's what we think of as law in the modern period. I think you would find a consensus, and you can see an intellectual history of this in Hart's book, The Concept of Law. So that's a certain notion of law. Now, Jewish law does require, in a sense, this notion of a divine decree. And yet, when you read the specific discussion about confession in Maimonides, it's not the divine decree that he is depending upon necessarily, even though that is what five justices of the Supreme Court signed their name to in the Miranda case, and then in the Garrity case as well. So we're certainly talking about law in a different sense. And the extreme way of putting it is that, in contrast to this committee structure with a bicameral legislature and the necessity of a signature by the president and the necessity of enforcement by judges, we have one genius alone in his study. Now, that genius alone in his study is relying upon the biblical text, relying upon the Mishnah from a couple thousand years ago, set forth in beautiful classical Hebrew, relying upon commentaries in Aramaic, relying upon 11th century commentaries by Rashi in France and Germany, and by his grandchildren, the Tosafot. And so it resonates through the centuries, actually. He probably was not relying upon the Tosafot. Notwithstanding Justice Warren saying that he's a 13th century commentator. He was a 12th century commentator. So I'm going to complicate, Sam, your remark that Justice Douglas is not understanding Maimonides in Maimonides' terms when he stops the quotation after the statement that it is a divine decree. He's not understanding Maimonides on his own terms. If you take Maimonides in context, Maimonides has a lot more to say about it. And what he has to say has relevance to, as I've said a moment ago, the way we view evidence in general. The way we view evidence. The American Civil Liberties Union would love Maimonides on this point. As a former prosecutor, you might not like him as much. But here's an interesting point that doesn't arise in any discussion that I've seen of Miranda. Or at least it's interesting to me. The prohibition in Maimonides, that is by divine decree, Rabbi Lamb points out, is a prohibition against voluntary and involuntary confessions. You cannot be a witness against yourself. That is absolute. That is absolute. No confessions of any kind whatsoever, under any circumstances, right? So, but then you look at the Rashba, right, who comes after Maimonides, another commentator. You look at the Rashba, and the Rashba says, well, he already places a limitation. We cannot use a confession unless it is necessary to use a confession. And we can certainly use a confession in circumstances where there's corroboration. There's a similar discussion in Zichron Yehuda, and there is an important discussion in Sefer HaTurim, which says, if there is a rational, now I'm quoting from Sefer HaTurim, which is, we're already in the 14th century. I'm racing through the centuries here to make a point about what it means to reach back 9 centuries to Maimonides and disregard the living character of Jewish law and the way in which codes and restatements in Jewish law are perhaps different from those in American law. In each case, the decisor has an explanation. And the explanation tends to be a combination of citation to sources or statements such as it is a divine decree, and also something that we talked about last night a little bit, svara, maybe, in other words, reasoning, natural reasoning. We're given that gift, lo b'shamayim hi, the halacha is not in heaven, it's for us to figure out. So we can reason even about these divine sources. And you see in Sefer HaTurim, the statement, if there's a rational basis for a finding of guilt and the facts are common knowledge, then if the judge concludes that the exigencies of the time, by which I think it is meant if there is a high rate of crime, demand that he so rule, he has the authority to consider a confession. So that's in the 14th century. So it's already not so absolute, and that is an authoritative source of Jewish law. And let me just say, Maimonides in the 12th century and the 13th century was not viewed as an authoritative source of Jewish law, even though Justice Warren can quote him 900 years later as an authoritative source of Jewish law. And of course, he's revered today and has been revered certainly since the Brisker School and so on. So now, let's go to the decisor who, if you will, divides the early commentators from the later commentators. That's Yosef Karo. Let's go to the Shulchan Aruch, which is the authoritative, the code of Jewish law. So now we're in the 17th century. The same, by the way, we're talking about the period of the English Revolution, we're talking about the period of Hobbes and Locke, we're talking about a period that was very important for Western law. And in the Shulchan Aruch, Yosef Karo says, if crime is rampant among the people, and the Ramah adds, in a commentary on the Shulchan Aruch, roughly contemporary, the Ramah adds, and it is an exigency of the times, which goes back to, by the way, what the Sefer HaTurim had said about, effectively, if there's a high rate of crime, you can think of this as what we call in the West raison d'etat, reasons of state. If there is an emergency, or we might say executive privilege, if there's an emergency, some normal laws can be suspended. So it's not so absolute. It's very clear in the Ramah's commentary on the Shulchan Aruch. So now we're talking about 17th century and later. We're talking about the later authorities, not the earlier authorities, the Acharonim, not the Rishonim, as we say. It's already clear that this is not an absolute principle. In all matters, he should act for the sake of heaven, and he should not esteem human dignity lightly. Yosef Karo says more or less the same thing as the Sefer HaTurim, and that takes us to the 17th century. Now, I have run out of time, but I think I have put on the table the following question. Why is it that literally generations, we're talking about more than 50 years ago, generations of those who are devoted to Jewish law and love Jewish law have found inspiration and have been moved by Justice Warren's citation of perhaps our greatest codifier from 900 years ago in this landmark case, which protects defendants and protects rights, and it's really an exalted opinion. It soars you can almost sing the opinion. It's such a beautiful opinion in the way it protects the rights of defendants, in the way in which it prohibits confessions, in the way in which it requires every child knows that you have the right to remain silent. Anything you say will be used against you in a court of law. Every child knows the Miranda case from watching television or from popular culture. And it is rooted in some measure in Jewish law. It's rooted in Jewish law, perhaps taken out of context, perhaps without regard to subsequent developments, perhaps without regard to the explanation that the codifier himself gave for the ruling. But nevertheless, I think those of us who are intrigued by, or more than intrigued by, are passionate about this exercise of comparing Jewish law and American law will find in the citations to Jewish law a source of not only inspiration, but a source of debate, a source of conversation, and a fruitful source for developing further and refining further this question of confessions. Now, in 2010, some say the Supreme Court took away the rights of defendants in regard to confessions. So, between 1966 and 2010, the Supreme Court of the United States may have gone from a position in which confessions were more or less prohibited, almost to the same extent as they were 900 years earlier in Maimonides, and then it sort of swung the other way with fewer protections for defendants. But yet, when long after Miranda and Garrity are forgotten, Maimonides, the Rashba, Sefer HaTurim, Shulchan Aruch, the Ramah will be remembered. These sources are permanently valuable to us. They're forever. And for those of us, and I know that I say this with some degree of partiality, for those of us who are committed to these texts, they are always a source of inspiration. And to compare them, as we are today, to sources of American law will never stop being fruitful and will never stop being inspiring. Thank you all for being here and for participating in this great event.
I'd like to introduce the first panel on bioethics and health policy in the Jewish and American societies. This panel is moderated by Marian Stoltz-Loike, and the panelists will be Ira Bedzow and John Loike. Yes.
Okay, so I'm Marian Stoltz-Loike, and I am the Dean of Lander College for Women, which is one of Touro's undergraduate institutions, and Vice President for Online Education for Touro College. And I'm very glad to be here. I'd like to thank Michael Morales and Professor Sam Levine and Dean Harry Ballin for inviting me. Dean Ballin and also Provost Salkin beautifully overviewed Mike's, the way that Jewish law and American law have touched one another and at times intersect and impact one another. I'm pleased to begin today's discussion on that topic with two fascinating scholars. First, I'd like to mention that new biotechnologies have really revolutionized the way that we address disease and the way also that healthcare impacts society. What's important about this is that these transformations may be revolutionary, but simultaneously they're introducing a host of bioethical issues that were previously unimagined. These affect all kinds of things. They relate to parenthood. They relate to issues of identity. They relate to issues of privacy and even concerns with the foods we eat. Today's scholars are two experts within the bioethical arena who are going to discuss these new technologies and what they mean in terms of Jewish law and American law. And in particular, they're going to look at some of the new ways of marketing and selling technologies and what are the ethical and also legal issues involved in that. Since I'm the first moderator, I just want you to understand the forum, how we're doing things today. Each speaker will have approximately 20 minutes, and the moderator has the thankless task of being timekeeper. And they will each have 20 minutes to speak, followed by Q&A. And I really look forward to an incredibly exciting discussion. Our first speaker today is Dr. Ira Bedzo. I'll introduce each speaker before they make their presentation. He's the director of the Institute of Bioethics and Humanities at New York Medical College. Dr. Bedzo.
So I thought by going first, I'd be able to set the bar however I wanted to, and then people would just either raise it or lower it accordingly. Little did I know that I'd have such a tough act to follow. I'm going to just start talking, and hopefully Marion will just stop me mid-sentence when my time is up. Marion started by saying that biotechnologies are influencing not only health practice and health policy, but the way people are thinking about incorporating or applying values, both social and medical, to the practice of healthcare. When you're looking at any new biotechnology, or when you're looking at any question in how healthcare or what healthcare ramifications might be, there are usually two sources that people go to, or two types of sources that people go to. They go to law journals and see what the law says, and then they go to medical ethics journals and see what medical ethicists say, or bioethicists say. And they don't read each other, really. It's actually quite interesting, and you can see how when medical ethics is put into practice, that there's really two divergent perspectives on which the moral authority, at least in America, and then I'll talk about Jewish law afterwards, in America, on the moral authority of the medical profession. And when I say moral authority of the medical profession, I don't mean technical competence. I actually mean what gives the power to the medical professional or to the medical profession to do what it does in society. So, and again, I'm going to paint with a pretty broad brush given time, but if you ever want to talk to me about the people and the sources that I'm referring to, feel free. I look like this. You can find me in a crowd. The first view is really articulated as an adaptation of virtue ethics and claims that there's an internal morality to the medical profession, which starts with the Hippocratic Oath and Hippocrates, goes down through the generations, and even if medical professionals or physicians work within society, they don't derive their authority from society. They derive their authority from the community of medical professionals themselves. It is a tradition that has an ethos. It is a tradition that has aspirations. It has a tradition whose values are tied specifically to the goal of the profession itself. So they would actually not say the goal, they would say the ends of the profession itself, the telos of the profession of itself. The second view is a social contract theory, which means the medical profession doesn't have ends in itself. The medical profession is part of society and receives special privileges from that society in order to fulfill certain duties that the society needs. So therefore, the ethics of that profession, the goals as opposed to ends of that profession, are really societal goals that those people within this capacity have taken upon themselves for certain privileges therefrom. You can see how these play out not only in the incorporation of broader society to medical ethics discussions and vice versa, as well as the relationship of medical ethics to broader society and vice versa, but you actually see this in licensing and accreditation as well. The Jewish view is similar to a social contract theory. The difference being it's a very different social contract. So let me explain the two different social contracts, and then I'll go into the applications or the particular details of the incorporation and the licensing and accrediting. So when you look at the social contract theory in American medical ethics, the view is more about the rights of the individual that then has subsequent or consequent duties of the medical professional. And the way it ties in is you look at, from the beginning of social contract theories like Hobbes all the way to Rawls, it's what are the needs of an individual in society? What should therefore society provide as a baseline to that individual? And then how does the medical professional who receives a certain power, a certain right, or a certain authority fulfill that need that now society is given? That make sense? Yeah? Okay. With regards to Jewish social contract theory, it doesn't actually start with the rights of the individual. it starts with the duties of individuals upon each other, right? So when you look at the Jewish view of what is the professional responsibility, or what is the medical professional responsibility, it doesn't start with, well, what are the rights of a person who is sick? It starts with, what are the obligations of society upon that person who is sick? So now, given that very broad view, let's look at how that actually plays out. So within the incorporation of the relation to modern society, even if these two views are actually quite distinct and quite separate, the way they play out in practice in American law and American medical practice is actually quite murky. So I'm going to try and tease it out a little bit. So from the virtue ethics perspective, you see that the way someone becomes socialized into the profession of medicine is very much as a professional community or professional society. The idea of taking a Hippocratic oath and looking at professional autonomy is not about what is the responsibility or what are the vows or the goals that an individual takes, and that individual then has the ability to act upon it. It's what does the profession's autonomy, whatever society's ethos are, what is the profession's goals and the profession's roles to which I am now committing myself to? Moreover, the profession itself has a professional code of ethics that, while works in parallel with health law, is not seen to be directly bound to it. And when I say directly bound to it, I'll put it in this way. In the introduction to the American the American Medical Association's Code of Ethics, it starts with your classic line of ethics is not the same thing as law. We can look at law as a floor, and ethics is more aspirational. But then it says, however, in times when the law contradicts our medical ethics, it is the responsibility of the medical profession to make note of that contradiction and to work against it. Now, of course, there are always going to be footnotes of don't lose your license, don't go to jail, and so forth. But the responsibility is there. Second, even in cases where the law is allowed, or the law allows certain things, like, for example, the death penalty and so forth, the American Medical Association's Code of Ethics won't say, well, that's legal, the ethical thing to do is different. It'll always ground it in the source of its own moral authority. They'll say, even if the country allows for the death penalty, it is against or contradicts the medical provider or the physician's role as a healer to participate in this event. So it's not that we say it's legal versus ethical. We say that the ethical foundation upon which the medical profession relies disallows participation into something that society deems acceptable. You see the same thing in legislation with death with dignity. They say facilitating the death or the aid in dying even with dignity is disallowed according to the medical role or the goal of healing in the medical profession. Not to say that it's not ethical from a societal perspective, but given the medical profession's foundation, it goes against their telos. How does this play out in terms of the stickiness? So it used to be that the ethics of the medical profession used to have a very strong foundation as a state interest. It still is considered a state interest when taking into consideration many health law court cases, but the diminishment of the state interest has been commensurate with the push of social contract theory into bioethics. So you see that whereas previously the state interest of the ethics of the medical profession was quite strong in the 50s, 60s, and 70s, you don't see it as much in contemporary literature about the independent and autonomous nature of the medical ethics. With regards to the social contract perspective, health law is becoming a much stronger view or a much stronger influence on medical practice. Now, that could be because of defensive medicine. It could be because of the economic structures of hospitals and physicians and so forth. It's just a fact to consider. Most importantly, I would say, though, within medical ethics itself, there has been an incorporation of the primary principle of patient autonomy. Patient autonomy was never considered an internal value in the medical profession. until, yes, there was right to refuse treatment, but until really the right to die movement came so strongly into necessitating the reform of medical ethics. Now, the respect patient autonomy was incorporated into medical ethics, but it was incorporated into medical ethics as a demonstration really of the ambiguity between where the professional authority and professional autonomy lies. With regards to Jewish law, with a physician's obligations to treat, it's actually quite interesting. The two main laws or two main obligations that give the physician, I guess, the obligation to treat. One is not to stand idly by or stand on your friend's blood. Save people's lives. The other is to return lost objects, right? So if you think about it, it's pretty clear that the medical professional or the physician has no independent mandate to heal. The independent mandate is, well, everyone has an obligation to heal. They are more capable of healing than anyone else. Therefore, their obligation suits their capabilities. So now everyone should be thinking, wait. There is always this verse that's always quoted that says, when in the context of an injuring party, the victim should be completely healed, and therefore we know that physicians are able to heal from the term vera po yera pet. He should wholly be healed, and it shows that the medical profession has this independent obligation. But no, it's actually not an independent obligation. It goes back and actually further defends the social contract theory. Because one, it gives them permission to heal. Now you could say, well, that permission to heal is because God is a true healer, so here they have permission. But the permission itself, even if God is a true healer, and they talk about, well, what that means, shows that it's not unlike an American social contract where physicians have a right to heal based on their license, where someone who doesn't have a license doesn't have a right to heal, that the physician has a permission to fulfill their obligation that is generally commanded. Right? It forces it back into the rishus, or the permission turned mitzvah is, you have an obligation to heal just like everybody else. You may not think you can heal by this means. Actually, you have permission to heal by this means also. So it really still doesn't separate the individual from anyone else, or the profession from any other general obligation. So I'll go into, since I have very little time, I'll go into the licensing and accreditation really briefly. So from a very easy perspective, you could see that medical providers have both general licenses, or the license to practice medicine, as well as accreditation and board certification and so forth. So you see this parallel track between professional recognition and state licensing. And I just mentioned from a social contract theory, what that license is. It's a power to do something in society that other people can't have. Right? So from a Jewish perspective, or from a Jewish social contract theory, what would be the power that the physician would have given the obligations that they have that they took on based on capability? So the first is, the Jewish law actually states that a physician cannot practice, or a physician should only practice if they're given permission from a beis din. Right? Meaning that physicians in Jewish culture or Jewish autonomous society have the same licensing requirements as an American physician in American society. So granted, we don't live in an autonomous Jewish environment. Batei Din are not giving accreditation to medical professionals. So how does this actually work? In the diaspora, the way it's been reasoned out, and you see this in the Aruch HaShulchan and others, that what this really means is the medical profession doesn't have an autonomous authority or an autonomous power to engage society. They have to come under the control of the government. So if the government has a licensing and a regulating agency, then that is equivalent to the beis din giving its license to treat, or for the doctors to treat. So that's the power given, or the licensing given. The power that it gives in order to fulfill this is that physicians, when given permission by the licensing agency or the based-in, are exempt from payment from damages for all medical errors except for those of gross negligence. Right? So you can see that because there's a societal need to heal, and these physicians are fulfilling that societal need, what they get in return as the contract is exemption from payment. So in general, when looking at healthcare issues, both from American legal and American ethical perspective, and from Jewish legal and Jewish ethical perspectives, it's not enough just to look at the technical, is this usur, is this mutter, is this allowed, is this prohibited? A lot of times in cases, especially with new biotechnology, and especially in cases where the structure, the dynamic of health policy is changing, and the authority between, let's say, hospital administrators and doctors are changing, things to parse out in terms of how to interpret these normative and empirical facts is, from what perspective are people making the arguments? When you see someone making an argument from the autonomous position of the medical profession, they may come out with a very different interpretive schemata or different interpretive schema of how they might drive what the normative or the right thing to do to incorporate. Whereas from a social contract or a social ethos perspective, health policy may be very different. So too in Jewish law, when it's not just a matter of, well, this fits under this halacha, or this fits under this mitzvah. To look at what the role of medical professionals are given the goals and aims of Jewish society as dictated by Jewish law, or as embedded within or permeated through the values of Jewish law, the policies become not only much richer, but more coherent in the general whole of what Jewish law is trying to do. So, thank you.
Do you want to cue up your presentation? Okay. So now I'd like to introduce Dr. John Loike, who's a professor of biology at Touro College. He's an international scholar who has published over 150 articles on medical ethics, bioethics, cell biology, and immunology. He has spoken and taught on the ethical implications of translational medicine, both in the US and around the world, including Israel, Germany, Austria, France, England, China, Thailand, and India. Dr. Loike writes a popular monthly column in The Scientist, which focuses on ethical challenges of emerging biotechnologies. Over the last 10 years, he has brought over 150 students to Thailand to enable the next generation of healthcare professionals to more fully understand cross-cultural bioethical challenges. Dr. Loike has published in Nature, Science, Harvard Law Review, Scientific American, and The Lancet. His articles on legal issues of parenthood and post-mortem fertility have introduced new understanding of the intersection between science and law. Dr. Loike is a frequent speaker on topics of Jewish bioethics and a frequent contributor to significant publications on Jewish law, including Tradition, the Journal of Halacha and Contemporary Society, and Chakira. Dr. Loike received his BS from Yeshiva University and his PhD from Albert Einstein College of Medicine. He completed his postdoctoral training at the Rockefeller in New York. Before coming to Touro, he was a research scientist and popular faculty member at Columbia University of College of Physicians and Surgeons. And now I'd like to introduce Dr. Loike.
Thank you very much. Why, my mother would love that introduction. First of all, I want to thank Dean Bellin for the invitation and Professor Sam Levine for allowing me to speak for a few minutes. Being fully transparent, I must confess I am not a lawyer, and one of the reasons I happen to have a privilege to work with Ira, we write papers together, is I use his expertise on law and philosophy with my expertise on science, and somehow we get it published. And we agree. So let me tell you what I'm going to talk about. I'm going to talk about 23andMe and commercial DNA testing, how it may cross into unethical territories. This is just a sampling of how many companies we have today, and it's growing virtually every week. And they all do a variety of things. I can spend the next 20 minutes going through each company and telling you about that, but for time, I'm going to stop. Now, what's really interesting is direct DNA testing to the consumer has provided genetic information to over 12 million individuals in the United States alone. It's a highly profitable endeavor. And the most common inquiry is, of course, genealogy. From a psychological perspective, we all have this intrinsic desire to understand our roots, where we came from. And I think the cartoon says a lot about the limits of where we can go. We can do a lot in terms of genealogy, medical predisposition to disease, and of course, the test can even show if whether you're predisposed to doctors, which is very relevant to this institution. But I think that what's really important is to understand the breadth of the applications involved here. As I said, ethnicity, ancestry is very, very common and probably the most frequently used for this testing. Finding relatives. You submit your DNA, and these companies tell you who your brother, your father, your first cousins, second cousins. Third is determining longevity. Yes, we have technology here to determine how long you're going to live. 100 years, 110, 115, right? And the scientific basis of this has some legitimacy. We can look at effective dieting. We can create these companies for an extra, once they do the testing, for an extra $79, they will tell you what diet you should engage in to lose weight based on your genetic profile. Athletic enhancement. Who should you pick for your next, draft? Look at the DNA. See whether LeBron James is any better than Zion, what's his name? Washington, whoever it is, right? And you can look at that as well. And also, not only that, but you can design a proper diet to enhance your athletic capabilities. We can look at behavior, personality traits, adultery. There's an adultery gene. We can go into that, but that's take too much time. There's risk-taking. Which individuals are more prone to risk-taking? Which individuals can manage stress management? Sleep patterns and stress. All of this is embedded in part in our DNA. And of course, a common thing is to assess our predisposition to diseases. And these companies will offer diets, lifestyle to reduce or to mitigate the chance of developing these diseases. For one of the more recent ones is GeneSight. That's will reveal what psychiatric medications will work best for a particular patient. Simple, $69, $100 for each test. Furthermore, aims to determine whether a person has genetic markers which increase their risk for infertility. All these, and the list is growing all the time. So let's take a few minutes to talk about the legal and ethical issues associated with DNA testing. First problem is the accuracy of DNA testing. I'm not going to tell you the science behind it, but the science is, how shall I say, it's a shortcut science. If you really want to do testing, you have to sequence the letters of the remember, the chromosomes, all your genetic information is composed of letters. And they provide this set of instructions for all the characteristics. There are about 22,000 genes. They're very important. That only represents about 5% of the 6 billion letters of the human genome. And the correct way to do that is to actually sequence those genes that are associated with particular traits or diseases or whatever. That's very expensive. These companies could never do that. Okay? How do they do it? They take shortcuts. They do either microarray or PCR. It's not important. But the way they designed it is not very accurate. And in fact, about 40% of the harmful medical details that are presented to the patients are false positives. The accuracy is not very good. I'll give you some examples. I have a friend. He and his wife, they're both physicians, they underwent medical testing just for the fun of it. He came back to find out that he was 99% Jewish from Eastern Europe. Very good. It's true. They're both children of Holocaust survivors. And she came back. She was 90% Jewish and 10% Native American, which means that one of her parents obviously was on with Columbus in discovering America, which is probably not true. Another example of how inaccurate is one of my friends. Instead of giving the saliva, what you do is you just take saliva from your mouth and you send it off. And instead of doing it from himself, took his dog and sent the saliva to his dog. And of course, the results came back that this dog was, of course, 99% Jewish from Germany. And of course, it was a German Shepherd. But the inaccuracy has to be recognized. And again, then you have, of course, the medical ethics issues that the fact that 30%, only 30%, shared their medical information. They'll tell you if you're going to have a predisposition to breast cancer, ovarian cancer, to Alzheimer's disease, Huntington, on and on and on. And they say, if you accept this medical information, please share it with your physician because of the psychological, the medical consequences of all of this. But in fact, the results show only 30% share this data with their physicians. Then you have paternity, maternity identifications. All of a sudden you get back a list of relatives, and guess what? You, who live in Queens, has a mother in Montreal, a father in Mexico that you never knew about, based on the similarities of your DNA. This is very relevant to law school, of course. Forensic, as you've all read about in the last few months, the FBI went into these databases to actually capture a relative of a criminal, and based on that was able to convict a criminal based on this DNA. And of course, there are inheritance applications. You think that you've inherited, this great estate from your father, but he's not really your father from genetic testing. What does that mean? And of course, you have companies that actually, these companies, how do they make money? They make money by selling their data for profit and for research. They will sell the data without the names, without the addresses, but they sell their data. And not only that, recently these new companies are going to pay you to submit your DNA for, one of them is Neolife, for cash. $250, $500. It's a great way to make some money to support your children's college education, which is so expensive. All right, then you have privacy issues. You have issues like what happens with life insurance issues, health insurance. When they give this information to these companies, they actually sell it. And they say, in their disclaimers, they say, we will sell the information under privacy rules, of course, HIPAA and all that. We will not reveal it, but we're going to sell it to various companies. They don't specify, but they're going to sell it to health insurance companies, life insurance companies. And that information is extremely valuable. And of course, how do you educate the public? To educate, to have them understand what this DNA testing is not easy. I mean, I could go into great detail to understand the complexity of what's involved. It's not just because, I'm going to give you one example. Everybody thinks if you have the mutations in BRCA1 or BRCA2, you read Google, 80% of those individuals will develop breast cancer within their lifetime, females, right? Especially in the Ashkenazi community. That's 80%. Why isn't it 100%? Because we understand there are other mechanisms that could mitigate or overrule these genetic set of instructions. And that the public has to know about before they make a decision whether this individual who has these mutations are going to undergo a mastectomy or ovarectomy, etc. And finally, who should regulate the commercial companies, and should it be regulated? This is America, right? Everything's entrepreneurial, and maybe it shouldn't be. And finally, the Jewish ethical issues. So that's an overview of all of this. Now, let's go into a little bit of detail. Putting all of this information, all of your information on your genetics into a database allows for it to be hacked. It's very easy to hack it. How well is this information protected by these companies? Not very well. It doesn't feature any family trees, and there are many cases where, as I've told you, the data is incorrect and may be inaccurate. Also, it doesn't offer a cap on how much information. For example, for somebody, they may want to know that they have a predisposition to BRCA1 or to certain types of diseases, atherosclerosis, where you can do something about that. You could really intervene. But suppose you get information that you're going to develop Huntington's disease or early Alzheimer's disease by the time you're 50. You can't do anything. At this point in time, we can't do anything about that. What benefit does that information have to you? What are the legal consequences? One of the problematic things, of course, is the idea of this, how private this is. Do you have an obligation to tell your family if you have these medical conditions? How does it affect your self-identity, who you are? And most of these companies, there's no official genetic counseling, and that's critical because for most people, you need this genetic counseling to understand where this is coming from. And of course, family planning, you can understand that you could get these genes. What genes are going to be passed on to children? Are you going to intervene? Can you select designer babies? All these issues come a point. So this is just an example of private false positive for cancer disease to show you how relevant it is. So let's compare, for the next 5 minutes, secular versus Jewish perspective. From a legal perspective, right? And I toss this out to you. Is it legal for these companies to share this information and to sell this information either for research or for generating for life insurance companies or health insurance companies? Is that legal? Number one. Number two, from a Jewish perspective, as Ira pointed out, there's a real distinction between Jewish autonomy and secular autonomy. In secular autonomy, you have the right, as long as you don't hurt anybody else, to do almost anything that you want, from a legal perspective. From a Jewish perspective, we always have a limited autonomy. We don't have this option. So the idea of we are giving our DNA for testing, in the Jewish law, you have to say, why? What is the purpose of providing this information where there's so many problems, right? It's not like you're going to a movie to watch a movie, or you're going to buy, going on YouTube to buy some music. What is the purpose of giving this information? What are the benefits and what are the risks? At this point in time, I will be bold and say, I don't think there's any benefit. I don't think there's any benefit, and I think one has to be very careful to submit your DNA for this testing. And then you have, from a Jewish perspective and from a legal perspective, suppose you discover that my mother is not who I thought it was, but some lady from India. Does that make me a mamzer? Does that make me an illegitimate child? And in Jewish law, absolutely not. In Jewish law, a mamzer, an illegitimate bastard, cannot be proven by DNA analysis, even though it may be 100% accurate. It has to be something that the community recognizes, right? On the other side, we know that I cannot marry any siblings, brothers and sisters. So if I discover I have a brother in Washington, D.C., I cannot, or a sister, I cannot marry that person, right? So under those circumstances, if the DNA testing is relatively accurate, we are very cautious to say you are not allowed to marry that sister that the DNA testing identified in Washington, D.C. So in that aspect, Jewish law would be very resistant to allow you to do that. In secular law, I toss it out to you. What does that mean in terms of inheritance and in terms of all the legal information? Can you sue the company when they tell you you're going to have, Huntington's when you're 50, and guess what? You don't. It's a false positive. And you went through all this thing, all the psychological distress that you're going to die when you're 50 because there's nothing we can do with Huntington's. What are you going to do? So these are some of the contrasts and some of the differences between Jewish law. So in secular law, there's no problem to submit your DNA to find out your genealogy. But in Jewish law, you create certain problems in terms of who are your relatives, who are your parents. Can you identify, if you have genes, can you say, oh my God, I have all these genes. Can I use this DNA testing to select for children who don't pass on these genes? And we can do that today. Now, this is very different than going to actual genetic counseling where they actually sequence the data. The accuracy is much higher. And there, they're not going to tell you, they have a lot of information and processes by which they can help you to make the decisions. In the case of the DNA testing, they don't. So this is basically what it's up to. And who should regulate this? Should it be the FDA? Should it be the NIH? We don't know. And it's a real problem. Can they effectively regulate it? It's not easy. It's a very easy test to do in the laboratory. And all I toss out to you is, we all know stem cell therapy, big promise from the late 1990s. Today, there's only one FDA-approved stem cell therapy, right, in terms of lymphoma, there are over 700 stem cell clinics in the United States. 700, and they do the analysis in America, and they send the patients to Mexico to do the stuff. It's a very difficult thing to regulate, and who should do it, how effectively we regulate it. Thank you.
Okay, I'd like to invite Dr. Bedzo to come back. I'm going to ask a couple of questions, and then we'll take some questions from the audience. So, Dr. Bedzo, let me ask you a question. As new technologies emerge, how do you think scientists and doctors need to address the issue of playing God? Where do you see an intersection or a divide between American and Jewish law?
Okay, repeat the question one more time.
Yeah.
It's a big one.
As new technologies emerge, how do you think scientists and doctors need to address the issue of playing God? And where do you see American and Jewish law intersecting or dividing?
Okay, so the first one with regards to doctors and
Scientists.
Doctors and scientists playing God. So look, this is a really hard question. The reason why it's a hard question is because not only because the microphone isn't working, but because the goals of science and the goals of clinical care are different. Right? So when you say doctors playing God versus scientists playing God, we have to recognize it's the goal of science or scientific research is the acquisition of knowledge. The goals of clinical care is the welfare of the patient. So you could say, with regards to sciences, does a scientist want to play God because they want to have the same type of knowledge that God has? Or they want to manipulate that science for other ends, which God didn't intend? With regards to the clinician, do you want to say, is he playing God because he's saving people's lives that God didn't want those lives saved? I think you have less trouble with regards to the clinician playing God than the scientist. And I think that with regards to the scientist, and you've seen a number of examples of this, where the scientific community on any issue will pursue its research, realize that the research that it's pursuing is dangerous, try to impose a moratorium or some sort of internal regulation. You'll always have a maverick that then breaks that moratorium and continues, and then the ethical community scrambles. This is one of the things that I think that the social contract aspect of the relationship between science, medicine, and society needs to be further bolstered. I think that while the acquisition of knowledge is incredibly important, there always comes a responsibility with what to do with that knowledge and how to acquire that knowledge responsibly. The government and the internal community, scientific community and professional community, need to work together to both to have external constraints and restraints and internal motivation to act ethically. It's a big question, but I would say that's the direction.
Good. Thank you.
I agree with Ira. I'd like to say two things. The first is, of course, there's an oxymoron here. Most scientists are atheists. What are they bringing God into the equation? I think the real question is not, are they playing God? Is there a biological precedent to these technologies? We debated huge amount of resources whether you could clone a human being. Is cloning ethical? Are you playing God? And in fact, there are many, many species of animals that engage in cloning. And I think that's the real issue, is there a biological precedent, and that changes the nature of the ethical conclusion. And I think that that's what really has to be addressed from a secular perspective. From a religious perspective, there's a very interesting thing, is that when you think about DNA testing, the Talmud and the law and Jewish law has many examples where it says, go back to the family history. If there's a history of a certain disease, be careful. So they really are informative of the importance of genetic testing done in a correct manner.
I just want to add one more thing. I know.
Oh, I give you each your own microphone.
I'll use both of them. I just want to add one more thing with regards to the Jewish law perspective. Well, just because Dean Ballin brought it up, Maimonides brings it in his code, and it's brought in tshuva after tshuva. Most recently, I saw it in Rav Zilberstein, where it talks about the obligation of a Beit Din to understand science and medicine. The quote, I'll paraphrase, was, people who are worthy to sit on a Beit Din has to know all of Torah and some of certain wisdoms, such and such and such, and medicine. And the way it's always parsed out in contemporary societies, they need to know some of all of these different types of sciences, meaning they need to know a little bit of medicine just to know what they're talking about. Rav Zilberstein, based on Rav Elyashiv, changes it. Well, actually, no, I would say he actually brings it back to its original meaning and says, no. They don't need to know every type of wisdom, but of those wisdoms that they need to know really well. One of those wisdoms that they need to know really well is medicine. And the proof text that he brings is, how could a Beit Din give permission for a doctor to be licensed if they don't know what that professional or that physician will be licensed in? So from the respect of Jewish law playing God, the rabbinic establishment has to understand the science in order to understand its normative implications.
Good.
Let me just add one more thing to that, and that is that although it's not publicly stated, there's an intrinsic understanding, and that at least in Jewish law, there's the concept of self-preservation and preventative medicine. That's clear. And because there is this obligation to engage in preventative medicine, there's an additional obligation that even the individual has to be educated and have a certain basic knowledge about human physiology to be enabled for him or her to make these decisions from a Jewish perspective.
Okay, one more follow-up, Dr. Loike, to your presentation, and then we'll open it to the audience. This way I'll give you some additional time to think of your own questions. But you mentioned the fact that individual information is being sold to a variety of companies. So is it ethical or even legal to reveal and sell more to these outside vendors than it is to reveal to a patient? And how should this be regulated?
You always ask tough questions. I think in terms of regulation, I'm a little bit pessimistic, and I'll tell you why. Back in the 1970s, we just discovered the concept of an oncogene. Those are genes that will enhance your susceptibility to getting cancers. We didn't know how they work. We found them in the human chromosomes, and we could identify them. And Paul Berg had a brilliant idea. He said, let's take this oncogene and import it into a bacteria, into E. coli. Because we know how to work with E. coli. We can see what protein is being made, how it works, have a better understanding. It was a brilliant idea until Bob Pollack, who at that time was he's a student of Watson, says, whoa, are you crazy? All of us, the whole world, in all of our intestines have E. coli. If this E. coli gets out with an oncogene, will destroy the human race. So they organized a conference, the Silomar conferences, in 1974. They were brilliant. At that time, there were only about 30 or 40 scientists across the globe who was working on this. And they instituted a very remarkable self-regulation process. And that was, do not create any of these synthetic organisms with a bacteria that can live outside of the laboratory. So all the bacteria that they made these transgenetic alterations could never survive outside the laboratory. And in fact, to this day, we have no evidence that any of these bacteria ever escaped. So this is an example where self-regulation can work. Today, we can't do self-regulation. There's so many companies, so many countries. How do you regulate this? Not only in the United States, how do you regulate it across the globe? I think we can have certain guidelines, and the governments should institute certain universal guidelines, but in terms of enforcing the regulation, that's a real challenge. I should tell you what the FBI does, in case you don't know. So how does the FBI regulate or understand who's engaged in creating new bioterrorist weapons? It's very simple. They are in partnership with all the major biotechnology companies that manufacture all these genes. And if somebody requests a gene that's involved in smallpox or in hoof and mouth disease, they contact the FBI and they have heads up. Why is this group, this individual, buying this equipment, these supplies that could be used? So that does work.
Okay, so let's open it to the audience for questions.
I'm
There
so
question?
glad to see that we were back clear.
Well, I want to know what from a legal perspective, what you think.
There's some comments. So think about it a little more. I have some additional questions. Okay. So, Dr. Dean Ballin, go ahead.
In area after area, our approach to regulation is disclosure. So if you look at Dodd-Frank, trying to respond to the subprime crisis, so much of the response is to require more disclosure. If you have a brokerage account, you may get piles of disclosure that you didn't get before Dodd-Frank, or you may get it by email. It's very doubtful that anyone reads the disclosure. Did you ever try reading a life insurance policy, by the way? And it's doubtful that anyone who reads it can understand it. In the case of, if I were to say to a random sample of college-educated Americans that 40% of diagnosed diseases through commercial products that analyze genes are false positives, what percentage of that college-educated population would understand what a false positive is? And we're talking about the simplest level. And my question would be, what kinds of regulation along the U.S. model of disclosure do you think would be helpful? And more broadly, what are the implications for educators in regard to the wisdom of Jewish law or secular law on this theory that disclosure is very often the best regulatory remedy?
Excellent question. I'll tell you, I've thought about this a lot. I don't have any good answers. But one thing I do think is that I think we, as a U.S. educational system, come in much too late. And the example is in terms of reproductive medicine. We teach our children much too late to give them a sense. That's why, up until recently, teenage pregnancy was one of the highest in any Western countries. Now, in Germany, as soon as the baby is born, if it's a male, it's given a condom. If it's a female, I mean, really, education begins from very early. I think there's a benefit to that model system. If we can educate very early on what all this means, what an understanding of their body and all this stuff, that may help our understanding to enable them to make reasonable decisions. But we come in colleges and high schools to teach them this stuff, I think it's too late. And you see this with smoking, you see this with drugs, you see this all across the board, that the later we come in with this educational process, the riskier we are.
Yeah,
Dr. Pitzel.
I'll put it in a slightly different way, but similar idea. Look, American society allows freedom of the individual. So disclosure is really justified by saying, oh, you give people information that can make informed decisions. That makes sense. It used to be when, and I don't mean to be nostalgic, but we used to have a legal system and a civil society, where a civil society would be a place where there was public discourse, there was information, there was discussion over not only should this be allowed legally or not, but what would be the community's choices in making an informed decision on their community's values and so forth. Just because something is legal doesn't mean that just because we have direct-to-consumer testing companies, doesn't mean that people need to use them. There's still going to be a supply and demand. So you have a choice of saying, oh, either regulate the amount of direct-to-consumer companies, enforce or ensure that there's a lot more disclosure so people can make decisions, or recognize that when people are atomistic individuals, giving them information with no context, they may not make the best decisions. increasing, and again, this might be a crazy lost cause already, but increasing the amount of civil discourse and deepening civil society might make us, or might allow us to have the laws that we need and implement them in the ways that we want.
Let me ask you a legal question. Could we mandate that all these companies provide any medical-related DNA testing through a genetic counselor?
I'm guessing as a matter of state law, I'm guessing that states could regulate that.
Would that be effective? I think it would be.
It might be, but if I may put a question back to you about autonomy, because we're talking about the Jewish and American law, autonomos, the idea that you make a law for yourself, the Kantian idea of sort of self-regulation, but self-regulation constrained by the idea that if it's a law for me, it should be a law for everyone else. Or you mentioned the Rawlsian social contract. What, and coming back to your point about education, how can a system that is based on autonomy successfully achieve the goal of autonomy when the putatively autonomous individual doesn't have the information necessary or the understanding necessary to make a rule for himself or to understand the implications for others?
That's a very good question, and all you have to do is turn to what happens, what we call the desperate patient. The patient comes and is informed by the physician that he or she has glioblastoma, they're going to die within a year. These are the options that they have. Do you want to do stem cell therapy, dendritic cell therapy, chemotherapy, radiation? And the desperate patient not only doesn't have the education to understand it, but doesn't have the emotional stability to appreciate what happens. And what does the desperate patient say? Doc, what would you do? And that's where autonomy interfaces with, decision making.
Look, I would even say it's great that we have the word autonomy. It's not Kantian the way we use it. For Kantian autonomy, it needs the decision has to be based in pure practical reason, which means it has to be truly rational. The way we look at autonomy today is not about free will, but about free choice. It's more of a Lockean version. So we can talk about autonomy all we want, but we're really not talking about autonomy in the Kantian sense. We just borrowed the term because it sounds good, but we really talk about free choice. And you see this with patient autonomy all the time. Patient autonomy, you never really see medical providers say, well, is the choice that they're making truly rational? It's more, this is the choice that they're making. How does that fit with their rights to live the life that they want and the physician's integrity to make the decision based on clinical practice? So.
Yes, last question. And let me just pass over the mic.
Oh, no, I have no complaints. It's sort of a booming pole.
Thank you. Yes.
I'm not entirely sure. Perhaps I'm playing devil's advocate. I'm still playing with it in my head, but I want to concede that maybe. But I want to suggest that maybe we ought not worry at all about autonomy, any version of it. And here's why. So when I use my Facebook, finally my kids taught me how to do it, and I go on Facebook. And my understanding, not totally consistent with American law, but my understanding of Facebook is it's a form of entertainment. And when I go on it, I forgo willingly some sense of privacy. So notwithstanding what the contractual agreement that I may or may not have with Facebook, and notwithstanding the fact that Facebook tells us that they want to protect the information, sometimes there are breaches, my sense is you don't have an expectation of privacy if you go on Facebook and put your data and your information on it, and if you want to connect with people, that's the price you pay. Okay, assuming that's true, what I'm hearing from you is we might need to have the same approach to this kind of genetic testing. It's a form of entertainment. It costs $60 to $100. 40% of the time it's not true or it's inaccurate. And if I order the test, I do it in part for the, so maybe that all falls into place. I don't tell my doctors, I only tell my doctors 30% of the time because nobody really believes it's that accurate. And do I really need to worry about privacy? Not so much. If companies want to commercialize or monetize my information, I should expect it just like Facebook does it. And if you don't want to have your information monetized, don't order the test.
Okay, thank you. I just want to caution Dr. Bedzo and Dr. Loike to answer this really excellent question concisely, just in the interest of time.
I'll do it 2 seconds, even though it deserves a much larger answer. If it was just entertainment, I 100% agree with you. The difficulty is when science turns into clinical relevance and clinical practice, then the healthcare model is not simply based on contract. There's a fiduciary responsibility based on the vulnerability of patients. So once you recognize that vulnerability, it's hard to just say, oh, who cares about autonomy? Now, granted, autonomy and vulnerability conflict. That's a tension that at least has to be recognized in order to parse out.
So every year I invite the FBI to speak to my students. And we had a discussion about privacy with the 2 FBI agents. And one said a very profound statement. It says, your privacy is restricted to your home. Once you leave the home, we can do whatever we want in terms of video, recordings, etc. You give up your right for privacy. And the other FBI agent said, you're crazy. We have a right to privacy across the globe. We need permission. So this is really a very touchy and very sensitive issue that we haven't resolved.
Okay, I want to thank our excellent speakers, Dr. Bedzo and Dr. Loike, for first beginning the conference on the first panel and also raising some incredibly important issues that I think as time evolves, we're going to see affecting how we think about ethics, how we think about law, both from a Jewish and from an American perspective. So thank you.
Thank you to the speakers and to the moderator. I'd like to introduce the second panel on philosophical and policy influences in Jewish and American law, moderated by Edie Ward, Professor of Law at St. John's University. I got yours up here. Yeah, it's on the other side. Very much for coming.
Good morning. My name is Edie Ward. I'm on the faculty of St. John's Law School, and it's my pleasure to have been invited to moderate as part of this conference, which celebrates and builds on the work of Professor Samuel Levine, who was a former colleague of mine at St. John's. The first panel set a very high bar, which will only further motivate this distinguished panel today. We have the largest panel and therefore the longest panel of the day. So I will also have the thankless task of keeping them on schedule so that there's time for questions at the end. The topic, the philosophical and policy influences of Jewish and American law, is extremely broad and opens up the opportunities for rich and interesting discussions, which will at least begin today. I'm going to introduce each speaker as he speaks, just before he speaks, and we'll, again, keep time strictly. We'll take questions at the end, and I also encourage the panelists to participate in that comment and question period. Our first speaker will be Professor Robert Cochran, who is the Louis D. Brandeis Professor of Law at Pepperdine University. He's published 10 books and over 60 articles. His books include Christian Perspectives on Legal Thought with Michael McConnell and Angela Carmella, Lawyers, Clients, and Moral Responsibility with Thomas Schaffer, Law in the Bible, Justice, Mercy, and Legal Institutions with David Van Drunen, and more than that, obviously. He is the founder of Pepperdine's Herbert and Eleanor Newtbar Institute on Law, Religion, and Ethics, and co-founder of the Global Justice Program. With no further ado, Mr. Cochran.
Let's see. Well, thank you very much, and it's so great to be here, with my good friend Sam Levine. Um, Again, you may know that we were on the faculty together at Pepperdine for several years, and I have the greatest admiration for Sam. I very often put on conferences that focus mainly on Christian perspectives of law, and then I would call on Sam to give a Jewish perspective, and I guess you could frame what he's asked me to do as returning the favor, or if you call it a favor. But anyway, I do greatly appreciate. I do see it as a favor and an honor to be able to speak to this group. Sam, I like to call Sam my rabbi, or I got into the practice of calling Sam my rabbi when he was at Pepperdine. Rabbi, of course, just means teacher. I guess it has more serious definitions within the Jewish faith. I'm not sure my tradition or his would find it appropriate that I called him rabbi, but I do it anyway. And in his absence, I occasionally call Michael Helfand rabbi, even though technically Michael's not a rabbi, but then technically I'm not Jewish either, so I guess maybe that's okay. This opportunity today has caused me to reflect on both some things that I learned from Sam Levine and some things I learned from Chaim Saman. Sam's insight about Jewish law, or I guess it's an insight that others have shared, but the insight that I gained from Sam that's been helpful to me in thinking about Christian perspectives of law is that you have a body of law or a body of insight about law that can be viewed much in the way that we view other bodies of law as informing American law, without saying, well, we should just adopt Jewish law or we should adopt Christian law, but that we can view this body of law much as international lawyers treat comparative law, or judges treat the law of other jurisdictions. Here's a body of law that may have implications for an issue that I'm facing, and the reasoning that goes into their decision might influence the decisions that I would make. I think that was a very helpful insight to me, rather than the suggestion, oh well, we're going to impose Jewish law, or we're going to impose a Christian view of law on things. Chaim did a critique of the book Christian Perspectives on Law. He actually did a review of 3 books for the Journal of Law and Religion, 2 of which that I'd edited, but these were early books that were bringing Christian critiques to law. And his comment was that we didn't find very much discussion in those books of what he would call law. That Christians had insight about social policy issues that these books addressed, but there wasn't much discussion of what Jesus might say about law. There wasn't much analyzed in the way that lawyers would analyze law and draw implications. And I took that as a great challenge, and have written several things that have tried to analyze what Jesus's perspective on law would be, in particular his perspective on the Mosaic law, and what implications we might draw for law generally, and for American law they will address today. And let me see, I haven't practiced with this to get the PowerPoint to move forward. What? Right now keyboard. Okay, gotcha. Thanks. First, to clear away what oftentimes is said about Jewish law by Christians, which I think is wrong. So one of the critiques that Jesus brought to law, and he addressed the Mosaic law, was that was a criticism of legalism at the expense of the heart. And so from Jesus' Sermon on the Mount, I've just included a couple of the sections where he'll identify a legal standard, and then he'll say, well, that's not all there is. There's a concern with the heart. So you've heard it was said, you shall not kill. Whoever does will be liable to judgment. But I said, who's angry with his brother is liable to judgment. Or you've heard it said, you shall not commit adultery. I say, someone who looks at a woman lustfully has already committed adultery in the heart. And over, there's a, he's reacting to a law, and he's saying, no, what's really important is the heart. Well, very often the Christian critique is, well, Jews are legalists. Jesus' concern is with the heart, and so we need to have our focus there. And I guess I sort of started with that notion, but what I've learned from my Jewish friends and actually from a more serious look at the Hebrew scriptures is that there's a deep concern with the heart there as well. And I think this criticism that Jesus makes is probably better made, within the communities. I think both of our communities have people that tend toward legalism and concern with the details of the rules and lose sight of character and matters of the heart. On the other hand, both of our communities have people that maybe err on the other side, that are antinomian, that ignore the law, and I think Jesus's focus on the heart might speak to both of our communities. Areas where I think Jesus does make comments that might be helpful in understanding law, and that I think he may bring something fresh, is that as he looked at the Mosaic law, he was able to summarize when he was asked what was the greatest commandment, identifying 2 commandments, love the Lord your God with all your heart, mind, soul, and strength, and then love your neighbor as yourself as the 2 great commandments, and identified these as the standards by which law might be interpreted, Mosaic law might be interpreted. In identifying these, at least the Greek translation of Jesus' statements, whether he ever uttered the word agape or not, but the New Testament translated his statement, or presented his statement using the word agape for love. The Septuagint had used the word hesed here. The Septuagint had translated the Hebrew word hesed as agape. So it wasn't, this wasn't a Christian or a Jewish creation. That is the use of the term agape here. But agape at the time was a word that didn't have very much content. It was really for Christians as they looked upon the life of Jesus and his teaching to add content to it, and it of course that content, Jesus was drawing that content from the Mosaic law. Well, what did he add at least I think, maybe in the questioning and discussion with my Jewish friends, I can be clarified. My thoughts can be clarified here. What did he add to an understanding of what agapic love might be, particularly as applied to humans, as opposed to our love for God? The parable of the Good Samaritan within Christian circles is very often contrasted with a legal standard. The parable of the Good Samaritan often summarized, well, you should love others. It creates a standard of love for personal life, our interaction with individuals. It's not thought of generally as being a legal parable, but in context, it's very much related to law. If you look at the parable of the Good Samaritan, which I've got on your screen, it's a lawyer who asks the question of Jesus, what should I do to inherit eternal life? And then Jesus responds with a legal question. What's written on the law? How do you read it? Interestingly here, the lawyer repeats back to Jesus the standards that I mentioned earlier. That raises, that is, love of God and love of neighbor, summarizing the law. That raises a question in my mind whether the New Testament here is even presenting this as an original thought by Jesus, that is, this summary. And so it may have been a standard summary of what the law was at the time. But as a torts professor, I think it's interesting that the lawyer responds with what I would call a duty question. That is, who is my neighbor? So you've got a duty to love your neighbor as yourself. Who is my neighbor? Is this, do we come up with a Cardozo answer or an Andrews answer? If you'll think back about your torts duty questions. And then Jesus goes on to tell the story, the well-known story of the Good Samaritan. So we've got a Jew that's asking a question, to whom do I owe a duty? And Jesus starts with, an individual being beaten and left on the side of the road, who then is assisted by the Samaritan. It's a very interesting story. It doesn't seem initially to respond to the question, unless you get into the story, you identify with the individual who's beaten, and then you experience the gratitude that is likely to have been felt toward the Samaritan. And the implication I draw from it is not only that your duty runs to everyone, but this broad-based duty to love the neighbor as yourself is a duty which is not just imposed on Jews and through Jesus on Christians, but is imposed on Samaritans and humans generally. The second issue that I'll address, or the second statement of Jesus that I'll address, was Jesus's statement, the Sabbath was made for man, not man for the Sabbath. Jesus made this statement or statements like it in situations where his disciples or he was engaged in activity on the Sabbath, and was criticized for them, gathering grain to eat as a snack as they wandered through a field, or in Jesus' case, his healing on the Sabbath. Here, course, Jesus, I think, was giving a standard that should be applied in trying to address Sabbath regulations. But I think that what we have is a standard that justifiably can be expanded beyond it. I make the argument that it could justifiably be expanded to suggest that the Mosaic Law was made for humans, not humans for the Mosaic Law, and beyond that, that law generally should be made for humans, not humans for law. And I'll quickly say that as to the Sabbath, having shared Sabbath dinner twice with Sam Levine's family and seeing his son Yehuda overjoyed at our coming for Sabbath dinner over the past years, I was actually quite envious of him. I try and get my kids to have family dinner. I did. They would be resistant when I told them family dinner was the highlight of my day. They looked at me as if, boy, this guy has a pathetic life, doesn't he? And I wish I'd been able to say, well, God told me you have to have family dinner with us. But anyway, I mean, I think Protestants and Christians have much to learn from our Jewish friends about the value of Sabbath and what it should be. That being said, Jesus' comment is that the standard that should be applied is one of what benefits humanity. And of course, he was talking about one of the largest, one of the sections that occupied the largest percentage of the Mosaic Law as it was described. I think that given his comments about the Sabbath, it has implications for all of the Mosaic Law and how it should be judged. And for a couple of reasons, I think that can be extended and draws implications for law generally. Those reasons, I mean, the notion of agape law and its agape love, and what Jesus said about in the story of the Good Samaritan, that standard is broader, that it applies to Samaritans. I think that it applies to all, and this standard of law should be judged by its effect on humans, I think is a universal standard. Jesus, in commenting on a couple of things within the Mosaic Law, looked back to creation as a standard by which he judged the Mosaic Law. When he talked about Moses's permission for divorce, he says it wasn't so from the beginning, that the joining of two people was for life and was not to be drawn asunder. He pointed to creation, which would suggest that these standards apply to all of humanity and might be a matter of judging all of human law. And I've got 30 seconds to wrap up. Let's see, what shall I say in my 30 seconds? I'll just say that, I'm hoping that during the day we can explore these notions with me if you'd like to discuss them further. And once again, thanks for Sam and all of you for having me with you.
Thank you for those remarks. Our next speaker is Dean Moshe Sokol, who is Dean of the Lander College for Men. He holds a PhD from the University of Pennsylvania. He is a professor of philosophy and Jewish studies at Touro's Graduate School of Jewish Studies. He's also taught at the University of Pennsylvania and New York University. He served Touro College in a variety of administrative capacities, including founding and directing the Graduate School of Jewish Studies and a collaborative medical program with the Technion in Israel. He's widely recognized in his field and has written or edited 5 books and published dozens of articles on ethics and Jewish studies in major British, American, and Israeli journals, and lectured at conferences around the world. Dean Sokol.
Thank you, Dean Ballin, for inviting me, and Professor Sam Levine. It's great to be here. I feel like I'm coming home in a way. So law is about self-restraint in many ways and discipline, and so I have disciplined myself by reading from a text. In that way, it is far less likely that I will exceed the boundaries of my time. And in any case, the field that I come from, everybody reads papers. Nobody does it extemporaneously. I've passed around some source sheets. My presentation falls within the general category of law and narrative. I'm not a lawyer, but I will be looking at a narrative from Rabbinic Times, which I think has considerable interest to those who study the law, Jewish law, and Jewish law more broadly. The source sheet, by the way, goes on 2 sides. Akavia ben Mahalalel, the first-century protagonist in the narrative I shall discuss, dissented from the majority on a matter of Jewish law and painfully suffered the consequences of that dissent. What was his jurisprudence? What motivated him? What exactly was his fate? Did he change his views over the course of his lifetime? What deathbed advice did he offer his own son? These questions are taken up in a passage in Mishnah Ediot, text you have, a compilation of teachings on a variety of subjects composed in Yavna shortly after the destruction of the Second Temple. As it happens, and perhaps for very good reason, we possess few teachings of Akavia, primarily those included in this Mishnah. A second teaching of a non-legal nature is recorded in another Mishnah in Pirkei Avot. I quote, Akavia ben Mahalalel said, reflect on 3 things and you will avoid transgression. Know where you came from, where you are going, and before whom you will have to give an account and reckoning. Where you came from a putrid drop. Where are you going? To a place of dust and worms and maggots. And before whom will you have to give an account and reckoning? Before the Supreme King of Kings, the Holy One, blessed be He. This crucial message appears to have served as the guidepost for Akavia's own tragic life, as we shall see. Our narrative begins by reporting that Akavia attested to 4 laws. The rabbis in the court responded with an offer. If you retract these 4 testimonies, we will appoint you Av Bet Din, head of the Supreme Rabbinical Court, a position second only to the Nasi, the leader of the Jewish community in court. It would appear that the rabbis in effect wished to bribe him into abandoning his position by promises of great rabbinic prominence. Surely that is unexpected, to say the very least. Akavia's response to their offer was tart indeed. He asserts that he would rather be called a fool his entire life for rejecting the gain of high office than be evil before God just for a moment. He then adds that he does not want people to say of him that because of personal gain he retracted his position. For our purposes here, let us focus on the first point, that Jewish legal truth and personal conscience may never be sacrificed. If people think him a fool for abandoning great personal gain, those considerations are irrelevant. As Akavia taught in Pirkei Avot, nothing matters but God's righteous judgment. The values of social status, wealth, Prestige, which the rabbis offer, are no more than byproducts of the physical dimension to the human condition, which ends in burial and decay, for which reason they are not values at all. The only enduring dimension of the human being, the only dimension which possesses absolute value, is that which adheres to God and to the truths of his Torah. The rabbis and he speak different languages and possess incommensurate values. What they value and seek to bribe him with is simply of no value at all to Akavia. Thus, Akavia's teachings in Pirkei Avot illuminates his response to the rabbi's offer. That said, how are we to understand the offer of the rabbis? How could they even attempt to bribe a person by offering him high office, especially a person with such deep and uncompromising principles? While we cannot say for sure, as the text does not explain itself, I would conjecture that the rabbis meant to say this. You, Akavia, take an isolated position against the majority view. We understand and respect your convictions. However, true human greatness does not lie in isolation. It has been said that humans are by their very nature political animals, that we live and function only within society. You must recognize the essential social context of the human condition. You are a great scholar, and the social context within which you live is the community of scholars. If you accept that reality and choose to conform to its standards, then because of your knowledge, deep principles, and gifts, we will make you its leader. On this account, the offer was not so much a bribe as it was a means to foster within him the social consciousness which would make his ascension to high office deserved. The Mishnah next proceeds to identify the 4 points of law in which Akavia opposed the majority. Only one is germane to our analysis. During temple times, a woman accused of an adulterous relationship by her husband, under certain well-defined halachic circumstances, becomes a sota, and according to biblical law must drink mei sota, special waters which are probative of her guilt or innocence. The question at hand is whether or not these laws apply to a female convert, as well, or only to a woman born Jewish. Akavia took the view that they do not apply, while the sages maintained that they did. In support of their position, the sages recount a tradition according to which during temple times, Shemaiah and Avtalion, the two heads of the Sanhedrin then, of the Jewish court, required a female convert by the name of Karkamis to drink mei sota. This demonstrates that the sages were correct. Akavia responded, somewhat enigmatically, that they made her drink by example. His response, asserts the Mishnah, led the sages on the court to excommunicate him, and according to this tradition, he died excommunicated, whereupon the court stoned his coffin. Before we examine the meaning of Akavia's response and the very harsh response it evoked, it is first important to observe that the debate at hand could not be resolved on the basis of halachic argument, which is how halachic differences are typically adjudicated. This is because the debate between Akavia and the sages was a debate about which oral tradition was correct. As will be evident later, Akavia maintained that he possesses an impeccably reliable tradition, and that the majority position amongst the sages that the convert could not drink mei sota was wrong, while the sages maintained with equal certainty that they had an impeccably reliable tradition that a convert could drink mei sota. The debate was only over testimony about the tradition and which testimony is correct. In other words, the debate was about a matter of fact, the in principle empirically verifiable reliability of an oral transmission, rather than a matter of value, what the halacha by virtue of its own inner logic should require. Therefore, the proof the sages offer is an empirical one, attesting to the reliability of their tradition. Interestingly, Akavia does not doubt the reliability of the sages' tradition regarding the practice of Shemaiah and Avtalion. He concedes the facts, yet casts doubt upon the utility of that precedent in adjudicating the law. How does he do so? By asserting that Shemaiah and Avtalion made her drink by example? What is the meaning of this somewhat obscure phrase? The classical commentators offer two fairly similar interpretations. The one I shall focus on here turns on the personal status of Shammai and Avtalyon themselves. For according to various rabbinic sources, they themselves were converts. As such, Akavia argued, they had a vested interest in regularizing the status of converts, for which reason they treated Karkamis, the female convert, like any other Jewish woman. In effect, Akavia was arguing that Shammai and Avtalyon's position was tainted by personal interest, and their practice could not serve as a legal precedent. Pardon the example, but it would be like arguing that a Hispanic U.S. judge must recuse himself from sitting on a case in which the defendant is Hispanic as well. If this is what Akavia meant, it would be a shocking accusation outside the pale of standard halachic discourse. Indeed, it seems fair to ask how he could even make that claim. By way of sharpening the question, consider the position of Rabbi Yehuda, cited next in the Mishnah. Rabbi Yehuda could simply not accept the fact that a man of Akavia's stature was excommunicated. God forbid, he proclaimed, that Akavia was excommunicated, for the temple courtyard is never locked for any man of Israel who has the wisdom and fear of sin like Akavia ben Mahalalel. Rabbi Yehuda maintained that it was simply unthinkable that Akavia might have been excommunicated, and the oral tradition must have confused Akavia with somebody else. Akavia, in his view, was unimpeachable. Now, this perspective sharpens one question while answering another. It sharpens the question of how Akavia could have made the comments he did, given his extraordinary stature. However, it helps answer another. Why were the sages so disturbed about Akavia's descent that they felt compelled to offer him high office? The answer may well be that precisely because of Akavia's stature, his descent was all the more dangerous. If an average scholar were to dissent, it would not threaten the viability of the system for halachic adjudication. However, dissent by a man of Akavia's stature could lead to a schism in the community, whose consequences might be its irreparable splintering. The sages sought to avoid this at all costs. But given Akavia's stature, why then did he cast aspersions on the great Shammai and Avtalyon? Part of the answer, I would suggest, lies exactly in the praise Rabbi Yehuda offered. Akavia feared sin. His teaching recorded in Pirkei Avot stressed the same theme. All that matters in life is how one stands before God in judgment. Akavia lived every moment in the presence of God and in fear of his judgment. He could tolerate not a whiff of deviation from that exacting standards, not in himself and not in anyone else, no matter their stature. For all these reasons, he suspected the worst in the case of Akavia, Shemaiah, and Avtalyon. However, we might still ask why a suspicional load would render that decision invalid. Surely the reputation was outstanding, and that should have been sufficient. Nevertheless, Akavia possessed, I would also suggest, an unshakable commitment to the truth as he saw it. Any halachic decision which may have been motivated even only slightly by factors unrelated to halachic truth render the decision unreliable and therefore halachically illegitimate. For these reasons, Akavia rejected their position. Time passes, although we don't know how long, and we next meet up with Akavia on his deathbed in a final conversation with his son. Interestingly, his son remains anonymous. We do not know his name or anything about him, but for this dialogue. He remains lost to the rabbinic tradition, much like the teachings of his father. In reading this passage, we must ask ourselves whether or not Akavia has changed in any way over the years, whether or not he has softened his views. What advice can a great, if ostracized dissident offer his son as he leaves the world? My son, Akavia says, retract the 4 teachings I used to say. Now, upon reflection, this is astonishing indeed. Akavia sacrificed his whole social life and religious stature because he was convinced that his oral tradition was correct. How could he then advise his son to abandon those very halachic positions for which he had sacrificed so much? His own son asks a similar question. If you want me to abandon those positions, why then didn't you? There is only one halachic truth. Either you were right or you were wrong. If you were right, then I cannot abandon your position. And if you were wrong, why then didn't you abandon your position yourself? Akavi's response is a fascinating one and turns on a distinction between legal process and legal truth, or some might have it, legal positivism and legal reasoning and legal realism. While there may or may not be an objective legal truth regarding the status of these disputed cases, legal practice is always determined by following the formal processes for adjudicating disputes. One of the cardinal principles for such adjudication is adherence to the minority. Thus, Akavia meant to say to his son, I am in possession of an impeccably reliable tradition, which I myself heard from a majority of scholars, that the majority took the position I did. Although my colleagues maintain that they are in a position of an equally reliable tradition, I cannot abandon my oral tradition for theirs, because I myself heard it from a majority. Thus, the formal procedures for the adjudication of halacha do not permit me to abandon my position. However, Akavia continued, your position is quite different. You heard my oral tradition from me, and you heard the sage's oral tradition from them. I am a lone advocate of my position, while they are not. Therefore, the formal procedure of majority rule requires you to abandon my position, while at the same time requiring me to sustain it. We should note here that there is a curious and tragic consequence of the recommendation Akavia makes to his son, which is that he condemns his own halachic position to permanent extinction. The very halachot for which he staked his life will be lost to future generations, since his son will follow his advice and not adopt his father's view, and therefore no one else will either. From this perspective, Akavia's recommendation is altogether remarkable. For one thing, it demonstrates his ability to live by the distinction between halachic truth and halachic process. He had the capacity to fully integrate the conviction that if the halachic process is a good one, then God's will has been fulfilled, irrespective of halachic truth. If the son follows a healthy halachic process and conforms to the majority, then God's will has been done, even if it runs contrary to Akavia's own conviction about what is correct. Now, it is one thing to understand this distinction, but it is altogether different to fully internalize and live by it. This is especially true when living by it means the distinction of the very halachic positions for which one has sacrificed so much. How did Akavia manage this feat? Derives from his experience of God as articulated in Pirkei Avot. All that matters is standing before God righteously. Now, if God wills that the halachic process follows the majority, then his son follows the majority, then all is right with God. And Akavia wants no more out of life than that. He had the capacity to completely dissociate himself from his own personal needs and the feelings he might have had when advising his son, because these needs simply didn't matter to him at all. The concluding dialogue in the Mishnah further sharpens this perspective on Akavia. His son finally asks Akavia to commend him to his colleagues. Akavia responds in his usual curt style that he cannot. His son then asks him why. Is he unworthy in some way? In his very last words recorded before dying, Akavia responds, no, you are not unworthy. Your own actions will draw you near, or your own actions will distance you. At one level, this is the advice of old Akavia. Letters of recommendation will do you no good. Your own knowledge of Torah, your integrity, your commitment to the truth will determine your standing in the community of scholars. Each individual creates his or her own destiny by the way he or she lives and by the critical choices made, for there is no escaping individual responsibility in shaping a life. While his son must abandon Akavia's halachot, he must never abandon the principles which made Akavia the man he was. Those were Akavia's last words. Yet it is difficult to avoid hearing in these final words another message as well. For if Akavia taught his son a powerful message about life, would that very message not apply to his own life as well? The words draw you near and distance you are telling indeed. For Akavia himself was first near the fellowship of scholars and then distanced himself from them, all because of his words and actions. If Akavia were to apply to himself the advice he gives his son, then Akavia here takes responsibility for the critical choices he made in his life. Does he regret any of those choices? We have no evidence that he does, and given the portrait we have drawn of him, it seems unlikely he would. That said, we do find a softening, a stress on the importance of following the majority for his son, and of thereby re-entering the community of scholars. After all, Akavia had learned from bitter personal experience just how painful that ostracism can be. Moreover, we must distinguish between his refusal to retract his halachic positions and the acerbic comments he made about Shemaiah and Avtalion. While I find it unimaginable that he would regret the decision to remain loyal to his oral tradition, I do wonder about the harsh comments he made regarding Shemaiah and Avtalion. For it was those harsh comments that provoked the painful ban in the first place, and at the very end of his life, it was that pain he advised his son to avoid. Of course, we can never really know. All we have are his final words, which echo long after we read them. Thank you.
Thank you, Dean Sokol. Our next speaker is a colleague of mine on the faculty of St. John's Law School, Keith Scharfman, who teaches and writes in the areas of antitrust, bankruptcy, commercial law, corporate finance, corporate reorganization, law and economics, and legal valuation, and is director of our bankruptcy studies program. He received his bachelor's degree in economics and international relations from Johns Hopkins and a JD from the University of Chicago. Following law school, he clerked for Judge Frank Easterbrook of the Seventh Circuit and then practiced law at Latham & Watkins. Prior to joining the St. John's faculty, he was tenured at Rutgers and Marquette and also taught as a visitor at Cornell and Florida State Law Schools. Professor Scharfman has published numerous law review articles. He's one of the earliest and best-known scholars to have applied a law and economics approach to Jewish law. In recognition of his scholarship, the National Conference of Bankruptcy Judges selected him as an American Bankruptcy Law Journal Fellow. He's been a member of that journal's editorial advisory board since 2007. He was recently elected as chair of the AALS section on Jewish law. Professor Scharfman.
Thank you very much, Professor Ward, and thank you for inviting me here today. It's a great pleasure to be here together with you to talk about Jewish law, and in particular, my own subspecialty within Jewish law, which is the application of economic principles to Jewish law. I also want to thank the Dean, Harry Ballin. It was wonderful to meet you last night, such a stimulating evening and dinner, and especially to meet Judge Dror. I'll echo or paraphrase the Pitum Haktoret prayer and say that I look forward to Bor Zaror, which are two of the ingredients of the incense offering listed in the Pitum Haktoret prayer. All right. And I also want to thank Michael Morales and your other editors and staff, colleagues at the Touro Law Review. As you're going to hear, my paper, which I've done already, needs a lot of help from you. Lots of editing, lots of footnotes, and I look forward to working together with you. This is I'm now a middle-aged law professor, and I've learned that law professors, as they go through life, acquire an ever greater number of drafts accumulating on their hard drives. And the paper that I'm going to contribute to this conference is one such draft. The first time I presented it was at Hebrew University, and at that time I had the pleasure of getting comments from two Nobel Prize winners, the late Kenneth Arrow and my cousin Robert Alman. This is presented at the Ramat Gan conference at Hebrew University. The second time I presented this paper was for the AALS section of Jewish law, my first time around being president, and I got comments at that time from Saul Levmore, from Sam Levine, from Michael Helfand. I think you were there also, I think, if I recall correctly, and I appreciate your comments. So now I think the third time will be a charm that the paper's finally found a home. So let me and of course the field has developed a little bit since then, and I have to make revisions to the paper in light of those developments. Economic analysis has since certainly the last 50 years become an ever increasingly powerful tool or mode of analysis for looking at really almost any legal rule, certainly American law, long known to be powerful for antitrust, but applied by Judge Posner, Guido Calabresi, and others to other fields within American law. And starting in, I would say, in the mid-1980s, we got very interesting scholarship, I would say early work in the field of economic analysis of law as applied to American law from Saul Levmore and Jeffrey Miller. Jeffrey Miller is now at NYU, but he likes to remind everyone he's actually Unitarian, not Jewish. So that's an important disclaimer that he makes, but I still regard his work as applying economic analysis to Jewish law, though it's from his point of view, he would call it neutrally the Hebrew Bible, his economic analysis of the Hebrew Bible. What I note in this paper is that the early work by Levmore and Miller is largely what we would call in the economic literature descriptive or positive, in the sense that it's not about the ought, but rather about the is. It's about what it tries to explain the law as it is without trying to justify it or say why it's good or bad or what it ought to be, but rather simply takes the law as it finds it and tries to offer an explanation. And Levmore does this in the area of tort law. He tries to explain the tort law that we have as described in the book of Exodus regarding accidents, and why any society would really have many of the same principles. And indeed, that is much of of the legal project of Menachem Elon, who we spoke about last night in his great treatise on Mishpat Ivri, Hebrew law. What he does is distill, as I understand it, he distills out the ritual aspects of Jewish law and focuses on those aspects of a legal system that really any society has to deal with. And that's what he regards as the piece of Jewish law that he's particularly interested in, the Mishpat Ivri, and that's what Levmore does as well when he looks at the book of Exodus, and that's really what Jeffrey Miller does when he looks at the various things in the Hebrew Bible, such as the contracts that are recorded in the book of Exodus, most famously the sale of the birthright by Esau to Jacob. These are what economic analysis would call a positive account. Jeffrey Miller, for example, explains that when it's expensive to record laws, there's a high cost to doing that. You want to record the really hard cases, like the sale of the birthright, yet it's enforceable. Book of Genesis says sale of the birthright is enforceable. Instead of having to record a lot of the easy cases follow a fortiori, as I think we can say in this company, kal v'chomer. I regard, in this paper, I discuss why that's only a first step, because there's other modes in economic analysis of law, the so-called normative dimension, by which we mean, how can we justify the law? In what sense is it desirable? Does it satisfy the ought principle as distinct from the is principle? It's particularly important to do that in a religious body of law, because we're not simply satisfied in a religious body of law that a bunch of interest groups wanted a certain law or regulation. That works if you're just kind of cynically trying to explain why we have the law that we have, if it's human-made law. But if it's divine law, or even if it's rabbinic law that's at least divinely sanctioned, we want to try to show how the law is normatively desirable, or at least, as I put it in the paper, normatively defensible. And that requires more work, which I think economics can help us do. I'll just add a footnote to this paper, which I have to add, which is the late Aaron Levine, longtime chairman of the Department of Economics at Yeshiva University. I had the privilege of serving as his research assistant briefly. Put out a volume in 2010, Oxford Handbook on Economics and Judaism. And that book is a collection of papers, I would say there, that largely, it's like Levmore and Miller, largely those papers, including my own contribution on the valuation in Jewish law, those papers are largely positive descriptive rather than normative, but there are, I would say, one or two papers there that do have a normative dimension. So we can see in Levine's work, not this Levine, but Aaron Levine, we wish you long life, Sam. But Aaron Levine's work, which was a marvelous job that he did collecting papers in this area, though again it was largely positive descriptive rather than normative. And so what I want to do here today is to think about three cases. Economists, law and economics scholars like to think of so-called puzzles. What Posner does throughout his treatise on economic analysis of law is every case that agrees with him makes sense, and every other case is a puzzle. So I want to think about, one could just as easily say the cases that he regards as puzzling really are the ones that make sense, and the ones that he likes perhaps are puzzles. But in any case, puzzles are in the eye of the beholder, I suppose. But I want to talk about, I guess, three in some ways puzzling cases from Jewish law, and then I won't have time, of course, to get to everything, and Professor Ward will stop me, but I'll offer some economic analysis that will try to give a normative defense to these various laws. The first law coincidentally happens to be from this, maybe not coincidentally, happens to be from this week's Torah portion concerning the quarantine that we impose on lepers. So someone contracts leprosy, basically they're asked, they're required to leave the inner encampment of the children of Israel and stay outside the camp till the disease abates, till it heals. And there are other laws and regulations concerning the leper. The leper is supposed to wear torn clothing and grow the hair long, and supposed to be uttering the words "tameh," "tameh" translated loosely unclean, ritually impure is really the translation. Ritually impure, as a person is before their quarantine, before the priest has made the diagnosis, the objective diagnosis to quarantine the person who is afflicted. And so it's easy here to think about, one could give sort of a Jeffrey Miller, Saul Levmore kind of public choice explanation for why you'd want to quarantine a leper. It's pretty obvious that there would be interest groups like the non-afflicted population, which would want to kind of quarantine the disease. But one can go beyond that. It is actually puzzling because the only recorded case in the Hebrew Bible of leprosy is the case of Miriam, the sister of Moses and Aaron. And the question is, do we need to have such an elaborate system and elaborate body of laws just to deal with one reported case? And so what I want to suggest is that there's really more at stake here, and one possibility is think about the principle that Miller talks about with the Esau-Jacob sale of the birthright. This is the hard case, right? This is the politically connected individual. This is Miriam. This is the sister of Moses and Aaron. Even she is quarantined. Maybe there were other cases, but this is the one to record. This is the efficient case, if you will, to record, because in a world where recording is costly, because she is the one. This is equal justice under the law. This is someone who is quarantined, if one had to imagine a case that was the hardest case where you would still impose a quarantine, Miriam's case would be it. Two other cases that I want to talk about briefly in the time that I have. So I have leprosy, then I have loans, and I have lands. I've got the three L's. So now the loan contracts that I want to talk about. And my bankruptcy students at St. John's know all about this. We have two laws here that I want to talk about. One is the discharge of debts every 7th year, so-called shmitat ksafim. Okay, so that's the U.S. Bankruptcy Code actually reflects that law in not allowing you to file for bankruptcy more than once in 8 years. But there's a discharge of debt every 7 years, and during the 7th sabbatical year is the year in which the debts are discharged. And one can ask there, it's a bit of a puzzle, how come then, no, let me take a step back. So debts are discharged in the 7th year. The problem is that people then may not lend, right, as you approach the sabbatical year, because the likelihood of getting your money back, likelihood of default goes up if there's going to be a discharge. Now, in American law, you actually can't waive your right to a bankruptcy discharge, at least at the time of lending. But the good thing is that Judaism doesn't quite do that. Judaism has a very important institution called prozbal, which is rabbinic creation. It's discussed in the Mishnah in the tractate Shavuot, in which a debt can be transferred to the Beth Din, or the rabbinical court can be appointed, or become an agent, or become the holder of debt. And when you do that publicly in court with witnesses, the debt is no longer dischargeable. And so the debt can survive the 7th year. So the puzzle I would put to you is, how does it make sense to have a sabbatical year in which debts are discharged, but then we circumvent that, we contract around in a Coasian sense, we contract around the restriction on debt. A similar problem one has is with the law against lending at interest, also recorded in the Hebrew Bible. One doesn't lend at interest to a co-religionist. But then, of course, the rabbi saw that we're not doing a lot of lending transactions, or as many as might be desirable. And so we have what Rabbi J. David Bleich has wonderfully called the permissible venture. The Talmud speaks about something called a heter iska, which is basically converts the debt instrument into basically a co-venture in which the putative borrower really has an equity interest in this co-venture. And then, because the borrower is really a co-venturer, one can collect from the borrower what would otherwise be characterized as interest. So again, if you're contracting around the law of interest, you're contracting around the law of debt discharge, well, it's a really bit of an economic puzzle. How is it then that what is the effect, or what is the value, or what is the significance of the initial rule against these kinds of transactions to begin with? And so I try to address that in this paper from an economic perspective. And it's a little bit, there are different explanations. I don't have time to go through all of them, but one easy one, perhaps, or easier one to see, is a notion of first of all, an educative function that this law has for unsophisticated parties. So you think about the borrower who basically is being asked to waive discharge. The borrower might not know they have the right to discharge, you see, but the lender has to go and ask the borrower to waive discharge by going through this process in the Beth Din and having witnesses create this prusbul documentation. And so that raises the cost to the lender. It educates the borrower. So we'll still get some of these more charitable type of lending situations, especially for low value transactions where that won't happen. And yet, we also have the possibility of larger loans or riskier loans. We can facilitate those. So you can think of the law here, the rabbinic gloss on the biblical law, as facilitative in some sense. There are many other explanations. I don't have time to go through other explanations, and some of them involving signaling function. As to default, when we flip who has to ask for the waiver, we change the signaling dynamics associated with a transaction. The third puzzle I'll leave you with. I see my time. How much time do I have? Okay. The last little puzzle I'll leave you with is a very interesting law concerning the sale of land in the land of Israel. There's really two laws here. One is the reversionary interest that is held by tribesmen in ancestral land. So if I sell to Harry here a parcel that I own as part of our ancestral land I'm not sure which tribe I'm in or which tribe you're in, but if we do that, a transaction, it looks like a sale that's fee simple in perpetuity, but in fact, I hold a reversionary interest in the Jubilee year. That land reverts back to me, and that is well known to all the transacting parties, or should be, that land will revert back to me. So really, in effect, it's a lease, and the most the lease could be for is 49 years, because the Jubilee occurs every 50 years. So I can't even sell you the land for as long as England sold Hong Kong to China. So that's one restriction. And then the other restriction that's interesting is I can sell land in a walled city, which, by the way, may not be in tribal land. For example, in Jerusalem, it's not really tribal land. I can sell you land in a walled city. The Bible says I can't sell it litzmitut, which means forever, in perpetuity. I can't sell it, but the rabbis, the Talmud, discuss this language and say I can sell it for a specified term of years that may well even exceed 50 years. So I can sell it to you for 60 years or 70 years or 80 years, but not in perpetuity. And I have a right to buy the land back within the first year transaction. Those are very interesting, I think, land sale rules from the Bible, and a bit of what's an economic explanation for these things. Again, I'll just give a very simple one. There are many explanations one can offer for these various rules, but one is this notion I'm pressing for this presentation, which is this educative function that I teach contract law also at St. John's, and one of the things we're worried about is hidden terms. And so this forces, if you think about this rule against a basic sale in perpetuity without specifying anything, Often you'll have an unsophisticated seller who's hard pressed to get some revenue from the land and basically sell it perhaps at a fire sale price, not realizing they're giving it up forever, and the requirement that the sale will basically be nullified if it's forever. It'll end up reverting in the Jubilee year. Is addressed by forcing the buyer who wants to really take it for longer to say, hey, well, no, let's specify 60 years, 80 years, 90 years, something like that. We're doing a Hong Kong sale. That will force the seller to confront that, and the seller might really be unsophisticated. So that's one aspect to it that I think has some explanation. The other thing is, think about ancestral land. It may well be that there are positive externalities, that's a term from economics, associated with living near one's tribesmen. Sometimes I wonder about that in my own neighborhood. But the theory is that Sam Levine is a good neighbor. But the theory is that by living next door to someone else who is in my tribe, who is in my clan, we can benefit from each other. We have perhaps a high level of trust and a high community of interest and so forth. And so the reversionary interest is intended to tax sales to non-tribesmen, if you will, raise the cost, raise the price that non-tribesmen pay, and that could be justified normatively by the value that's not captured by the owner himself or herself in retaining the property and living next door alongside tribesmen. So because that positive externality is not internalized by the seller, the law in effect taxes the transaction to adjust for that. In any case, I'm basically out of time, so I want to thank you for listening. Thank you again for the invitation. I'm so glad my paper has found a home in the Touro Law Review, and which, as you see now, I'm sure it needs quite a bit of editing, so I look forward to your help. Thank you very much.
Thank you, Professor Scharfman. And last but certainly not least, Stephen L. Winter is the Walter S. Gibbs Distinguished Professor of Constitutional Law at Wayne State University. Before joining the Wayne State Law faculty in 2002, he was a member of the faculty at Brooklyn Law and the University of Miami School of Law. He has also taught at American University's Washington College of Law and the Cardozo-Rutgers Newark campus and Yale Law Schools. After law school, Professor Winter clerked for Judge Hayes of the Second Circuit. He served as assistant counsel after that for the NAACP Legal Defense and Educational Fund, where he litigated a wide range of civil rights cases and worked on more than a dozen U.S. Supreme Court cases. He's the author of numerous articles on constitutional law and legal theory. He's currently working on a book about consumerism and democracy. And without further ado, Professor Winter.
So I wrote this especially for you. Around election time, I sometimes see a bumper sticker or a sign enjoining the observer to vote biblically. This amuses me because I'm pretty sure there is not much voting in the Bible. As I remember it, the Almighty was none too pleased when the Jewish people asked for a king like the other nations. Imagine if they had asked for a democracy. Both in that request and in the parallel passage in Deuteronomy, excuse me, appointment of a king is indicated by the verb sim, to set or to place. In the Christian Bible, there's one passage where the apostles suggest that the congregants choose officials to minister to the widows so that the apostles are free to continue their work. But other than that one instance, nothing. Even more confusing to me is this sign, which asks how Jesus would vote. For starters, I always understood him to be a render unto Caesar kind of guy, whose kingdom was emphatically from another place. Besides, I don't see why he would want to bother to vote when presumably he has a direct line. My point is that democracy and theology are distinctive systems that work on very different principles. Comparative study of American and Jewish law must therefore, shameless plug for Sam, must therefore attend to the fundamentally different assumptions that animate these distinct legal systems. One of the strengths of Sam's work
is his care not to overgeneralize the similarities, instead noting critical differences in their assumptions and approach. For example, in his discussion of the debate over rules versus standards, Sam explains that only some of the arguments in the American debate are germane to Jewish law. The claim that rules better promote autonomy and democracy is simply inapplicable in the religious context. I want to push this point further. Among the different assumptions that underlie theocratic and democratic systems are profoundly different conceptions of law. One is top-down, the other bottom-up. One understands law as authority, the other holds out the prospect of a law that is the product of public participation and communal action. The Greeks who invented democracy had a name for this latter conception. They called it nomos. More is at stake than the scholarly integrity of comparative legal studies. Fundamental aspects of our own legal system, including the meaning of the rule of law ideal, turn on which of these basic conceptions we embrace. The Czech philosopher Jan Patočka offers the provocative thesis that politics and history begin with the emergence of philosophy. For prehistorical humans, he explains, religion and the natural world present life as, quote, self-evident and given. Only with Socratic questioning of the nature of things does, quote, the radical question of meaning based on the shaking of the naive, directly accepted of meaning of life arise. As long as events were understood as the product of fate, divine plan, or the natural order, there could be no politics and no history. This is not to say that humans did not act to affect their world, but the relevant response to the gods or to fate was not action but propitiation. Nor is it to say that there were no histories. History as chronicle or sequence of events was practiced throughout the Middle East and elsewhere. But while these early narrative histories understood, quote, the past as something important for the successful future, their function was to provide, quote, ritualistic writings, cultimatic records, observations of what is fortunate and unfortunate in events and acts. These narrative histories also preserved and transmitted the normative values of their cultures, and the Bible introduced a clear vision of the nation as the bearer of history. But these histories still worked, quote, as a drama that unfolds before our eyes. The idea of history as the product of the choices and actions of human beings, rather than the result of divine intervention or natural order, had yet to arise. Philosophy gives rise to politics and history, according to Patočka, because it opens up, quote, the realm of human possibilities, which freedom is understood, quote, explicitly as something that is to be carried out, as a possibility we can accomplish, never just accept. Politics entails taking responsibility for the consequences of one's actions and, at the same time, recognizing and respecting the responsibility of others. And that can happen, quote, only in a community of equals. For that reason, the beginning of history, in a strict sense, is the polis. Ellen Meeksons Wood explains, quote, in order to question the existing arrangements, there must at the minimum be some belief in humanity's ability to control its own circumstances, some sense of the separation of human beings from an unchangeable natural order and of the social from the natural. There must be an idea that history involves conscious human effort to solve human problems. Such a view is associated with some direct experience of social change and mobility, some practical distance from the inexorable cycles of nature which comes with urban civilization. I want to note two caveats before moving on. First, I'm not suggesting that the Greeks discovered human agency or that earlier religious thought lacked a concept of free will. Rather, the nature of free will is understood differently within a religious worldview that assumes the truth of divine authority and human duty. The faculty of choice is exercised with respect to obedience or transgression. There are two commandments of worldly engagement, notably the command in Genesis to replenish the earth and subdue it, and the duty to repair the world in the kingdom of God, or tikkun olam. But as Wood points out, quote, nowhere else had the emphasis on human agency taken center stage in intellectual life as it did in Greece. What changes in Greek thought is an understanding of freedom and meaning as themselves the product of human action, aptly summed up in Protagoras' famous aphorism, man is the measure of all things. In religious thought, the idea of equality derives from the understanding that we are all made in God's image. In classical Greek thought, Hannah Arendt observes, quote, men were by nature not equal. and needed in our official institution, the polis, which by virtue of its nomos would make them equal. Second, I do not think that Patočka's claim about the priority of philosophy is, strictly speaking, a factual one. For one thing, the chronology is off. Athenian democracy emerged before the philosophers Protagoras and Socrates, and before the historians Herodotus and Thucydides. For another, Patočka's own account explains the emergence of the polis as a contingent response to external military threats and internal political struggles. Rather, Patočka's point is in the nature of a parable or a thought experiment that reveals the conceptual architecture of politics and history, which requires the recognition of the constructedness and contingency of human knowledge and action. As Patočka says, and this quote will give you some sense of the poetry of his writing, quote, "It is like a landscape illuminated by lightning, amid which humans stand alone, with no support, relying on solely that which presents itself, and that which presents itself is everything." Now, this next slide actually kind of says the opposite. So another essay by Patočka, I'll give you a second to read it quickly. So it's focused on the negative, but it's essentially making the same point. Democratic politics, then, is a politics of another order. It is not simply a matter of majority rule or consent of the governed. Democracy is the politics of collective self-rule, the sense that we construct the social order that will govern us. As Pericles says in the funeral oration, we Athenians decide public questions for ourselves. The constitution that we, the people, adopted may set the ground rules, but we are free to amend it, and we are free to decide via public debate in elections the rules that will govern social life. This understanding of democracy entails a distinctive notion of law, which correspondingly gives the rule of law ideal a very particular cast. The poet Wallace Stevens says, quote, "A new meaning is the equivalent of a new word." The Greeks, apparently, did not think so. The original Greek word for law was thesmos. From the Greek tythemi, to put or place, thesmos signifies, quote, "something imposed by an external agency, conceived as standing apart and on a higher plane than the ordinary." It thus shares with the English word law a common sense and conceptual etymology. The Oxford English Dictionary defines law as, quote, "a rule of conduct imposed by authority," and traces the term to the Old Norse lagu for, quote, "something laid or fixed." This is the sense in which this is the sense of law conveyed by the colloquial expression, following the rules laid down. And I'll go back to Pericles. Martin Ostwald tells us that nomos abruptly replaced thesmos as the Greek word for law, and that this occurred at the time of the democratic reforms of Cleisthenes in 508-507 BC. Nomos, Wood says, quote, "suggests something held in common, whether pasture or custom. As applied to legal requirements, it expresses a duty of obedience, quote, motivated less by the authority of the agent who imposed it than by the fact that it is regarded and accepted as valid by those who live under it." The relation between nomos and democracy was foundational. Cleisthenes himself seemed to describe the new political order as isonomia. A compound of isos, and meaning equal, and nomos for law, isonomia was the most prominent and popular of a trio of cognate terms for democracy and its institutions that included isogoria, the equal right of poor and working people to address the assembly, and isokratia, equality of power. Not only did isonomia precede the coinage of the term democracy, a compound of demos and kratos, the people and power, but it provided the normative force for the democratic ideal. Democratia does no more than describe a fact, Gregory of Lastos explains. Isonomia expresses an idea, indeed a whole set of ideas, by which the partisans of democracy justified the rule of the people. Victor Ehrenberg tells us that by the time of Cleisthenes' reforms, isonomia had come to mean not a state of equal law for everybody, but the ideal of a community in which the citizens had their equal share. Isonomia, Vlastos elaborates, quote, designates a political order in which the rule of law and responsible government are maintained by the equal distribution of political power. It is easy to see how revolutionary the Greek idea of democracy actually was. And from a modern perspective, it is also easy to see that ideal as hypocritical. Only certain classes of people were understood to be within its ambit: women, slaves, and other dependents. The non-native born, they were all excluded. As Vlastos elsewhere points out, the equality on which the ancient Greeks, quote, prided themselves was the club privilege of those who had the good judgment to pick their ancestors from free Athenian stock of the required purity of blood, close quote. Perhaps these two are connected. The perception and acceptance of equality may come more easily among the homogeneous, but the idea of ordinary people ruling themselves through direct participation in lawmaking was nevertheless radical, and it required a completely different conception of law, not as authority, but as common possession and entitlement. We take it for granted that the rule of law is a basic democratic principle. The conventional understanding is that the rule of law serves to protect liberty by imposing constraints on official action. This is Justice Jackson's characterization in Youngstown Sheet and Tube, quote, "The essence of our free government is leave to live by no man's leave, underneath the law, to be governed by those impersonal forces which we call law. A government of laws and not of men is one in which official action is governed by pre-existing rules of sufficient clarity and generality to preclude the arbitrary whim of individuals or the brute impositions of power. So understood, the rule of law ideal is closely entwined with law's traditional tendency towards formalism. And as such, law is hypostatized as an impersonal force. Lost is the sense of law as a nomos that represents the collective force of democratic decision-making. The rule of law ideal has thus come to signify a lesser idea of law as authority. This is the sense in which the former Attorney General Jeff Sessions used it in the spring of 2018 in his official announcement of the Trump administration's zero tolerance policy that separated migrant families at the border. I should say infamously separated families at the border. The transition from isonomia to this desiccated view of law as authority, Vlastos says, turned a profound idea into a shallow dogma. Anglicized and imported into England from Italy at the end of the 16th century, isonomy expressed the idea of equality of laws to all manner of persons. By the 17th century, it was largely displaced by the phrases equality before the law, government of laws, or simply the rule of law. The phrase a government of laws and not of men was coined by James Harrington in the late 17th century, but for him it signaled the rule of virtue over the corrupt, that is, self-interested, rule of men. John Adams would immortalize this phrase in Article 30 of the Massachusetts Declaration of Rights, and Chief Justice Marshall would invoke it to support his assertion of power of judicial review in Marbury versus Madison. The rule of law idea was thus dramatically transformed. What began as a democratic ideal of self-governance, only by those rules adopted by the people themselves, evolved into a notion of constitutional authority pursuant to impersonal rules enforced by an independent and unaccountable judiciary. Robert Cover radicalizes our understanding of law as nomos, in large part by subverting the conventional antinomies of obedience and disobedience, legal precept and social meaning, nature and nurture. Cover's analysis of each of these oppositions works an Aufhebung, an overcoming that simultaneously destroys and preserves the antinomy by transforming it into a new synthesis. Indeed, he plainly announces this dialectical methodology in the epigraph of Nomos and Narrative, which quotes the first stanza of a poem by Wallace Stevens, "A violent order is a disorder, and a great disorder is an order. These two things are one," pages of illustrations. Despite his use of Jewish religious texts, Cover's primary influence is not Jewish but Greek. This is clear in his choice of the term nomos and of the term paideia as the framework for his analysis. For the pre-Socratics, quote, the distinction between physis, nature, and nomos, law, custom, or convention, was a preoccupation, Wood tells us, that became their central intellectual problem. For Cover, the opposition of physis and nomos, of physics and nomos, is transformed into parallel and essential conditions of existence. Quote, this nomos is as much our world as is the physical universe of mass, energy, and momentum. Indeed, our apprehension of the structure of the normative world is no less fundamental than our appreciation of the structure of the physical world. Just as the development of increasingly complex responses to the physical attributes of our world begins with birth itself, so does the parallel development of the responses to personal otherness that define the normative world. Here, Cover's dialectical move is to take an antithesis of the necessary, that is physical nature, and the contingent, that is the normative world of law and culture, and in a move reminiscent of the existentialists, transpose the two into a new synthesis in which what appeared contingent emerges as necessary for us. Cover makes an analogous dialectical move with respect to law and narrative. On one hand, every narrative is insistent in its demand for its prescriptive point. On the other, law cannot be understood without the narratives that give it history, purpose, and meaning. Quote, for every constitution there is an epic, for every decalogue a scripture. Moreover, the relation between legal precept and social meaning is, for Cover, entirely circular. Law may appear to stand above and organize the social according to its command, but for Cover, formalism of this sort is an illusion. Quote, prescription, even when embodied in a legal text, cannot escape its origin and end in experience in the narratives that are the trajectories plotted upon material reality by our imagination. In Cover's thought, law and narrative frame each other. In so doing, each transforms the meaning of the other. Perhaps his strongest example comes from the fight over slavery. The abolitionist Wendell Phillips agreed, in scare quotes, with Chief Justice Taney's interpretation that the Fugitive Slave Act clause dictated the return of runaway slaves. But Phillips renounced any obligation under the Constitution, while Taney, of course, enforced it. Because abolitionists like Phillips and establishment jurists like Taney operated within different constitutional nomoi, they, quote, could only be said to agree on the meaning of the document abstracted from any need to, or desire to act upon it. And no two people can be said to agree, Cover says, on what the text requires if they disagree on the circumstances in which it will warrant their actions. The relation between nomos and narrative that Cover explores is not analogous to the relation between halakha and agadah. First, the terms or elements of the analogy do not align. Nomos does not map onto halakha. Nomos is the third term or output function of a dialectic of law and narrative. If one were to draw this analogy, one might say that just as the complex relations of law and narrative constitute a nomos, halakha and agadah together comprise the Torah. But, second, even that analogy is not quite apt because the relation between the elements is fundamentally different. Halakha and agadah are complementary elements of a single tradition. Thus, Sam quotes from Chaim Nachman Bialik as saying that the two, quote, are really one, two sides of the same shield. But this is not a view that Wallace Stevens would endorse. In the later stanza of the same poem, he dismisses such monism as squamous, which is scaly. For Bialik, the relation between the two elements is fixed. Halakha crystallizes agadah, while agadah refines halakha. But Cover, as we have seen, views law and narrative as a reciprocal relation that is mutually transformative. One could, of course, take such a view of halakha and agadah. Thus, Cover gives an example of the law of primogeniture stated in Deuteronomy, which is embedded in a series of biblical narratives about the patriarchs in which the normal order of succession is overturned. Cover reads this as a case similar to the slavery example, in which the story's deviation from the legal rule signifies an exceptional quality of divine destiny. But Sam takes issue with this layered interpretation. He argues, alternatively, that Deuteronomy's later rule of primogeniture did not apply to the earlier normative world of the patriarchs, and that the rule was anyway qualified by exceptions which explain the patriarchs' actions. This dispute between Sam and Bob underscores the profound difference between halakha and nomos. Religious law typically prizes formal consistency. Cover's account in Nomos and Narrative prefers the redemptive over the insular version of nomos, and the jurisgenerative power of diverse communities over the jurispathic function of the courts. Third, and relatedly, Cover's anti-formalist understanding of law is at odds with the notion of law at work in halakha. For Bialik, the dichotomy of halakha and agadah maps the conventional dichotomies of reason versus rhetoric and the objective versus the subjective. Thus, for Bialik, the arrows of halakha fly straight and true with the strength and directness imparted by a well-drawn bow, while the shafts of agadah, he says, are uncertain in their aim and come with a swerve. For cover, in contrast, the social contingency of law, the fact that it has its origin and end in experience, makes it recalcitrant to formalization and effective domestication. The uncontrolled character of meaning, he says, is destabilizing. Quote, precepts must have meaning, but they necessarily borrow it from materials created by social activity that is not subject to the strictures of provenance that characterize what we call formal lawmaking. Fourth, where halakha and agadah are the handiwork of divine provenance and rabbinic authority, cover understands nomos as the product of human culture and imagination. Quote, the community posits a law external to itself, that it is committed to obeying, and that it does obey in dedication to its understanding of that law. The process, quote, begins with when someone accepts the demands of interpretation and, through the personal act of commitment, affirms the position taken. This commitment is then objectified as an external demand that is embodied in an origin story, quote, a story of how the law now object came to be, and more importantly, how it came to be one's own, close quote. Law for cover is a human creation, a nomos in the Greek sense, and therefore both contingent and contestable in a way that divine law is not. Fifth and finally, the role of disobedience in cover's work has no analog in the biblical worldview. One of the singular passages of nomos and narrative is cover's unpacking of the civil rights sit-in movement, of which he was a part. If you want in the Q&A, if there is any time left, you can ask me why the Woolworth and Savannah, but I have a story. Cover definitely subverts the dichotomy of obedience and disobedience. The demonstrators, he argues, are obeying what they understand as the bona fide command of the Equal Protection Clause in the face of segregation laws they understand as unconstitutional. There is, Cover says, quote, both disobedience and obedience in either case, close quote. On one hand, the demonstrators are defying the segregation laws sanctioned by the courts. On the other hand, quote, only obedience to the movement's own interpretation of the Constitution was fidelity to the understanding of law by which the movement's members would live uncoerced, close quote. Conversely, the judge asked to enforce the segregation laws faces a similar dilemma. Sorry, the judges in the plural, asked to enforce the segregation laws face a similar dilemma. They can obey the segregation laws, or they can disobey the law in the name of the Constitution. Again, there is obedience and disobedience in either case. The sit-in in defiance of the segregation laws thus, quote, forces the judge to choose between affirming his interpretation of the official law through violence against the protesters and, on the other hand, permitting the polynomia of legal meaning. A great order is a disorder. A great disorder is an order. These two things are one, but not in the sense that they can be reconciled. A and B are not, Stevens says, like statuary posed for a vista in the Louvre, but things chalked on the sidewalk so that the pensive man can see. The thrust of nomos and narrative is to reject the imperial mode of world maintenance characterized by law as impersonal authority in favor of the paideia nomos of law and narrative, in which there is, quote, a common and personal way of education into and performance of the law. Cover opts for legal pluralism and asks us to invite new worlds. That paradigm of nomos offers a vision of law that better keeps faith with our democratic heritage and aspirations.
I'd like to thank our panel, and in the interest of keeping on time, there will be questions and discussion should wait till lunch. Thank you. Thank our panel again.
Thank you. For you, it needs to explore nomos, this text. Just take it literally in the text. It says, Ani shamati mipi hamerubim, vehem shamu mipi hamerubim. So that the formalism that Dean Silver was talking about is a formalism that seems.
We're just going to take 5 minutes to for a little break, and then we'll get back to it.
Precisely goes with the
Is it not time for lunch yet?
Not yet.
in the text that you explore.
We're a little behind, but
And it actually merges.
oh, right here.
I may add it back in. The one thing I was going to talk about was about Smith, right? Because even in this language,
Okay,
quote,
good, thank you.
right, it's also about the authority, the top-down authority.
Yes, but that's also true of Hellenistic. It's true of Hellenistic culture, in a way.
I don't think that's really quite right. But more true of the Roman Senate than of Athenian democratic culture. But
No, I'm talking about the Hellenistic. So if you say that Jewish law is not just Mosaic law, it's a very interesting phrase. It has that succession implication that it gets rejected. I mean, Jewish law, this started with the 11th century, which is very much Jewish law. And then you see a progression from the 11th to the 17th century, where Jewish law takes on a codified character that continues to this day. It's very interesting to consider.
Right.
Yes, of course. But you'll recall that I questioned what do we mean by codification? I mean, what do we mean by code? It's not the same thing as code. In the process, we participate in that. But the idea that precisely in these debates and the injunction to this, I have a tradition. I believe that it's an impeccable tradition, and yet I'm telling you that you should.
I don't think the fact that both include majority rule make it the same. I think that's
Substantive aspects of Jewish and American law. That's fine. Do you want a microphone? Stand right here.
That's fine. I'll just move on. I'd like to welcome everyone again to this wonderful symposium and thank the Law Review and also Professor Sam Levine for having the vision to present such excellent panels. In panel 3, we're moving from the philosophical and policy influences of Jewish and American law to the substantive aspects. We're going to hear from 2 speakers. Our first one is Professor Greg Randall Lee, who is a familiar presence at Touro Symposia, and he is a professor of law at Widener University Commonwealth Law School and specializes in constitutional law, professional responsibility. He's involved in advocacy programs, and he recently wrote an article on disability law, and you can see here that he's going to be speaking about disability law again, which will be published in the next, this article is at the publisher, and it will be published in the next few weeks in the Touro Law Review. Professor Lee has been instrumental in working for the benefit of people with disabilities, and he worked on the first case which guaranteed the rights of people who are deaf to serve as jurors. In the interest of time, I'm going to ask Professor Lee to start.
Thank you for that gracious introduction. Thank you to the Law Review for continuing to let me publish there in spite of myself. Thank everyone at Touro for being so gracious and all the times that I've been allowed to come here. And especially thank you to Sam, who I see as a mentor on all of this. And thank all of you for coming, because this would be a much lonelier experience if you were not here. The Rabbi Daniel Yolkut received a call one day from a woman who needed to talk with him about something that was troubling her. Initially, Rabbi Yolkut was relieved to learn that that something was not him, but that relief quickly dissipated as the woman began to describe her concerns. The woman, Rabbi Yolkut had observed, was a very wonderful person, one who sought to live consistent with the instructions of her faith. Yet what was troubling her was, of all things, something in the Torah. Rabbi Yolkut, the woman, explained, every spring we read this one passage, and every time this passage is read, I want to get up and leave the synagogue. The passage that bothered the woman was from Leviticus. The passage reads, say to Aaron, none of your descendants throughout their generations who has a blemish may approach to offer the bread of his God. For no one who has a blemish shall draw near. A man blind or lame, or one who has a mutilated face or limb too long, or a man who has an injured foot or an injured hand, or a hunchback or a dwarf, or a man with a defect in his sight, or an itching disease or scabs or crushed testicles, no man of the descendants of Aaron the priest who has a blemish shall come near to offer the bread of his God. He may eat the bread of his God, both of the most holy and of the holy things, but he shall not come near the veil or approach the altar, because he has a blemish, that he may not profane my sanctuaries. For I am the Lord who sanctify them. Rabbi Yolkut, the woman, continued, every year I listen to this passage, I listen to how God discriminates against the disabled, and it makes me want to get up and leave. Why does God reject the children he has made broken? The children he formed in their mother's womb. He makes them broken and then he rejects them. Is this the response of a God who art a gracious God and merciful, slow to anger and abounding in steadfast love? Is not such a rejection an indication of the coldness, the harshness, the callousness of God? And Rabbi Yolkut had nothing to say to this woman in response. After all, if God demanded perfect metal, perfect wood, perfect cloth, perfect rings, perfect lambs, and perfect measurements down to the cubit, why would we expect him to settle for less than perfect people to serve in the temple? Could he not look over all he had created and say, "This is good"? And if all he had created was good, should he not be able to insist that those who served in his temple be perfect? Perhaps the woman's outrage was fueled somewhat by being American, by being able to compare our laws with respect to people with disabilities to God. After all, in America, our laws do not allow discrimination against people who are disabled. We grant them access. We accommodate them. We invite them to work and have value. We call them equal and seek ways to help them emulate the lives of those of us who are not disabled. We allow them to share in our perfection. Or do we? Might one also accuse us, as the woman to Rabbi Yolkut accused God, of rejecting those whom we label in our laws disabled? Might one accuse us of rejecting these people as they are and then seeking to accept them only as we might redefine them? Do we seek to remake these people in our own image when we should be helping them to find God's perfection for them, helping them to find God's image uniquely articulated in how he created them? I had a friend once who was blind. By law, this friend was entitled to job training, so each day my friend would go off to his vocational rehabilitation site and receive his training, placing nuts and bolts in a cup, passing him by on a circular assembly line. For a long time, it struck me that this task was a very odd job for which to train a person who was blind. The only real skill this task seemed to me to require was hand-eye coordination, an asset that seemed to me inherently inaccessible to a person who was blind. It seemed to me that my friend was better equipped to be the president of a Fortune 500 company than he was to put nuts and bolts in a moving cup. Still, those who knew better than I did, and ultimately let me know as much, had determined this was the job my friend was best suited for and thus would be trained for. So off my friend went each day, and each day he somehow figured out how to get those nuts and bolts into that moving cup. Years later, I was trying for the 6th time to learn piano. I was also in the process of failing for the 6th time, and in fact failing in exactly the same spot. That spot was the moment when I was required to move my hands on the keys without looking at the keyboard. As I was insisting that this was impossible, that I could not do it, that this feat required hand-eye coordination and therefore necessarily eye involvement. As I was insisting that if I were going to play the piano, I had to see the keys, my son gently corrected me, "Actually, Dad, you don't. You don't need to look. It's just muscle memory. Stevie Wonder, Ray Charles can play the piano. Jose Feliciano can play the guitar. You don't need to see to make music. People don't need to see to make music." I never learned the piano, but after that I did begin to wonder whether Joe got his job putting nuts and bolts into a moving cup because the people who decided those things had listened to enough Ray Charles and Stevie Wonder to know that Joe could do that job, or whether he had gotten that job because it was a sufficiently menial task that it could be done by a blind person. Did Joe get that job because we as a nation recognized that Joe was perfectly and wonderfully made? Did Joe get that job because we appreciated that a blind Stevie Wonder or a blind Ray Charles could play the piano, a deaf Beethoven could compose music, or an armless Tony Melendez could play the guitar? Or did my friend Joe get that job because he was disabled? And this was a job accessible to disabled people. In Claiborne versus Claiborne Living Center, the Supreme Court of the United States recognized that although people with disabilities may be entitled to equal protection, they are not entitled to any heightened scrutiny in furtherance of that protection. When the court did so, the court insisted it was doing so in part because, quote, in the vast majority of situations, our legislatures do for those they label disabled what is desirable, what is legitimate, what is to the benefit of these people. To accomplish those ends, the court insisted our government bodies must have a certain amount of flexibility and freedom from judicial oversight. The court then went on to concede, however, that the particular case before them in Claiborne was the product of, quote, irrational prejudice. Yet one more example of what the court recognized as a history of, quote, instances of discrimination against the retarded that are, in fact, invidious. It was a history that the court failed to acknowledge had taken place when the court summarized the working of Claiborne 26 years later in Board of Trustees versus Garrett. Rabbi Yolkut ultimately did find an answer for the holy but troubled woman who came to visit him. He found that answer in the story of a congregation who had wanted to appoint a man whose arms were paralyzed to be their cantor. Unsure this could be done in light of the passage from Leviticus, the congregation took their cantor question to a respected rabbi who advised them on the matter. The rabbi responded, "It is obvious to me that this individual is fitting to serve in this role. Indeed, the man is the ideal candidate. The King of Kings delights in using shattered vessels." The rabbi then went on to explain, that passage in Leviticus has nothing to do with your cantor candidate because the temple is about perfection. And that's why the servers in the temple have to be perfect. But the cantor is about prayer. And God hears in a particularly profound way the cries of the poor. In further investigating the matter, Rabbi Yolkut noticed also that since the 12th century, those who serve in the temple had been grouped with the vessels of the temple. The vessels of the temple and those who work therein. Thus, those who work in the temple are furniture. The temple has implements, and it has human implements as well. The priest who works in the temple is not there as an individual. He's there as part of the furniture. He's there to carry out a specific role that has nothing to do with himself. It has nothing to do with his character, with his ego. He's there literally to blend into the surroundings. Because the temple is perfect, as long as the priest is part of the temple, then he has to be perfect as well. But if God has not called people with disabilities to the role in which one needs to be perfect, he has called them to something more, prayer. Prayer is our actual encounter with God. It's where the action is, the big dance, so to speak. And it is at the big dance that God loves shattered vessels. From the moment I first heard Rabbi Yolkut's ultimate response, I thought it was insightful and I thought it was beautiful, and I still do. But as beautiful and as brilliant as I think that answer is, I'm just not sure it's God's answer. The answer still assumes that those who have what we call disabilities are imperfect even in the eyes of God, and it concedes that because God sees these people as imperfect, there are things he will not allow them to do. Is it the case that people with disabilities are imperfect in the eyes of God, and because of their imperfections, there are things like serving the temple that God will not allow them to do? Or could it be that God has made these people, and in fact all people, uniquely perfect? And that in that unique perfection, God calls each to do something different. Different people were called to different. In making the Ark of the Tabernacle, God put in those he called to the work, quote, ability and intelligence to know how to do that work. Some were called to devise artistic designs, some were called to work in gold and silver and bronze, some were called in cutting stones for setting, some were called to carving wood, and some were called to weave fine twined linen and blue and purple and scarlet stuff, with cherubim skillfully worked. Different people were called to different tasks, but each was perfect in his task, and the fact that each was made perfect for his task and yet not perfect for another made none of these people imperfect in the eyes of God. The Word of God does not tell us how many of the people God called to this work were disabled. The Word of God only tells us how many were perfectly able to do what God had called them to do. No one said to those devising artistic designs, "You are imperfect because you do not work in gold and silver and bronze." No one said to those who cut stones for setting, "You are imperfect because you do not carve wood." No one said to those who wove fine twined linen and blue and purple and scarlet stuff, "You are imperfect because you do not devise artistic designs." When God looked on each of these children, God saw each one as fearfully and wonderfully made. To be fearfully made is to be made awesomely. To be made in such a way that one must wonder how one can stand before such awesomeness, such marvelousness, such perfection, and live. Could it be, however, that even some of these people had what we call today disabilities? Professor Sam Levin, who happens to be here because he has to be here, director of the Jewish Law Institute here at Touro, recently published a book, Was Yosef on the Spectrum? Was Yosef, son of Jacob, son of Rachel, prophet, mystic, favorite of his father, selected savior of the civilized world, master businessman, and Broadway star on the spectrum? When Professor Levin first mentioned that possibility to me and began to explain his reasoning, I felt what I thought were two different responses. My first response was, isn't that clever? Isn't that neat? Isn't it creative and lawyerly how Professor Levin has managed to find a way to connect all those events and all those conversations together to support his thesis? My second response was not quite so supportive. My second, and of course unexpressed response was, what is Professor Levin thinking? Joseph is one of the most important figures not only in Jewish history, but in world history. Joseph was a prophet and a mystic at the center of events essential to the Jewish story. Joseph was an instrument chosen by God to save civilization. Disabled? Broken? On the spectrum? What's Professor Levin going to say next? That Moses didn't really look and sound like Charlton Heston? Of course, as much as I understood these as two responses, they were only one. What Sam is suggesting cannot be true. But what if it is? How beautiful might it be if God would choose to save his people through a child they all thought was broken? And why not have a beautiful story of a broken child in the midst of a story of brokenness? Because isn't that what the story of Joseph and his family is? A story about brokenness and love. Broken people, broken promises, broken romances, broken families. Jacob, Joseph's father, is a man who devises schemes so that he can get everything he wants, only to have those schemes cost him everything he gained and everyone he loves. And he lives with the recognition, because of my greed, because of my selfishness, because of my deceitfulness, I can never see my parents, my brother, again. Leah, Jacob's wife, is a woman who deceives Jacob, the man she loves, so that for one night he will see her as the perfect woman and even marry her, only to realize that no matter how good a wife she is or how many sons she gives him, Jacob will never see her that way again. And she lives with the recognition, my husband only loved me because he thought I was my sister, and I will never know that love again. Rachel, Joseph's mother, is a woman who marries her sister's husband, causes her sister to be rejected by her husband, and then is barren herself. Rachel watches woman after woman after woman bear her husband's sons, and then when finally her barrenness is broken, Professor Levin would have us believe that that barrenness is broken by a son who is broken, even though that son may be perfect in his father's eyes. So much brokenness. Ironically, in the midst of this broken story, Professor Levin directs us to look to, of all places, Pharaoh, to see the hand of God. When Pharaoh encounters Joseph, Pharaoh does not recognize Joseph as disabled. It is Pharaoh who recognizes Joseph as an instrument of God. And it is Pharaoh who seeks to help this instrument fulfill his divine purpose. As Professor Levin puts it, only Pharaoh in the story possesses the wherewithal to find the strengths in others and identify the value they may bring, while at the same time recognizing, and when necessary, accommodating their deficits and weaknesses. Pharaoh, like God, comes into the brokenness and brings fruitfulness and healing and abundance, such that the brokenness is forgotten and only the perfection remains, because nothing was ever really broken, just unrevealed. There are those who insist that the best way to teach autistic children is not to try to fix them, but to try to meet them and help them uncover their perfection. That's what they want. That's what they hunger for. And that is how we know they are like us, because that's all any of us want, any of us need. At the end of Joseph's story, Professor Levin highlights for us Joseph's two great revelations. First, every step of Joseph's journey, even the moments of brokenness, God intended it for good. If Joseph had been more politically discerning, less a candidate for being on the spectrum, he might never have made it to Egypt. What got Joseph to Egypt was a dad who played favorites, a less than discreet tongue, and 11 jealous brothers. In the end, we learn God made Joseph perfect, and Joseph was never out of God's care. Second, Joseph's journey has not only saved civilization and healed a family, but it also has led Joseph to the perfection for which God created him. As Professor Levin points out, Joseph has indeed learned to overcome his condition, let go of past insults and indignities, to understand others, including his peers, talk to them in a manner that shows how he relates to them. Joseph ends up not only great, but good. God hasn't created us all to be the same. He's created us all to be perfectly his. And disability law in America will emulate Jewish law when we stop trying to make everyone equal, everyone the same, and figure out how to help everyone find their perfect. In her song, Wrap My Arms Around Your Name, Sarah Mason asked the question, do all the angels sound the same? If the angels are all perfect and yet they all do not sound the same, Why do we expect that God will express his perfection in each of us in exactly the same way? There once was, in what was then Austria but is now Ukraine, a budding young rabbi named Menachem Mendel Hagar, or Mendel for short. Mendel was clearly a rising star in the faith, upwardly mobile and destined for greatness. Mendel's upward trajectory got sidetracked, however, when he decided one day that he was called to embrace the spiritual practice of going into exile. Essentially, Mendel decided that he should begin wandering about the country as a homeless person. Mendel felt certain that this experience of impoverished homelessness wandering would allow him to better empathize with the pain of his people who were themselves suffering in exile, and also better empathize with the pain of his God who himself moved in a world that did not recognize him. Thus, Mendel set off to wander from town to town, trying to enhance his empathy as he embraced his self-imposed exile. Needless to say, as time wore on and Mendel drifted from place to place, he came to appear less and less like a rising rabbinical star and more like a bum. Or to put it more politely, like a, quote, vagabond madman. Not surprisingly then, no matter where Mendel went in his wanderings, people shunned him. No one wanted to welcome him, no one wanted to shelter him, no one wanted to offer him food. Essentially, no one really wanted Mendel hanging around, except in one little town. In this one little town into which Mendel would wander from time to time, there lived a little girl named Rivkala. Whenever Mendel would come into Rivkala's town, Rivkala would manage somehow to track Mendel down and invite him to tea. Now, Rivkala's parents had no interest in having some crazy, dirty beggar loitering around in their kitchen, so Rivkala had to host her teas with Mendel outside in the yard. Rivkala would bring out her little rickety tea table and her two little chairs, and she would bring out her little teapot and her two chipped teacups, and she would sneak a few cookies from the larder, and Rivkala and Mendel would sit and have tea. The two of them, Rivkala and Mendel, would sit together in the yard at the little table and the little chairs and talk and laugh and eat cookies and sip tea, until finally Mendel would thank Rivkala for the tea and bid her good day, and then he would pick up his sack, throw it over his shoulder, and go off to the next town where he knew again he would find no one who would welcome him or show him kindness. Indeed, during all his years of exile, these teas with Rivkala were the only human contact Mendel had. After a few years, Mendel went back to being a rising star and went on to an illustrious rabbinical career. Ultimately, Mendel wrote a famous scholarly book and became the rabbi of Vizhnitz. He lived well in what one might call a palace and spent time each day teaching and conversing with students, servants, and a plethora of other admirers. Rivkala sadly did not fare so well. After she had stopped encountering Mendel and having him for tea, she contracted a terrible disease which left her paralyzed. Her parents, besides themselves with despair, took Rivkala from doctor to doctor to doctor, hoping one of them would somehow find some way to help their disabled daughter. Alas, however, there was nothing that 19th century medicine, there or anywhere else, had to offer Rivkala. Throughout all the fruitless doctor visits, Rivkala kept begging her parents to take her to Vizhnitz. The child insisted that in Vizhnitz there lived a great and righteous rabbi who happened to be her old friend Mendel. Rivkala was sure if she could reach out to her old friend Mendel, he would be able to help her. Her parents had no interest in taking him there to see a crazy beggar, but desperation makes people do strange things, and finally, having exhausted all medical possibilities and having watched helplessly as their daughter's condition continued to deteriorate, Rivkala's parents agreed to take their child to Vizhnitz to seek out the crazy man who formerly had sipped tea in their backyard. Much to the surprise of Rivkala's parents, the family ultimately found Mendel very much as their daughter had described they would. As they pressed out of the cold air through a pair of doors and into a great hall carrying the little bed there before them was the former Mendel, the former exile, seated on what appeared to them to be a throne and surrounded by a multitude of what could have been courtiers. As the cold winds followed the family into the hall, Mendel's eyes turned toward the doorway and fixed on Rivka lying on her bed. It is not clear whether Mendel first recognized her as a crippled child or as the little girl who had once shared with him cookies and tea and kindness, but when he spoke, he said Rivkala, and she said, "Oh, Mendel, I am so sick." Mendel embraced for a moment all that had befallen his only friend from his days in exile. Then, however, the rabbi called for a friend to go and get a crate. The friend brought back the crate and began to unpack it. There was in the crate a rickety table, a small chair, a pot, and a cup for tea. And Mendel said to Rivkala, "Rivkala, pour me a cup of tea. I want you to pour a cup of tea like you used to." Time passed and nothing happened. 1 minute, 2 minutes, 3 minutes, 4 minutes, 5 minutes. Then finally Rivkala rose up from her bed, walked to the little table, and she lifted the teapot and once more poured her friend Mendel a cup of tea. Is the story of Mendel and Rivkala a story of brokenness, of impairment, of disability, or a story of perfection? We do see in the story pain and suffering and disappointment, but pain and suffering, disappointment with which we are called to empathize and of which we are called to show compassion. But in the end, however, it is not all that we see as pain and suffering and disappointment in the story made glorious in the love of God. Do they not prove but instruments to reveal to us God's love and glories in ways we could never have imagined were we not asked to encounter that pain and suffering and disappointment? At the end of the day, will not disability law in America only be perfected if it seeks to mirror the law that we see of God, that all people are perfect and all are perfectly fulfilled in a mission God has for them, and that our job is to help people to find that perfect calling. Thank you for your time.
Thank you, Professor Lee. And once again, you've managed to capture the law, the good that the law can do, particularly with respect to people with disabilities, but also its limits. And you've used biblical stories to illustrate that, as you did in your prior article, in which you spoke about the love that emanates from these biblical accounts and how we can incorporate them into our own lives and help the disabled members of our society, and ultimately how everyone here and throughout the world has limitations. I'm sure there'll be more questions and comments over lunch. It's my pleasure to introduce Judge Moshe Drori, who is the Vice President of the Jerusalem District Court. He is also a visiting professor at Hebrew University. He has written numerous books, countless articles, and will be speaking about the role of repentance in criminal law in Israel. And we should also think about the role of repentance rehabilitation in American law as well. I will certainly looking forward to hearing him, but he has, in his opinions, considered the circumstances in which a court may decide to sentence a person to community service rather than a conviction, in the goal of therapy, to educate and impart moral values to the defendant. Judge Drori.
Thank you very much to invite me for coming all the way from Israel to this conference. Thank you very much. 1,000 years ago, on 1135, Rabbi Moshe ben Maimon, Rambam, commonly known as Maimonides, was born in Spain. He was a philosopher, Torah scholar, astronomer, and physician. He worked in Morocco and in Egypt as a rabbi and a leader of the community in Egypt. He died in Egypt in 1204 and was buried in Tiberia in Eretz Israel. His code of Jewish law, entitled Mishneh Torah, repetition of the Torah, contain religious aspects of the legal secular aspects of all the source of Judaism. Maimonides, in his framework of his code, introduced an innovation. He devoted a separate section, Hilchot Shuvah, the law of repentance, which are not concentrated in any one tractate of the Babylonian Talmud. Maimonides include these laws in the first part of his code, namely Sefer Hamada, Book of Knowledge. This matter appears to belong to the religious aspects of law, of the Jewish law. One might well ask where this law belongs to the framework of a case law of a judge, which deal with the legal aspects of the halakha. Nevertheless, upon careful study of these laws, I have concluded that this is possible and even necessary to apply them in the framework of Israeli law when we are faced with a lacuna or with the need to apply Jewish law. For this purpose, it is immaterial whether we regard these laws as part of the values of the State of Israel as a Jewish state, or whether they constitute a legitimate source of Jewish law. I have cited Maimonides' Hilchot Shuvah, law of repentance, in 25 judgments and decisions that I have handed down. I will confine myself in this short of time in 5 examples that I've mentioned, Hilchot Shuvah. The first of them will be the freedom of choice. The basic element for understanding a person's responsibility for his action is the assumption that he has a freedom of choice and that the world is not deterministic. Maimonides formulates this in his 5th chapter of Hilchot Shuvah, and I not quote all this here. By virtue of this principle of choice, I have given credibility to detainees for drug offenders who sought to participate in a rehabilitation process during their detention in the framework of alternative of detention within the community. Even in a case of an individual who has a criminal history of drug offense, in some cases I granted request in reliance upon the said freedom of choice of the Maimonides and let him go to rehabilitation institution. On the basis of the above, and in addition to case law of the Supreme Court of Israel, I elaborate and extend the right of medical patient to receive compensation for a breach of his or her autonomy, since its autonomy reflects the free choice of the patient. The second example deal with not conviction in a lightened or lightened sentence. In one particular case in which I ruled that under the circumstances there it was just justification for not convicting, I discussed Hilchot Shuvah at length, and I attached significant weight to the offender's expression of regret. In another case, which dealt with a Jewish juvenile who threw a rock after following prayer assembly for 3 boys who were kidnapped in the summer of 2014, and afterward it was released that they were killed by an Arab terrorist. The question arose as follows: should this minor be convicted or not? The probation service recommend that he should not be convicted, and in this framework, they describe the process of therapy and rehab that this minor undergo in various institutions. In a comprehensive judgment, which I handed down one day before Yom Kippur, I refer to Maimonides' Hilchot Tshuva, both in relation to actual expression of regret and to the change that the patient undergo, and also in relation to the promise not to do it again. On the other case, I involved a person who commits two offenses of theft and has undergo process of rehabilitation over a long period, and I base my decision on the above ruling of Maimonides, and his sentence was very lenient. On the other hand, when it was clear that the man in front of me is a person who is not completely sorry, that he has not internalized the severity of his acts, and it was assessed by the probation officer that he is in risk of doing his offenses again, then the consideration of freedom of choice drove me for harshment. I will conclude this matter by citing dissenting view that I have in a panel criminal case, in a very interesting case. There was a person who murdered his daughter. The question was as follows: whether he is entitled to keep his photos of the child or whether the photos should be given to the child mother. In my decision, I ruled that a copy should be made of the photos so that one copy should retain by the defendant, who had already been sentenced to a life imprisonment, and the reason was hope that in looking at these photos, he should lead him to repeat, and this also was before Yom Kippur. Another thing that is important in regret and apology is doing a process of giving compensation and apology to the defendant. Maimonides himself said it's not sufficient for a person to feel regretful or even to express his regret aloud. He must compensate the victim and apologize to him. On the basis of this ruling of Maimonides, I ruled that a person who had slandered another must apologize to the injured party. As opposed to this, when it was proven to me that there was no regret but only continuing breach of the law, I ruled that there is no room for leniency. Another institution in Jewish law that is equivalent or has some meaning in Israeli law is the conditional punishment. In Hilchot Tshuva, Maimonides described a type of institution of conditional punishment, in the sense that a person is not punished immediately for the first offense he had committed. Rather, his punishments take effects beginning only after the third or the fourth offense that he does. What is the meaning of this idea of Maimonides? When a person commits an offense for the first time, he is given a type of conditional punishment. The same applies after the second offense. Only after the third offense, he should be punished both for the third offense and for the first and the second offense as well. If the offender underwent a process as a result of which merits are equal to his sin, he is forgiven also for the first and the second offenses, and is punished only as to the last third offense. Israeli law laid down a time limit in relation to activation of conditional imprisonment, namely that the second offense is committed within period of conditional prescribed time by the court, between 1 year to 2 years. As opposed to this, in Jewish law, there is no such limit exists, and neither it's thereby any need for an explicit provision for a type of sentence that warns the accused that he is liable to be punished if he commits the offense again. Moreover, in Jewish law, ab initio, the punishment will be conditional only, whereby in Israeli law, the court is authorized to impose an actual prison sentence either by itself or together with a conditional sentence even for the first offense. I will skip down in order to finish in time. The major part of Maimonides' Hilchot Tshuva deal with the benefit and virtue of penitence. However, there is one exception. It's calling in Hebrew Chilul Shem, a discretion of the holy name. The idea of this conception is if someone is doing something so severe, he should not be allowed to have the rights of repentance. In one case, I invoked this idea when it was an appeal of sentence of 4 students of well-known yeshiva who stole a Torah overseas and brought it to Israel in order to sell it and gain profits. I said in my judgment, this is something like Chilul Hashem, and therefore the sentence should not be lenient, it should be very severe. The last example that I have is something that is also in American law. After punishment in a sex offender, after serving the time in jail, someone is going back to the community, and there is law in Israel and in America as well that you can prohibit him to stay in this neighborhood in order not to do it or protect the neighborhood. I said in my case, one of my cases, that this decision reflected in me the idea of Hilchot Tshuva of the Rambam, that one of the paths of repentance is for a person to exile himself from his home, since the exile atones for his sin. Being Israel, to sum it up, being a Jewish state, Israel is committed to apply Jewish law. Maimonides is a main source of practical everyday decision and judgment in Israel courts. I hope that we can learn from the idea of Maimonides not only in his technical legal norms, but also in Hilchot Tshuva, that we can derive from these narratives, we can derive from it conception that will lead us to apply Jewish law in the state of Israel. And this is one of the heritage of Jewish society, that we have a country, we have a state of Israel, and there it's the Rambam, the Maimonides can be part of its legal system. Thank you very much.
Thank you, Judge Drury, for your demonstration not only of the incorporation of Jewish law in Israel, but also here we can learn, and a number of our students are writing about sentencing, which is a major issue in the United States, and we can learn something about rehabilitation in the area of sentencing reform here. I'm sure everyone would like a break for lunch, and I invite everyone to get something, and we'll continue with some questions and comments during the lunch period.
we met, you were here, I don't know how many years ago. You did a faculty colloquium that was wonderful. Well, it wasn't that long ago. And I'm still talking about your presentation at the teaching symposium. Remember that? Yeah. When you did the trip to, which I guess it was Slovakia, or was it the Czech Republic?
That was to that particular was Slovakia.
That was Slovakia, that's what I thought. So we have 20 minutes each?
Yeah.
Does that sound right?
You'll signal us?
Unless you want to. No one else has, but it's entirely up to you. If you don't try to keep them, you don't have to. What would you prefer?
I don't really have a preference. I don't know.
Whatever you want. Okay. Good. Sure. I have yours. Right next to me.
Where's where show up?
Yes.
Very professional presentation.
Okay, so yours is when you're ready to present. We're good to go. Yeah, do you want me to introduce?
Right, just got here. I felt the disturbance.
All right, we're going to get started with the fourth panel on legal scholarship and legal practice in Jewish and American law. I'm going to turn it over to our moderator, Professor Seplowitz.
Thank you, Michael. Good afternoon, everyone, and welcome to those of you who are just joining us. We're ready to start panel 4, and we're making a little change in the order to be more historically oriented. Dean Henry Abramson will be our first speaker. He is a dean of the Touro College Men's School, and he's also a professor at Touro College. He has a very impressive background. He received his PhD in history from the University of Toronto. He's held appointments at Harvard and at Hebrew University, has written prolifically. I had the honor of hearing him speak at the Dylan William Conference earlier this year, And it was a fascinating insight into the Jewish community in Slovakia during the Holocaust, and in particular a cemetery. So I'm going to turn over the podium to Dean Abramson, who's going to talk about originalism and Jewish law. And of course, originalism is a source of much controversy in American law. And I'm sure he'll say a few words about that as well.
15 minutes? 15, 20? Okay. All right. Thank you very much, Professor Suplowitz. It's a great honor to be here. I'd like to share with you one of the most embarrassing moments of my academic career. And it's hard to choose, actually. But one of the most embarrassing moments was a presentation I gave at the prestigious Association for Jewish Studies conference in Boston back in the 1990s. And I had just finished a book on the Talmud, and I had already published some works in history, and I thought, you know what, I haven't actually spoken about my research in front of experts when I switched from historical studies to Talmudic studies to intellectual history, and I said, okay, I'm going to get up and I'll talk about a particular aspect of my research. I presented my paper, and I could not believe the degree of vitriol that I met with afterwards. It turned out that I was speaking to precisely no one in the room, because the world of the study of Talmud had changed so radically from the time that I was in yeshiva to the academic environment of the Association for Jewish Studies that I was really so far out of my depth, and I vowed that I would never embarrass myself by speaking about a topic that I do not know much more about ever again. And yet here I am. It's a joke. Okay, thank you. There was, for those of you who are live streaming, there was like uproarious laughter. It's just the microphones don't pick it up. Okay, so my topic for today is basically going to go back and revisit that painful experience and try to put it within some context, because now I understand so well how my talk at the AJS was such a lead balloon. Because in reality, the world of the study of the Talmud has become dramatically bifurcated into the world that is associated with the yeshiva, the rabbinical seminaries around the world, and with the halls of academe. And these two worlds barely intersect. And when they do, there's often a considerable amount of friction, as I discovered to my peril. So what I'd basically like to do in the next 15 minutes or so is just take you through a little bit of an introduction to the Talmud, to the academic study of the Talmud by contrast, and to some of the debates that are currently going on in the academic world about how we approach this document, and specifically just touching on how there are some parallels with the intense debate going on over the subject of originalism in American law. Again, bravely going into an area that I don't know much about. My area of expertise is primarily history. So Sam Levine, whose work I respect tremendously, indicated to me that most of the people in the audience would probably not have a very broad sense of what the Talmud is. And Sam, I'm going to get you for this later, because just looking around the room, I see quite an erudite audience. So I apologize if I'm going to bore you with some of this basic material, but just to give you a sense of what exactly the Talmud is, we should understand that although it has been called the Constitution of Judaism, that's a very difficult term to actually apply to this bizarre, sprawling 2,711 folio page document. It's a massive work that was largely compiled in late antiquity with the representation of literally hundreds of authors. Many of them, most of them certainly rabbis, but many not rabbis, including women, children, slaves, and a whole host of non-Jews, a whole host of characters appear in the Talmud. It's certainly the farthest thing we can imagine from a code of law, because it rarely presents conclusions. It's all about debates, many of which represent oral traditional debates that go back centuries before its compilation in two versions, a Jerusalem version, or so-called Jerusalem version, really written a little further north in Israel, and a Babylonian version. There's some debate about the years, but let's say the 3rd through the 6th centuries of the Common Era are basically when the Talmud was born in the form that we understand it today. It would probably be more accurate to describe it as a transcript of hundreds and hundreds of discussions on a wide variety of topics in the human experience as a whole. The Talmud moves easily on a stream of consciousness basis from topic to topic, tangent to tangent, with amazing ease. A discussion may start on, let's say, the law of what if someone's cow gores someone's ox, or I guess I should put that the other way around, someone's ox gores someone's cow, and then the cow wanders away to another field and dies there and makes a big mess, and who gets to pay for cleaning up the mess? And by the way, do you know the people who live over in this area, they have strange haircuts? Oh, and what about haircuts? And they'll go on just one tangent after another before finally the Talmud will say, Gufa, let's get back to the main issue at hand, and will rarely present a straightforward conclusion. So it's really not a code of law at all, and it's very hard even to say that it represents a statement of basic principles, because we're talking about a massive document that rarely in any one place sets down a series of issues that are like common beliefs to the entire enterprise. It's a thoroughly non-Western document, or I should say more precisely, a non-Greek document, because it doesn't have your contemporary divisions of books that deal with particular subjects exclusively, broken down into chapters, broken down into paragraphs. You know, it's amazing that Jews, as smart as they are, they could not even invent punctuation. It's hard to know exactly when one sentence stops and another one starts. So it's a very, very difficult document to work with. Furthermore, it's more about legislation, about the debates that go into legislation, than those founding principles. That's perhaps the first reason why it is so distinct from what we might call anything like an American Constitution. It often, more often than not, it is ambiguous, and even at the level of what are the letters on the page. There's very great debate over exactly what are the texts that we're referring to. Of course, the questions of authorship are huge, as we shall see shortly, so we don't even know for sure who wrote this, when they wrote it, why they wrote it, was it in these words or in some other words. So it's a very, very difficult document to work with. Further, if that wasn't difficult enough, we also have historical interference by the church from the 13th century on that's quite insistent and systemic. Once the church discovers the Talmud by an apostate named Nicholas Donin, who presented to Pope Innocent III, a rather ironic name, he presented to him that the Talmud was in fact the reason why the Jews had failed to recognize the truth of Christianity and convert. So at that point, the Innocent III was unaware, of course, that the real reason the Jews failed to convert is because of our, significant consumption of Chinese food. That's really what kept us well within the tribe. Thank you, at least. That was more uproarious laughter for the live streaming audience. But at any rate, the church got very involved in criticizing the Talmud, demanding edits of the Talmud, and as we move into the Gutenberg era, not only was there church censorship, there was extensive self-censorship, where Jewish printers would successively engage in all kinds of obfuscations in order to try and make sure that their texts made it past the censor and into print. So we're dealing with an extremely difficult text to work with on multiple levels. So when we get to the academic study of the Talmud, there's a huge shift that begins really in the 19th century, extends significantly in the post-war 20th century, and into our 21st century as well, with some very promising approaches. The traditional approach is basically to take the Talmud at face value. And this is the way Jews have literally been studying the Talmud and been to use the Hebrew term, engaging in mesirut nefesh. There's really handing over their life's blood, their life's soul, for the study of this document as an act of piety. But basically taking at face value. If it says that Abaye said this, he certainly said it. He certainly said it directly to Rava. Rava certainly responded. Questions of authorship, questions of timing are simply not engaged at all, and the text is taken as literally a canonized sacred text. In the 19th century, some significant advances were made in Eastern Europe when patterns of arguments were clearly discerned within the text. Questions, answers, statements of fact, objections, and a whole series of patterns of debate are identified, and that represented a major step forward without necessarily challenging the nature of the text as it was traditionally understood. But by the late 20th century, the scholars began, and this is where we begin to see a bifurcation between the religious study of the Talmud and the academic study of the Talmud. Late 20th century approaches began to minimize the sacrosanct quality of the text and began to argue that, in fact, perhaps it was not composed precisely as we received it today. And in fact, modern researchers at the end of the 20th century began to identify these anonymous authors called stamaim, or anonymous authors who are constructing the text in a way that gives us a form that really makes sense within the 19th century approach. Finally, when we get to our time, the 21st century is building on this approach that really emphasizes the human element of the creation of the Talmud, which implicitly impugns the divine nature of this text, which is not quite a prophetic text, but is nevertheless held as a document of tremendous sanctity. But much more emphasis looking at the influence of non-Jewish cultures on the text, not only Greek and Latin, which is late 20th century, but also Middle Persian, which is a huge and growing area of study, looking at how the Iranian context affected the writing of the text. And we're looking at things beyond, let's say, vocabulary and legal principles and legal concepts, and seeing how they are applied in Talmudic law by understanding their application in general society. That helps us understand what's going on in the text. So these are all things which really begin to assault the traditional nature of the Talmud, and as a result, the traditional study of Talmud in the yeshivas and the modern study of Talmud in the academy are often at each other's throats. I will tell you a very quick personal story. Some of my best friends are academic students of the Talmud, and one particular woman that I went to graduate school with, she did her dissertation on the Tosefta of Avodah Zarah. And most guys in yeshiva don't even know there is a Tosefta on Avodah Zarah, so it's like an amazing thing just to hear her talk about it. And she once met me at a conference, and she used the phrase b'di avad. And I was still in kollel at the time, and I had no idea what she was saying until finally she repeated herself. She said then b'di'evet, the same word, but we were worlds apart. Here I was completely immersed in traditional Talmudic study in my yeshiva. I never heard the word b'di avad, and she couldn't understand me when I said b'di'evet. So, and the same Aramaic word, which means essentially ex post facto. So there is an unreasonable relationship between these two schools. However, there's no question that the traditional bren, the enthusiasm, the dedication of yeshiva students informs academic study, and the unique discoveries, historical, etymological, anthropological, new modes of analysis, feminist analysis, socio-political analysis, also contributes to the traditional yeshiva study. It's possible that in the coming years we may see some coming together of these two schools. Now, comparisons with originalism, this is where I really don't know what I'm talking about, so I will speak very fast and mumble a little bit. But as I understand the debate, there's basically two major ways of looking at the Constitution that are engaged in modern American debate. The first, we shall say, is originalism, which I understand is associated with the late Justice Antonin Scalia, which wants us to try and determine what was the original intent of the fathers. Those of you who know what you're talking about here, please nod so I feel a little less, thank you very much, I saw a nod back of the room. Trying to determine what is they were thinking at the time based on their understanding of society. The so-called living constitutionalists, on the other hand, say no. They wrote that because they were, after all, white Christian male property holders, and that was their Weltanschauung. That's where they came from. If they lived in our time, if they lived in the America of the 21st century, perhaps they would have seen these debates in a very different light, and they would not have necessarily said and written the things that they did. And this has tremendous implications. Just to give you two of them, as a Canadian, I have to say that they both I've been living in this country for a very long time now, and I still cannot quite understand the American fascination with some of these issues. First of all, civil rights. Of course, the original framers of the Constitution were, some of them, slaveholders themselves, and they saw nothing wrong with that institution whatsoever. And when they said all men are created equal, they meant, white Christian men. And even the term white was not entirely clear. Irishmen, Italian men might not necessarily have been men. I myself, when I have to fill out those census surveys, when they ask me what kind of ethnicity, I always hesitate to check off white because I don't feel white. And the only reason I check off white is because I know it really bothers the white supremacists to think of Jews as being white, so I get a little pleasure out of doing that. But again, if they did not see any problem with slavery, and this country, of course, had to go through a major civil war 100 years later and still bears the scars of that conflict. Perhaps if we interpret the Constitution based on originalism or living constitutionalism, we'll see these issues very differently. And of course, this amazing fascination that the United States has with weapons of this nature, the Second Amendment. It's very hard for me to understand how people can defend, well, you know what, I'm not going to get into a political rampage here. I'm already getting sweated up about it. But perhaps if the authors of the Second Amendment had understood what would be the consequence in our times of the mass production of these weapons, which are far more lethal than anything they could have imagined with 18th century single-firing muskets, perhaps they would not have authored the amendment the way they did. So there's a couple of examples of how this might apply in understanding the Constitution. Finally, to look at it from a Talmudic perspective, in many ways, the debate between the traditional study of the Talmud and the academic study of the Talmud has phenomenal implications for the legislation of contemporary Jewish life. In areas where there are certain Talmudic principles which are enshrined on key passages in the Talmud, taken on an almost divinely inspired basis, and yet were we to perhaps take, rather than an originalist approach to those texts, and rather something like a living constitutional approach to those texts, we may consider them quite different. The Talmud is an extremely flexible document. It is, you heard earlier today our colleague John Loike speak about bioethics. The fact that the Talmud actually has significant documentation that informs the decisions associated with disparate practices today, such as in vitro fertilization, is absolutely amazing, and it is a testament to the genius of this document. But there are many areas where the Talmud is sort of mired in a place of tremendous conflict. For example, the ongoing conflict over divorce law in the Jewish context is a problem of tremendous proportions, and as yet there seems to be no solution, no way forward, because we have an originalist approach to certain arguments in the Talmud. A living approach might revise those. Similarly, issues of gender as a whole. The Talmud identifies, for example, 7 different genders, literally 7 different genders, and the approach to those 7 genders could literally change the way we understand contemporary orientations as well. That's just giving you a couple of examples. This is what I put in Aramaic here to close my presentation, the nafka mina, which is literally a Talmudic term meaning that which derives therefrom. Those things which derive from the argument of originalism and living constitutionalism, when applied to the Talmud, have potentially very, very seismic implications. Thank you very much for your attention. If you like, do we have time?
We have a few minutes. Does anyone have a question
Okay.
or a comment?
No hard questions, please.
We have one question.
Please.
Would have seen themselves in sort of the capacity of continuing the trajectory of the Amoraim and having been more dynamic in that respect. So when you talk about the Nafkamina, I think that that holds true even with them, that the Rambam also would have been willing to not see certain statements of the sages of the Talmud as sacrosanct, but rather individual opinions, whereas some of the more Franco-German commentators would have seen every iota, every word as having that significance. So,
I think that's a very fair comment. I would expand it with two additional comments. The first is that I think on the level of text, like what are the actual letters on the page, everybody would agree, let's get the most accurate text possible. Earlier manuscripts, divergent manuscripts, manuscripts that come from Islamic lands, which are not affected by church censorship, those are all great things. So I think where everybody's in agreement on that, where you see, I think, greatness in the Jewish tradition, and you mentioned Maimonides in particular, are people, when you have people who have what they term in the yeshiva world broad shoulders, who can kind of go against the grain and say, I'm going to defend an argument which is very unpopular, and nevertheless carry the day. Maimonides is a great one. The only problem is that whenever we have people like that in Jewish history, we tend to burn their books, and it takes at least 200 years before we accept them. Maimonides, Rabbi Moshe Chaim Luzzatto, one of the great figures of the 20th century, the Lubavitcher Rebbe, some incredible leaders who remain quite controversial in their lifetimes, and only after the passage of significant time do we realize the impact they had in shaping the tradition. Yes, please. Yeah.
Product as a product of the Roman Holocaust, in the sense that if, God forbid, there was a nuclear disaster in the United States, we would pack our spaceships with every CPLR legal code in the planet and everything about American life and everything in Google, and we throw it in there, and there would be absence of punctuation and disorder of all types.
No room for us either.
And this has occurred with every culture historically that's been wiped off the map. They've tried desperately to put their last words into place. In the case of Jews, of basically the Southern Confederacy, which is, we forget sometimes that Jews are a victim of a civil war in which we lost. The North won, Israel won, Judah lost, and we are the remnants of that group. And so we forget that we didn't have Abraham Lincoln, we had Rehoboam, Solomon's son, and we had a catastrophe where he was taxing the crap out of the North and caused a civil war in which we lost. So I'll get to a point, basically the Chumash is the Constitution, the absence of punctuation, part of the psychiatric disorder of the misery of a people that's lost and had a Roman Holocaust, now has to go travel with everybody, and where so-called all the misinterpretations of Jesus the Jew as an Orthodox Jew that keeps all the services and keeps everything, is basically God, and we're a bunch of jerks, and then on top of it, we are not drawn upon. And you mentioned slavery, and I was bothered by
Dr.
this.
Berman, I don't want to lose your first question.
I'll say the last thing is that the Fugitive Slave Act is sitting right there in the Torah. So I've read all these Southern, very religious men justify slavery from the Chumash, ignoring Jeremiah's edict to get rid of your slaves, ignoring the prophets later, and forgetting that we don't look at the Torah as 613 commandments. We consider the laws of the prophets, the laws of Joshua, the laws that have occurred since as part of the additional factors.
Okay, thank
Upon
you.
that,
Thank
I
you.
thank you for your words. And again, as we came in saying, I said to you that as far as I'm concerned, the Levitical laws of the Chumash have been replaced by tax laws.
Okay.
And that the United States functions
let me-
80% on
I don't want to
Torah
take away
basis.
too much time from my colleagues here. So I'll just say the question that I heard at the initial statement was, should we consider the Chumash the Constitution? And I think that would be definitely a much more appropriate text to consider the Constitution. The only thing is that particular quote, the Talmud is the Constitution of Judaism, that's actually the quote from Saul Lieberman, who I believe you talked about earlier. It's a well-known association. Okay, so please, Dr. Rowland.
I'm Harry and you're Henry.
I am.
Dean Abramson.
Only my wife calls me Dean Abramson.
Henry, thank you very much for a very stimulating presentation. I want to suggest something, and maybe you or others can react to it tonight, or I hope you can stay for dinner. And what I want to suggest is that originalism, well, I say this as someone who is suspect of any ism, that Justice Scalia's jurisprudence is not captured by that word, nor is the jurisprudence of anyone who's ever sat on the Supreme Court of the United States. But if you look at the Congressional Research Service, which has a clause-by-clause and an amendment-by-amendment summary of the scholarship pertaining to, for example, the Second Amendment, which you referred to, you see some very interesting things, which I think reflect something quite extraordinary. What you might call Talmudic principles of interpretation that go to, in part, the original public understanding. Justice Scalia was very careful to say in his opinions and in his public comments about how the Constitution should be interpreted that what he was interested in was the public understanding, not the intention necessarily of an author.
Public
But
understanding at that time.
there was a question of the reception
Yeah.
as well as the intention of authors. When you look at something like the Second Amendment, there is a history, and this is very Talmudic in its approach, there is a history of separating the two clauses. So a well-regulated militia being necessary to the security of a free state. That talks about a free state, which at the time meant the 13 states. So the first clause has been used to support a states' rights view. You need a militia for each of the 13 states needs a militia. And the second clause, the right of the people to keep and bear arms shall not be infringed. And there is a long history of emphasizing either the first clause or the second clause. So already the public understanding is extremely complex and requires a kind of Talmudic mind to decide which of the two clauses to emphasize. Then you have to take into account that in 1791, when the Bill of Rights was added to the original Constitution and it was confirmed, this applied only in regard to the federal government's regulation of the states. It did not apply to the states themselves until the 14th Amendment, which came in as part of the Civil Rights Amendments. So now you have to ask yourself, since we have a Constitution with amendments, how do you interpret the first clause, a well-regulated militia being necessary to the security of a free state? If the Second Amendment is being applied to the states through the 14th Amendment, that first clause is now rendered null and void, which means that it's actually not possible in any straightforward way to say, and we could multiply the examples, and there are hundreds of pages of commentary on this, if you just scratch the surface of it, it's really impossible to say what public understanding we're talking about. And one thing that I would recommend to anyone who would look into this from the American point of view would be Achille Lamar's volumes on the Living Constitution, in which he looks at the role of amendments and how they have changed it. So how can we speak about a document that was regularly amended in terms of a divisive public understanding to begin with, which is then complicated exponentially by a divisive public understanding of the effect that the amendments would have on the original complex public understanding. So I think that our constitutional interpretation becomes more Talmudic because of the layers of history. So you might say it's like a baraita being brought because we have another Tanaj. It's just to use a Talmudic terminology. We're constantly having to bring in other sources in order to understand what a public understanding might mean. And all of this changes in the cases that you cited. By the way, men being created equal is not in the Constitution, it's in the Declaration of Independence. So, I think the question of what the public understanding of the Constitution is, and does the 1789 or 1791 Constitution reflect the opinions of the 1776 Declaration of Independence, even complicates it further. So I don't think originalism in the form in which some people take it, what did the framers intend, has ever been viewed by any serious person, including Justice Scalia, as a theory of constitutional interpretation, which is, I think, why the approaches that the Talmud provides actually can be melded together, just as you talked about academic Talmud study and yeshiva Talmud study coming together. Maybe it will all come together in a rich and plural mode of interpretation that is not limited to the binary of originalism and a living constitution.
That is fascinating. Okay, I better close because I'm worried about, but I want to close with one small joke that I think you'll enjoy, as Harry puts it, and that was very enlightening for me. The Rezeptionsgeschichte is really important for this. Check out this. This is one small thing, just to give you an illustration of Talmudic hermeneutics. When I was in yeshiva, it was the time when the Soviet Union collapsed, and there were a whole bunch of really hungry students from the Soviet Union. So one of the things they used to do is they would stand in line for a second portion. The yeshiva gave free food, so you'd get lunch, you'd eat lunch, you'd go back, get another lunch, take it up to your room. It would go to waste, it would cause bugs, it was expensive, and so on. So I went into the cafeteria, and I saw this sign on the way in that said, "The yeshiva provides food for one portion only. No student is permitted to stand in line for second portion." Okay, Nebuch, I went in, I ate my lunch. By the time I came out, I saw that one of the other Bochrim, one of the other students, had subtly altered the sign to read like this: "The yeshiva provides food for one portion only? No! Student is permitted to stand in line." This should be an underline. Whoops. "The student is permitted to stand in line." That should be an underline. How do we do that? Control U. There. And then an exclamation mark. This is kind of traditional Talmudic hermeneutics at work. Who knows where to put the comma, but it makes a huge difference for how we read the text. Thank you very much for your attention.
Thank you for your stimulating discussion, and I hope during the break or after at dinner we'll be able to continue discussing Dean Abramson's presentation as well as everyone else's. Our next speaker is Eli Wald, who is the Charles W. Delaney Jr. Professor of Law at the University of Denver Sturm College of Law. He holds degrees in law as well as undergraduate from Tel Aviv University, and he was a law review editor, so we have the law review here. And his specialty is legal ethics and the legal profession. And if we look at the title of his talk, it says Jewish Lawyers and the U.S. Legal Profession, the End of the Affair. I think our discussion in the last few moments, or the last 10 minutes, illustrates, at least in part, that we're continuing the affair between Jewish scholars and Jews and the legal profession, and you can see how much we enjoy the disagreeing with each other. So please, Professor Wall.
I was tempted, hi everybody, I was tempted to just cede my time so we can, no, I mean it genuinely, because the discussion was fascinating. Nonetheless, it's not an easy transition to make because, and this perhaps is a quick reply about my title. My paper is about Jewish lawyers, not about Jewish law. But, right, but let me start, of course, by thanking the Dean, thanking Sam, thanking the law review. We've heard it throughout the day. Much appreciated. Thank you for having us all, and in particular,
Just take this down so it's not so.
by all means.
Just everybody.
And let me, in a way of a brief introduction, tell you what kind of a comparative project I'm exploring in this paper. I'm interested in trying to understand the experience of Jewish lawyers in the second half of the 20th century as a comparative exercise, i.e. to explore what the experience was and then to see what we may be able to learn from it in the 21st century. So that was introductory point number one. The second is that unlike some of you who have complete papers, I have to concede I, as of today, have 6 pages, and that is a way of saying it. I would love to receive feedback and comments. We'll think of this paper as one informative stages. So thank you in advance. That said, here's a quick outline so you know what I'm about to do in the 17 minutes or so that I have left. First, I'd like to talk a little bit about the state of knowledge. What do we know about the experience of Jewish lawyers in the second half of the 20th century? I'll tell you briefly that great minds, Jewish and otherwise, have tried to explore what is referred to as the love affair or the Jewish vocation for law or the success story or the overrepresentation of Jews in the practice of law in the second half of the 20th century. And the consensus, I'll present this in slightly greater detail in a minute, is that we don't really know exactly what accounts for this, for the vocation, the Jewish vocation for law. So that's part one. And then the bulk of the paper is trying to advance something I tentatively call the confluence theory. It explains both the success and, if you will, the end of the affair as I'll describe it. And then finally, in part three, I'll try to suggest what it is that we can learn from all of that. So that's kind of the exercise. Okay, so here's part one. Really incredible legal minds, from Mark Galanter to Sanford Levinson, from Gerald Orbach to Martha Mino, have tried to explore what they have called the Jewish vocation for law. And if you ask me to summarize the state of knowledge, I'll tell you that there are roughly half a dozen explanations. One of them is known as the Puritan forebears theory, or the American exceptionalist theory, and that suggests that the affinity, if you will, between Jewish lawyers and American law has to do with American law. It's, if you will, Jewish foundational content. And even the advocates of this theory discredit it fairly quickly. I'll tell you quickly. First, it does not explain the affinity of Jewish lawyers to the law in other countries, as in other than the United States, which is well documented. But secondarily, as Gerald Orbach himself and Suzanne Stone and others have argued, the similarity between American law and Jewish law is greatly invented, notwithstanding the some of the great instances of today's conference and such. To perhaps believe that it can be explained in the Jewish roots of American law is to overstate the Jewish law, roots of American law. So what are the other 5 explanations? Again, we don't have to go through all of them, but there's one known as the carryover theory. Jewish lawyers, so say proponents, are experts in Jewish law, and that love and that passion and that expertise tends to carry over and at least open the door toward an interest in American law. And one of the empirical debunkments of that is that, of course, some of the many of the of Jewish lawyers in the second half of the 20th century, and in particular some of the very well-known and successful Jewish lawyers, were not particularly religious and had no grounding or knowledge of Jewish law. So it's hard to see how that lack of knowledge would carry over. And then there is more theories. There's, and many of you are familiar with all of them. There's what's known as the prophetic trope, the notion that in some meaningful way Jewish lawyers continue this tradition of the Nevi'im or the prophets, and there's the tzaddik theory that Jewish lawyers in some meaningful way embody this Jewish tradition of being tzaddikim or tzaddikot, and so on and so forth. And again, in the paper, I'll try to convince you, and if you're interested, I'm happy to send you the draft to suggest that even people who discuss these theories don't really believe that they tend to explain the affinity between Jewish lawyers and American law. So in this paper, I try to advance a different theory, and I call it tentatively the confluence of circumstances theory. And what I'd like to suggest is there's really no great inherent affinity between Jewish lawyers and American law. Rather, Following World War II and in the second part of the 20th century, there were, well, a confluence of circumstances that explain the affinity of Jewish lawyers and American law, and the very same type of considerations explain, if you will, the end of the affair as we're experiencing it today. So let me run through some of the arguments, and if there are any time for questions, maybe we'll talk about more of them, but here's the first one. So here's what happens beginning roughly in 1950 or 1948 first. And there's 5 of these, if you want to track. First, the quest for socioeconomic advancement and elevated status. So mid-20th century Jews, some predominantly from Eastern Europe, not the German sub-tradition, we can talk about that, are second-generation immigrants. And they're looking for higher paid, higher status jobs, building on the grit and drive of their parents who advocate for education as means out of a lower socioeconomic class. And in the context of overt discrimination that prevails in as late as 1950 and later vis-a-vis Jews, Jews are looking for opportunities that feature individual visible merit and limited reliance on exclusionary networks that were prevailing at the time, and therefore professions are a draw. It's not just law, it's also medicine. So all of that is taking place when doors are beginning to open after World War II. What do we mean, just to give you a whiff of doors are beginning to open? Well, there's the demise, for example, of admission quotas in medical schools and in elite American law schools, so one can actually get in. And then there's the GI Bill that actually makes the cost of legal education incredibly affordable after World War II. There's the changing climate and culture in the country in general that makes doors begin to open. So all of that is happening at the same time, and just to complete the list, what else? There's the promise of law and civil rights. And quite a few of us have spoken already about civil rights, so I'll just say for purposes of now that for members of an excluded group, like Jews in America in the mid-20th century, law represents the promise of an objective, meritorious standard of equality and of justice. Now, it's a promise, but it's, well, not to, no pun intended, it's a promising avenue. In particular, the allure of civil rights is an integral aspect of changing the law and the legal profession is a draw. And all of that is taking place, and here's the 5th and final factor, where law is an attractive field to enter. Now, Mark Galanter is one of the many things he's famous for is, of course, to caution us against nostalgia for the past. So when I say law is an attractive field to enter, I mean, of course, relatively speaking. Nobody is suggesting that law was easy. No one is suggesting that lawyers at the time did not work very hard. But the elite at the time, the WASP elite, is exclusionary, yet very stable and very sleepy. So it's relatively easy, say, for Catholic and Jewish law firms to rise and compete because the elite is slow to respond, or exclusionary and discriminatory, but slow to respond. One can open one's own shop, work extremely hard, to be sure, and rise relatively quickly within the law in the early part of the second half of the 20th century. Let me stop there. Have I convinced you? A confluence of circumstances, not something unique either to American law in the abstract or to the Jewish community. Now, very briefly, what happened since? What do we mean, by the way? So to the extent that with the end of the affair, we mean, of course, not the decline of the importance of Jewish law or the desire to debate it. What we mean is, for example, the overrepresentation of Jews in the legal profession, which is, as a matter of empiricism, documented to have declined significantly. So what have happened to these factors? Let's look at them very quickly. So first, remember, the first factor had to do with the drive of second-generation immigrants, where Jews are perceived, and to some extent are, by the early 20th century, part of the established elite. There is the, if you will, and again, I'm quoting others, not my language, the loss of drive and appetite, relatively speaking, by third-generation or even now beginning fourth-generation immigrants. What else is going on? The sky is the limit. Right? There's less overt, significantly less overt discrimination. It doesn't mean, of course, there's no anti-Semitism, instances of anti-Semitism, sadly. Rather, it means that the decline of overt discrimination is a defining characteristic of a society, and its replacement with implicit bias. So the law is not so unique. If you want to go into engineering or I don't know, social media, it's at least possible. You're not necessarily, as a Jew or a Catholic, going to run into these strong, explicit, discriminatory networks. The climate and culture have changed. So over lunch, Bob and I talked a little bit about the rising cost of legal education. If any person, a member of an excluded group or otherwise, Jewish, Catholic or otherwise, wanted to go attend law school these days, it's not just that the GI Bill as we've known it in post-World War II doesn't exist. In real dollars, it has become extremely expensive. And it's a barrier to entry for especially the disadvantaged and the underprivileged. Law and civil rights have changed quite a bit. We are living through an era of the disillusionment with the law and the perception of law as status quo oriented and perhaps more conservative in meaningful ways than it was perhaps in the 1960s. The decline of the allure of civil rights for several reasons, the rise of conservative civil rights and conservative public interest advocacy. Law is less receptive to civil rights in some meaningful ways, one may argue, so on and so forth. And all right. The last factor, if you will, is for those of us who are practicing, law is hard these days. A lot of the bright, and I don't mean to scare off the law students, law is still, as Justice Brian has told us, there's a great opportunity in the law, and yet law is going through a period roughly in the last 10, 20 years that can easily be described as hyper-competitive. It is hard. It is harder in some meaningful and quantifiable ways than it was 50 years ago. Again, not to suggest that it was easy 50 years ago. And the brightest and the young, Jews and otherwise, may not be particularly eager to go into law schools and become lawyers. Let me just give you one suggestion. It is incredibly hard to make equity partner at a large law firm these days, both in Manhattan and in LA and San Francisco and Chicago. It doesn't mean it was easy in the past, but it's near, statistically speaking, impossible these days. So the notion that you might either start your own large law firm that will become Wachtel, Rosen, Lipton, Katz, or if you couldn't go elsewhere, or the notion that you can, get into and succeed at Paul Weiss, or it's just unlikely, significantly. Okay. So if all of that is true, so that brings us to a pause. What have we, I hope, accomplished? I hope that maybe I provoked you into thinking that there's nothing inherent about American law or the Jewish community that explains the affinity of Jewish lawyers and the practice of law in the second half of the 20th century. Rather, there was a confluence of circumstances that explained that love affair, and these circumstances have changed considerably, such that what? And here comes, if you will, if it wasn't sobering already, the sobering part. I'd like to suggest that to the extent that American law and its practice allowed Jewish lawyers as members of a previously excluded group to advance socioeconomically and otherwise toward equality, that experience may not be open and may not be easily replicable by other contemporarily excluded groups. That is, that the law practice in the 21st century may be, to be blunt, less welcoming and less promising as an avenue for socioeconomic advancement, elevated status, and equality than it was perhaps a generation ago. And another way of saying that, and then I'll rest and would be delighted to entertain question, is that looking to law as an equalizing playing field, as perhaps it served for not just members of the Jewish community, but other excluded groups previously, may be asking the law in the United States to do things that it can no longer offer and can no longer promise. And with that, let me pause. And
6 minutes for questions.
that is fantastic. Well, thank you very much. Yes, sir.
Thank you very much for your talk. I just want to know why you started your discussion in the 1950s. You could have started it in 1850 with Mayor Isaacs, son of the second rabbi, went to NYU, his brother Isaac Isaacs. You started 100 years after the first Jewish lawyer or something like that.
So it's an excellent question. So as you might have guessed, I'm in some meaningful way a law and society person, and usually things start with numbers and facts. So picking 1948 or 1951, as you allude to, and I of course agree, is arbitrary. But the reason why is that prior to roughly 1948, although there's nothing unique about that year, it means a lot to many of us, like you can hear my Israeli accent, but there's nothing magical about that year. But prior to that year, the percentage of Jewish lawyers, and in particular the percentage of Jewish lawyers in position of power and influence in the legal profession, is relatively negligent. So the answer, it's not zero, of course, but the Jewish lawyers practicing as American lawyers. So let me take another crack at it. The percentage of members of the Jewish community who are also U.S. lawyers is relatively small. Now, again, not zero, but relatively small. Things change in terms of numbers considerably after World War II, and that's why I picked the time. Just to give you a sense, I'm fond of sharing with my students, before 1971, there's no meaningful way in which to talk about women lawyers in this country, because the percentage of women lawyers as members of the legal profession, the same definition I use for Jewish lawyers, is less than 1%. It's closer to zero if you want to round it out in whole percentages. So that's how I mean it, although I take your point and you are right, that there are notable exceptions of quite famous and successful Jewish lawyers before that era. That is true, of course. Yes, sir. So am I directing? I apologize. Am I directing traffic, or am I sitting to you?
And why don't we hear from someone who hasn't spoken yet? Professor Schweitzer.
I assume that you might be referring also to discrimination among the, top prestigious law schools against admitting Jews to partnership. Want to comment?
Right. So I gave you, Sarah, I gave you an answer that grounded in numbers, but thank you for clarifying. Right. So generally speaking, picking, say, 1950 is a good time, because prior to that, both elite American law schools and many non-elite law schools that existed explicitly discriminated and excluded Jewish applicants. There's the famous sign at the Yale Law School that comes to mind. But then also on Wall Street and outside of New York, prior to 1948, Jews, again, at the Yale Law School, need not apply for positions at large elite law firms at the time. So, yes, and if you're interested, there's actually, I still have, in research, there's not just a sign, there's a picture of the sign, which was on the bulletin board. So there was no electronic version, but back then, of course, the bulletin board has explicitly, Jews need not apply. By the way, for those who want a popularized version that is based, of course, in truth, on the basis of sex, the recent movie that tells the story of a young law student by the name of Ruth Bader Ginsburg, among other things, gives a popular depiction of the experience of one who finished first in her class, happens to be a woman and happens to be Jewish, first in her class, and at the time was the first to accomplish the incredible feat of making it both to the Harvard Law Review and the Columbia Law Review, only to be excluded, not to find a job. It's a story familiar to us, but it's worth repeating. Not to find a job at any law firm in Manhattan, not in another city, and not in another part of a city, and then becomes, no disparaging remarks on all of us, a law professor, and the rest is history, and you know the rest. But
if I could just add one thing, in the same vein, William Howard Taft, President and later Chief Justice, remarked there are too damn many Russian Jewish people in the legal profession.
Because just as the microphone passes, because you asked me really early on, before I studied, this fantastic question about what do you mean by the end of the affair. One thing that I'll say too, that I haven't gotten to because one only has 16 or 17 minutes. Part of what I mean by the success story and the end of the affair, sir, there's this remarkable story about flipping stereotypes, right? So as you point out, roughly by now 70 years ago, the prevailing stereotype is and this is all documented, not my languages, we don't want to have lawyers with oriental minds. That's the reference to Jews. And within a generation, of course, the prevailing stereotype becomes everybody wants to have a Jewish lawyer. And even that stereotype, by the time you come back, so it's the positive consequences of negative stereotypes. And even that, as we know, it is in decline now in the 21st century. So there's more that I could capture in the notes, but thank you. Dean, of course.
Just a comment about what might be a very fruitful area of research, which you just alluded to, and that is the attitude of clients. So with regard to one firm, Davis Polk, I could give you the whole history because I was there for 25 years, and the first Jewish partner was made in 1971 at the request of Morgan Stanley. But and also the first Jewish and the first woman partner, same person. But the JP Morgan, Morgan Stanley, they all started to insist on promotions. They started to interfere, if you will. We want that person to become a partner. We want this person to become a partner. And it was fiercely meritocratic. The individuals who became partners in the early 70s many of them were simply the most gifted lawyers and clients who actually forced the hand of the law firms. So the law firms, the so-called white shoe firms, might not have made as many Jewish partners as they did if it had not been for the pressure from clients. There's a long story about hostile takeovers and bankruptcy, and whole practice areas arose that the white shoe firms didn't want to touch. So, for example, Davis Polk would not do hostile takeovers because as partners who were there when I started said, that's for the Jewish firms.
Right.
And so you had firms actually grow up around practice areas. So I don't want to
No, Dean,
say anything more about it, but it is a rich and unwritten history about how.
So I'm embarrassed to say it's not unwritten because I've written it. So I had the privilege, Dean, to spend one summer of my life interviewing what at the time were 36 of the greatest still living, sadly many have passed, Jewish lawyers of the era. Some of my work you've seen in the popularized version of Malcolm Gladwell, Outliers, the chapter on Joe Flom.
On Joe Flom, which is substantially
So I'm
wrong,
happy to report that Malcolm Gladwell did not interview Joe Flom, and I did. And that chapter is based on my interview with Joe Flom. So the short version is, you are absolutely right. So in that twin articles that I'm happy to send to you, I call it the pockets of unprotected competition. And so it's absolutely true that, for example, the rise of Skadden Arps and Joe Flom on the one hand, and Wachtell, Lipton, Rosen, Katz was you got it exactly right. Large law firms would not practice. It's not just that they wouldn't practice hostile takeover and defense. They wouldn't, at some extent, practice litigation because they deemed that to be the failure of prudent.
Yes, that's right. So Paul Weiss came into that breach. Marty Lipton invented the poison pill. He invented the staggered board. He basically invented modern M&A. He worked closely with Martin Ginsburg on the tax side, whose wife you mentioned a little while ago, but it was the advent of particular practice areas, changes in the American economic landscape, the advent of large dollar mergers and acquisitions, large scale bankruptcies, and all these things. And so it's partly in the Gladwell chapter on Joe Flom, by the way, whose nephew Dennis Hirsch was the first head of the mergers and acquisitions department at Davis Polk, and the first Jewish head of that department.
So I'll just say, to give you a contrast, so you're absolutely right. Yet another factor is how clients pushed, and again, you got it exactly right, Dean. How the clients that you described did not push for Jewish lawyers. They pushed for the top lawyers, the top meritorious lawyers, and some of them happen to be Jewish. And okay, I want to contrast that if you buy my confluence of circumstances and the declining nature of what's going on today, you may be very well familiar with a similar attempt that did not fare so well, known as a push by clients. So about a decade ago, now 15 years, many of America's Fortune 50, not Fortune 500, so a subset, engage in something called the call for action. And they tell America's largest law firms, if you don't diversify, you're going to come off our preferred provider list. And as if you may know what happened there, so it was right. So it was one of those well-intended, for sure, call for actions that backfired. Because when Walmart begins to demand, for example, that law firms diversify, what law firms do is they only diversify the Walmart team, not the entire law firm, just the team that services Walmart. And then what happens is minority lawyers get pigeonholed to those teams and can't get off of them because the firms won't let them. And 15 years later, when the Fortune 50 realize what's going on, they could have maybe pushed forward, but they don't, then back away. So this is in part what I mean by maybe the confluence of circumstances in the 21st century is sufficiently different to yield different outcomes, to pushes that are quite similar, like client pushes. But one more, I don't want to take anybody's time. I just saw a hand that I...
At dinner, yes?
No, let me make a comment. It's the third time that you've cut me off, so I think at this point that I'll try and keep it very short, though. So, 2 quick points. First, I'm reasonably persuaded by your outline. Seems to be the generally right approach. I think you need at least one more detail. So this kind of follows on the dean's point. One of the things that distinguished law at the time that you're looking is there always already, this is something you already know, there are already a series of tracks for Jewish lawyers. They're lower tracks or different tracks in addition to later with mergers and acquisitions. You've got Jewish firms in New York going back to the late 19th century. Paul Weiss claims its origin going back then, but it's really a 1940s phenomenon. But and then of course there's the ambulance chasing bar, right? The ones that Taft is complaining about. So as a place to move in the 1950s, that second generation, my grandfather pushed my uncle into going to law school. He hated it and didn't practice. But you're clearly right about that. But part of it was there were opportunities even in the face of discrimination at the elite levels at the time. So I think that the story you're telling is probably basically correct. And there's some more detail you can add. 2 quick caveats. I agree with the critique or the self-critique of it's not about the affinity of Jewish law and American law. That's correct. But Michael Walzer has this concept he calls first Jews and Judaism as a culture of argument. And I think that he's right about that descriptively, and I think that may be a factor. So it's not the direct knowledge of Talmudic law that makes young American Jewish men and women feel comfortable, the men, because women by and large were not schooled in the Talmud, moving into law. I think it's the fact that, we argue about everything, and it kind of fits right in. And that's, so I think that's part of it. So there's a cultural affinity, but not necessarily this concrete, legal, rationalistic. The other, which is a much smaller footnote, I think, and I don't know whom else you interviewed, but for that subset of the bar that were Jewish civil rights lawyers, some version of the prophetic story, I think, is true. Right? They weren't necessarily religious, but part of their self-identification as Jews was a sense of a commitment to social justice. So I think for people like Jack Greenberg, for example, through the Defense Fund, he came from a not particularly religious identified family, but that was part of his sense of what it meant to be Jewish. And I think that there's probably more of that. I think it's a small factor. I do think it's a footnote rather than a major. But that would be the only caveat.
So let me conclude, of course, and so I'll say something very briefly, and then I'd love to chat more. So Walzer himself, would you believe it, already opined on this discourse and applying his own theoretical frameworks. He's calling it, in the context of the practice of law, the ambience theory. So there's even a term of art. The zeal for argument, the zeal for debate, the tradition of higher education and all that. The one thing I'll say, and it's the same, and again, I don't mean to be gloom and doom, but to build on your point and you acknowledge your point about existing tracks. About 10, 15 years ago, there was a major innovation in big law firms. It was called the implosion of the old two-track model, associates and partners, and the rise of multiple tracks. So equity partners, non-equity partners of counsel that are not retiring partners. That's the third track. And then associates and non-partner track associates and staff attorneys. And I see you know that you know all of this. About when it just started.
That hit my generation hard.
Right. When it started, some scholars in the legal profession thought of it exactly as what you said. Well, that's a great opportunity. Not everybody is created, wants the same thing in the practice of law. This multitude of tracks would allow more people in, and it will be just like it was for the Jews, but there will be tracks there. Now, I know you're smiling in recognition. So the evidence is just emerging. We don't know everything yet. But what's beginning to emerge, of course, is the same power dynamics from before. So let me just end by, you know who's at the top and who's emerging as the equity, the super equity partners, and who's overrepresented in the entry level. So the rise of new tracks is maybe increasing inequality, not serving as a push toward equality. Thank you very much. I'd love to talk more and hear your feedback and incorporate it. Thank you.
Thank you, Professor Wald. And I think what you have done for us, and certainly you'll be sending us an article, but inspiring us to think about how we can not be negative about the future of law. And we have such talented law students here, and we will find ways. And we as lawyers today should be committed to finding ways to make sure that there is entry, an equal entry for all the new members of the legal profession. Our final speaker, who I want to welcome back to Touro, is David Hollander, who is the law librarian at Princeton. And he is in charge both of the Judaica collection and also the law library at Princeton. It's a very impressive collection. He's going to be talking about the importance of the bibliography. And just as a very short introduction, you've heard a lot about history. And you're going to hear more about history, about the different periods of bibliographies, the early bibliography, when, again, motivated in part by anti-Semitism. Then we'll move on to Robert Cover, who we've certainly has impacted all of our discussions, and we will hear a lot about him in the next, again, in his impact in the next panel. And finally, going back to the morning, we'll hear about the impact of Mishpat Ivri, in other words, the Israeli legal scholars. And I'd like to welcome you, and you have your 20 minutes, which I've been told to use.
So thank you very much for having me. So this is a position I'm not normally in, because normally I'm speaking not to faculty members or students. I'm really speaking to other librarians. So I'm going to sort of be speaking a language that you may not be familiar with, and taking a perspective that I think is valuable but might be a little bit different. So I like to say I'm sort of on a crusade, if you will, a losing crusade to save the art of bibliography that used to be sort of the stock and trade of librarians and isn't anymore for many reasons. But I'm going to die on this hill trying to save it. So what is it, I guess, is the first question. So, so I almost propose that the title for this talk would be "Why My Presentation," in the spirit of the approaching Passover, why my presentation is different from all the other presentations. So here's how it's different. So everybody knows what a bibliography is. For students, it's that annoying thing that you have, or well, for faculty members too, that annoying thing that you have, well, not in Blue Book format, but in other formats that you would have to put at the end of a paper, at the end of a book. But in the library world, it's basically a curated list of resources on a topic, often annotated with summaries, annotated with analysis, providing a description of each of those sources. These can be multi-volume length or book length or even just an article length, and you do see them in law reviews. But where the hard work is in the curation, and this is what librarians used to do, really work hard to curate a list that's useful and that teaches something. So it's not just every article on a topic always. It's not just, you know, what a database spits out, a list of articles, and I'm just going to annotate them all. There's something more. There's some more thought put into it. So the librarian uses his or her judgment to choose which to add to the list and which to analyze. So this sort of scholarship, and it is scholarship, is different than substantive scholarship, most of what we're hearing today. So substantive scholarship starts with the topic, and it uses substantive arguments from other sources in a variety of ways to make an argument about that substantive topic. Whereas bibliography takes sort of a step back from the substantive discussion. And it sort of zooms out and looks at the larger context. It starts with the sources as a whole, not with the substance of a source. And then instead of using the substantive argument in the sources, it zeroes in, it zooms out at the 30,000-foot level to get a sense of the whole ecosystem of sources and how they fit together. Things like who is citing who is not citing who is not including the other person. How does this sort of ecosystem of sources about a topic fit together, and what does that tell us about the scholarship in that topic? So that bibliography can tell us something about the topic, but it also then gets turned back over to the faculty members for them to use as a tool to advance their substantive scholarship. Historically, for centuries, this is what librarians did all day. You know, they would sit and they would make these things. Now, in an era when there wasn't digital, when even an editor, when books weren't that common, you know, it was extremely difficult. Somebody would sit and, you know, for decades and write a bibliography on a topic. As the modern age advanced and as digital technology sort of replaced a lot of the needing to find the things, it sort of has fallen by the wayside. So this is why the art of bibliography librarians is dying. You have online catalogs, online bases, and these are way better to actually find a list of articles than a human who's hunting them down. So I don't mean to diss online databases. They're essential to the work that we do. But I argue that number one, they're not perfect. For example, talking about Robert Cover and his Nomosa narrative, I primarily use two different databases to find articles in my research, and one is Hein Online. I assume everybody's familiar with Hein Online. Okay, good, so not. The other one is the Index to Legal Periodicals and Books, which has been rebranded Legal Source, which I don't really like, but nobody asked me. So Robert Covered in neither of those databases is given the subject Jewish law. And you can understand why when you read the article, there's not that much Jewish law in that. Some of his subsequent work has more, but it's so important to legal scholarship about Jewish law, either to push back against him or to sort of carry on what he's doing. So in that case, if you were searching for the most important articles on Jewish law in those two databases, you wouldn't find Nomosa narrative. You'd have to come across it another way. So not only are those databases not perfect, but I also argue that searching a database doesn't fully replicate a human eye or a human mind in putting together these sources and handing them together. So sure, they spit out easy long lists, but when it comes to analyzing how they fit together as a scholarly conversation on a sort of global level, a human eye, somebody will read the sources and understand the sources and make connections between the sources, is necessary to sort of do what is really valuable about a bibliography. So why do I say it's a losing battle? Because of all the other time, budgets, fewer and fewer librarians hired at a law school. Please hire more librarians.
And it's just demands of other things that have pulled it away. So I'm frankly not optimistic that these are going to increase in their number. I hope that librarians stick to it. So for today, I want to sort of discuss, so I spent 3 years putting together a bibliography of a very specific reason. So it's academic law research that deals with Jewish law in some way or another. And it was a labor of love. I read every article. Almost every article in full about Jewish law that deals with Jewish law. I sort of set up parameters as to what I would do. So now there's this bibliography and it's done and it's been published. So what could we learn from it? So I want to sort of take through some of the things that we can learn from it. So one thing that I immediately noticed when I started doing this is that there was sort of in the early 20th century, up until about 1945, there was sort of a defensiveness to a lot of these articles. It was clear to me that they were arguing against something, some kind of attitude about Jewish law that existed in the legal academy. And I did dip into Britain as well in this time period. Now there were, what does that tell us? So just to give a few examples, even as sort of there's a 1940 article that talks about Jewish law as the stepchild of scholarly investigation. That was a quote. And then just sort of some other examples. There seem to be arguing that Jewish law is worthy of study to begin with, which leads me to believe that other non-Jewish scholars at the time thought it was unworthy of study. And they often seem to be making an argument that Jewish law is richer and more dynamic and less rigid, and not rigid, which leads me to believe that there was this attitude in the academy about Jewish law being rigid and not really have anything to say to anyone, let alone to the American legal system. I think part of this may be because some of the prevailing scholars at the time thought of this as biblical law or Mosaic law. They certainly were, these are the non-Jewish scholars, unable to dip into rabbinic-ish, Talmud and that sort of thing, where the richest meat of Jewish law is, and they just would look at the laws in the Bible and think, oh, those are harsh, those are rigid, there's really not much we can learn from them. So some of these early articles are trying to bring to the attention of other scholars the existence of a Talmudic literature and a rabbinic literature that deals with these things. So I thought that was really interesting. There are some exceptions. It's most notable that even Isaac Herzog, who was the chief rabbi of Ireland and then the chief Ashkenazi rabbi in Mandatory Palestine and then Israel, he published very rich, very complex, very rooted in his yeshiva Talmudic background, articles that really are sort of published early in American law journals. There's one from 1931 that's published at Temple, the precursor to Temple University's Law Review. So there are certainly notable exceptions. There's also, discovered sort of a little mini flurry of articles in the 1920s dealing with the emerging Zionist state of Israel and this relates to the judge's talk from earlier, sort of what would be the role of Jewish law in the state that it would exist, and what would Jewish law as a philosophy have to do to be prepared to play a role in a state. And they seem to be quite enthusiastic that it would play a huge, huge role as the law of the state of Israel. Of course, that didn't come to pass, but there was certainly a flurry. So only by sort of zooming out and looking at everything from this bibliographic perspective can we learn these kinds of things about scholarship and maybe learn then what was going on in academia, what was its attitudes towards Jews, what was its attitudes towards Jewish law. And there's a lot more we can do. So that's just sort of one sort of lesson that I took away from the research that I did. Now I also want to sort of unspool sort of one thread of the research. So I've already called it an ecosystem. I can think of it as a tapestry. There's all sorts of strains and streams that you can see when you see it on this global level, not just a list of articles, but a list of articles that have been read and curated and analyzed against each other. So just to sort of pluck one thread out of the string of what could be many, I want to start with what I call the big moment. And the big moment is Robert Covard's Nomos, a narrative. Now, because I'm not a substantive scholar, I'm not going to talk about what he says or evaluate what he says. I'm going to see what the effect he has on the bibliography of Jewish law scholarship. So, Nomos and Narrative, I don't think I'm going to be uncontroversial by saying is a very famous and impactful article. Just to get a little sort of quantitative here, according to Hein Online, it's been cited in 1,796 articles and 11 court opinions, including one Supreme Court opinion. And then I also counted 12 law review articles up until well into the 2000s that don't just take his ideas and argue with them, but the articles are about his article. So it's sort of a slightly different thing than talking about his ideas. The articles that talk about his ideas are probably closer to that 1,700 that cite him. But articles just about his article, including one by Sam Levine, which is Halacha and Agadah translating Robert Cover's Nomos and Narrative, and that is from 1998. So, but even as late as 2013, and I stopped my research in 2015, we have Nomos and Narrative in Jewish Law by Alan Jotkowitz. So, so it's a famous article. And it prompted, it prompted several streams of scholarship, some that have nothing to do with Jewish law, just the notion of law and narrative and the relationship of them. So you've got all this outgrowth of his article that has nothing to do with law, but he also sort of prompted a new stream of scholarship about Jewish law. So just to sort of, with all sorts of caveats that we could talk about, in the 17 years before Nomos and Narrative was published, Hein Online has 19 articles indexed with the subject Jewish law, and indexed to legal periodicals has 39. So that's the 17 years before it was published in, that's 19 before Nomos and Narrative was published. In the 17 years after, Hein Online has 98, and Legal Source has, or indexed to legal periodicals and books has 301. So you see this explosion. Now there may be many reasons for that explosion. They may be related to Eli Wald's talk, sort of now Jews are finally entering the profession and they're able to get, but I just still think it's notable that, somebody can do, so this is where I can hand it back to scholars. You really want to discover what was going on with, instead of law firms, in legal academia regarding Jews and Jewish law. This is sort of a tool like a bibliography can sort of prompt that and get that going. And then, of course, so that's the big moment. Robert Cover. And so then, of course, just to sort of follow one string along is Suzanne Last-Stone's challenge to him. Her pushback on this whole notion about it, which then gets replied to by Sam Levine, who pushes, who takes in the criticisms by Susan Last-Stone and sort of tries to develop a method to use Jewish law in comparison to American law, and then sets up the notion of evaluating Jewish law on its own terms, considering carefully the expanded principle incorporates theological underpinnings and wouldn't be appropriate, and so on and so forth. So this is sort of one little thread that I can pluck from this literature that we can see on a sort of a global level. So from Cover to Stone to Levine is that thread. Now, obviously, this is overly simplistic. I'm neglecting all sorts of work by other scholars, but I think doing a bibliography can set up these kinds of discoveries in a way that just sort of delving only into the substance without sort of taking a global look can. And that's why I think bibliographic analysis is valuable. Just some other 30,000-foot trends, some other examples of things that I learned and that I could explore more, and I hope to explore more, and I hope others will explore it. So law students love to write about Jewish law, but always the same few topics with notable exceptions. They love to write about Jewish divorce or disputes about Jewish divorce that make their ways into American court. They love to write about Eruv disputes, and of course, kosher supervision law. So these are things, and what is common about these things? They often really are American constitutional law issues where a Jewish legal issue gets involved. And so law students sort of write about these over and over again. So so there may be many reasons for that. I just sort of proposed one. There's a whole subcategory of Israeli professors who publish in American law schools who take a sort of different sort of take about Jewish law and its role in society based on their experience in Israel. And then there's a whole other trend of sort of professors who really never had an interest in Jewish law, but who want to, as a part of exploring their Jewish heritage, tend to try to find something sort of to tie into their scholarship. So those are just a few of the other trends that I found. There are many more that you can have, and so I encourage the Touro Law School to encourage its librarians to do this kind of work and to give them the time to do it. And I hope that my work is useful to you and somehow as scholars who do Jewish law and American law. So thank you very much. Sure.
There's time for one question.
If there's no other question, I don't. So the question I have is when people say curation, I usually think of selection.
Okay.
There's a process of, like, if we go see an exhibit in a museum and we hear that it's been curated, what we assume is someone has selected a subset of the universe of pieces of art for us to enjoy. So I was struck when you said that you read everything.
Yes.
Because it doesn't sound to me like curation. It's not curation as selection. It's curation as an exhaustive. And I was wondering if you can speak more a little bit about it, or maybe there were selections by virtue of the criteria that you...
There were selections. I decided to curate on a large scale, so I tried to read everything, but I did exclude certain things, and I list them in my preface why I was excluded certain things. I rather than doing every student-written article about divorce, I sort of picked a few of what I judged to be the most sophisticated ones and sort of put them into representing other ones. I excluded work that wasn't really about Jewish law, it was really about biblical law, just from a totally non-Jewish perspective. But I do think a shorter bibliography than I set out to do could really curate. Somebody could write a bibliography about the scholarship that leads from Cover to Stone to Levine and other people, and it really can be curated. The other thing is that the annotations weren't just summarizing. I did make connections. Something I thought was, largely off base, or I stated that, part of the scholarship is being a scholar, and I explained why I thought it was sort of off track or not useful, and which ones were especially useful. So I think curation, I use it as a very elastic term. So, and I went big, but I think you can do this and go little as well.
Roger Citron, I'll be the 13th person to talk about Professor Cover in the next panel. But the connection between your two talks. In other words, right, when we look at, they coexist in time with each other. What's going on? Right, in other words, right, the profession opened up, now no one cares. So, at least, that arguably, that's oversimplifying, but I'm a teacher, that's what I do. And then, of course, you have talked about this sort of profusion of Jewish law scholarship. And I'm just curious if there's any connection between the two, or what could we say?
Well, I think there is. I think it may be that the explanation that I give of Robert Cover's brilliance or non-brilliance, because both can inspire articles, may be undermined. Maybe it is that there's just more Jewish professors at the time. I mean, and this is the kind of, or maybe it's, and most likely it's a combination of the two factors. Although Cover isn't until the 1980s, and he's starting and so the explosion in academia seems to come a little bit later than sort of the opening up in the post-World War II, and maybe there's a reason there. I don't know.
And the only reason why I ask is because I thought that oftentimes, instead of going to Cravath or Debevoise or whatever the elite white shoe firms were, well, go become a professor. In other words, I'm sort of drawing on in my mind, there's a New York Times Magazine article from a long time ago that sort of said, so where did the bright Jewish boys go before they were let into the white shoe firms? And the academy was one of them, and yet it seems like they couldn't, or they elected, for whatever set of reasons, not to write about Jewish law.
So all I'll say briefly is that, first of all, credit here goes to the Law Review and Sam, because we haven't met before, and I think it's fair to assume that we didn't know about each other's work, although I agree with you, right, some of the synergies or some of the ways in which, or perhaps consistent things or things that could be consistent have already emerged. But just to give you a very brief tentative reply, so first of all, it's not the case that the academy was open for Jews. It really depends on what departments you're talking about. Law schools became relatively quickly after World War II, but not immediately, much more open than, say, the classics department in many elite universities. And some argue that even today, one would want to not generalize about the American academy. But I will tell you, because there's those of us who study the legal profession, or also study the branch of legal profession called academic lawyers, the number of Jewish law professors in U.S. accredited law schools is in great decline, relatively speaking. So there was a period of time where there was a significant overrepresentation of Jewish law professors, at least in some subset of American law schools. Not all law schools, depends what part of the country you're in and what law schools, but some law schools. And if you track all hiring, if you want to see some of the data that NALP and others have accumulated, if you're wondering about what's going on in the last 20 years in hiring, now it's not just Jewish law professors, but the number of new hires that happen to be Jewish appears to be significantly.
So just a quick point about sociology of knowledge. One of the things that makes Cover's article important and pivotal, particularly to the bibliography, is that nobody really would have written what he wrote earlier, including him, right? It's only after he's tenured at Yale for 5 years that he suddenly says, you know, I'm going to write about this stuff that nobody, right? It's sort of like not part of the canon at all. And then he gives license to everybody, right? So he really sort of like the dam breaking. But you know, when he was at Columbia before, if he had written Nomos, he wouldn't have gotten hired at Yale. It's pretty straightforward, right? Once he's at Yale and he's established, he gets the Harvard Forward, less prestigious now, but at the time, the most prestigious single venue in the legal academy, and it's extremely well received. That breaks the dams open. I was just starting teaching in '86, so soon after Violence in the Word. But that's what happened.
We are. We are sitting in Touro College, Jacob D. Fuchsberg Law Center. Jacob Fuchsberg was a medical malpractice lawyer with a great love of argument. It supports everything that all of you have said, who became very wealthy and who ran for office and ended up on the New York State Court of Appeals. Saul Wachtler ran for a series of public offices and ultimately became the chief judge of the New York State Court of Appeals. And Jacob Fuchsberg and Saul Wachtler sat on the Court of Appeals together. Jacob Fuchsberg is the person after whom the school is named. His son Alan is on our Board of Governors. Saul Wachtler is a beloved adjunct professor here. And they are approximately the same generation of Howard Glickstein, who was the dean here for 16 years. And I would suggest that many of the things that you referred to are represented in these three personalities of the Touro Law Center. Jacob Fuchsberg illustrates in the post-war period it's not just Milberg Weiss and so on, the tremendous influence of medical malpractice lawyers, which was one component of it, that applied outside of the elite New York City law firms, because he was not welcome in the elite New York City law firms. Also, the involvement in politics and the election of state judges and how that, which you didn't mention, but it was important. So Wachtler shows there's a kind of prophetic strain, but he was a Republican, so it's not the same prophetic strain as Howard Glickstein's, and I prefer not to go into detail on that right now. And Howard Glickstein, who was one of the principal draftsmen of the Civil Rights Act of '64 and the Voting Rights Act of '65, represents the civil rights strain. So in a way, in this school and within the history of this school, many of those strains are reflected. Just wanted to make the observation. since we're here.
And we should remember Leon Laser as well within that tradition.
Leon Laser, who was the principal author of the pattern jury instructions in the state of New York and one of New York State's great judges, who should have been on the Court of Appeals and was a distinguished judge in the second department, was also a professor at the school.
Thank
So
you
there are
very
connections among all these.
Again, we look forward to publishing beyond your preface, which I found extremely engaging. And are we ready for the next?
We're going to take a quick
All
5-minute
right.
break.
All right, thank you very much.
It's so funny how you didn't even know.
I think the first 30
It was great, thank you. I worked on a bibliography a long time ago. By the time I finished it, the internet was sufficiently well developed. Schmidt, but I don't know.
They could teach you cutie. Yeah, right, but that's right. No, that was like, oh, I forgot. Yes, and so that was the qualification. And Professor Winter, I'm glad I asked the question. The answers were very good. Because they coincide. They really do. Exactly.
Sure, because if you survey it, you get feedback and it gets in.
Sure, of course.
When I get to go back to them tomorrow, immediately.
Those are two. We really do it well.
It's really funny. I'm sure we could.
Yeah, hi. Hello. Yeah, I was just but so you thought about how Jewish entry into law compares with like other equally lucrative white collar careers?
So the only thing that's fantastic question. So I alluded to as far as I can tell, because I'm trying to collect sources and see if you're suggesting density, where are they going? Even now, as opposed to
yeah.
So in the past, I'm pretty sure it was also medical school. Particles they couldn't get into engineering. Or, but if you're asking me, my sense, and it's subject to significant research, investment banking, Wall Street, and then I don't mean the geographical sense, the sense of financial institutions. And that's the one concentration, kind of the financial institutions, and then a lot of
very productive.
what I call the sky everywhere. So arts and science, but nothing enough, to show a trend. It's just
Right. That's actually not, that's an answer to a question I wasn't actually thinking about. So the question on that is to what extent is that geographic center in New York? I mean, I'm not thinking about Jewish in 20th
Right. But if you ask me to answer a question
I think about 1960 entering medicine and engineering and 20 other equally white collar.
I wish you would.
Thank you.
It's a cover of the beginning. And individualized career with visibility and success. And in many, so they're very famous. So I searched historical answers. It's law, and then it's and a few other freestanding professions of some kind. Really, so we got published before that question. Because at the time, now it's not, but back then, commercial real estate was Jewish happening. Not as a lawyer. Tax advisors, non-accountants, freestanding professions are allowed Go back and I read it. But I was saying, of course, the graduate I'd love to. Honor.
Come on aboard.
I said, welcome aboard. Hi, you did a brilliant job of What's that? On time. I know, so we'll talk fast. Right. Good. Briefly is good. We'll go straight into it.
Very good.
Everything brief is good.
So I was very angry. I wanted to write a rebuttal. I'm like, you know, I was involved in the case, and we just picked up America and we argued in front of him. It sounds like repeat states.
I don't remember reference to you, you'll forgive me, but I'm going to go back and look at that.
The only citation is to calling our
And your point was?
the primary point was that third parties really needed information. Third parties, like in principle.
That we can get started again?
So you
These
don't
are
want
much more
You
interesting.
do not want me to grab. No, but
I'd
I'd like you to sign that and give it to me.
Hold on a second. I think I'd be much better off reading your note.
Here, you- Whoever's going first.
Michael is going first. Good afternoon, everyone. If you would take your seats, please, we can get started with the final panel of the day. I think I'll listen to you. I'll just bring you up here. Yeah. Nothing, I'm kidding. Good afternoon again. My name is Myra Berman. I'm the Associate Dean for Academic Affairs here at the Law School, and it is my pleasure to introduce to you, one at a time, the three panelists on this final panel, which is Equity Considerations in Jewish and American Law. Our first panelist will be Professor Michael Helfand, who is the Associate Dean for Faculty and Research at Pepperdine, and I will be extremely brief. I have already taken the red pen and cut out half of the material. Professor Helfand joined Pepperdine Law faculty in 2010, where in addition to his teaching, he serves as the Associate Director of the Diane and Guilford Glaser Institute for Jewish Studies, as well as a member of the faculty of the Strauss Institute for Dispute Resolution. In addition, he serves as both an arbitrator and consultant for the Bet Din of America. Prior to joining Pepperdine Law faculty, Professor Helfand was an associate at Davis Polk, which we've heard so much about today, where his practice focused on complex commercial litigation. Professor Helfand will be speaking today about the future of Bet Din arbitration in the United States. Professor?
I feel like, given today's conversation, I should just tell stories from my bus rides to Metro North with Dean Ballin in the morning back in 2000. Those were fun. Much more interesting conversations we had than what I'm about to present today. I probably shouldn't start that way. Okay, good. What am I going to talk about this afternoon? My goal this afternoon is to speak ever so briefly about the future of Beit Din arbitration in the United States. When I talk about Beit Din, or rabbinical court arbitration in the United States, What I have in mind is the marriage of really two institutions. This is quite, in many ways, an American story. On the one hand, the classic Beit Din, classic rabbinical court under Jewish law, a panel of 3 rabbis that would and can and continue to resolve disputes in accordance with Jewish law. It's an ancient institution that has been merged with a more, well, also ancient, but also modern institution of arbitration, the voluntary submission by 2 parties of a dispute to a third-party neutral for binding resolution. And so the merger of Beit Din and arbitration, Beit Din in many ways being itself a court, arbitration being a method of alternative dispute resolution, has given rise, an increasing rise, to what I refer to as Beit Din arbitration, parties executing arbitration agreements and thereby contractually agreeing to submit a dispute for resolution in accordance with Jewish law. You sign up 3 rabbis, you sign up some Jewish law, and together you have yourself Beit Din arbitration. What's important about it is Beit Din awards, Beit Din arbitration awards, just like any other arbitration awards, are enforceable in the United States, are enforceable under classic arbitration doctrine, just like the decision, again, of any other arbitration tribunal. And some indications is that the use of such forms of arbitration are on the rise. So to give you a flavor, in 2002, as you heard in a little bit about in my bio, I do a lot of work with the Beth Din of America, one of the largest, if not the largest, Beit Din arbitrator in the United States. And so I get privy to some of their fun statistics. To give you a flavor, in 2002, on the commercial docket, the number of commercial cases filed with the Beth Din of America in 2002, the entire year was 56. And by comparison, to give you a sense, in 2019, in the month of January, there were 18 cases filed. Just to give you a sense of scale, in 1 month of 2019, you almost have half as much as you normally have in an entire year. The last full year I have numbers for right now is 2016, when 115 cases were filed. So that's one way in which you can kind of get a flavor for the way in which Beit Din arbitration appears, although real statistical data isn't completely available, is on the rise. And while it's on the rise, it's also been increasingly mired in various forms of controversy. And by this I have in mind not just Beit Din arbitration, but the broader category of religious arbitration, the submission of disputes for religious adjudication to religious authorities for resolution in accordance with religious law, has been increasingly mired in various kinds of controversies. And I have 2 in mind that I want to talk about. There are more, but 2 primary ones in mind. The first, Beit Din arbitration, has been increasingly mired in attacks on arbitration more broadly, concerns that arbitration doesn't truly represent the voluntary consent of the parties, that arbitration has inadequate procedural safeguards. And if you want a good example of this, in 2015, the New York Times ran a series of 3 articles where they described arbitration as, quote, how it, quote, stacks the deck of justice. And the first article was kind of the similar critiques that we've seen, the second as well. But the third one focused on a criticism of religious arbitration subsumed within this broader critique of arbitration more generally. And it said, quote, religious arbitration may have less to do with honoring a set of beliefs than with controlling legal outcomes. So that's kind of one version of the criticism of religious arbitration, a criticism built upon a criticism of arbitration generally, lack of consent, lack of procedural safeguards. There's also been a second criticism, in some way conflicting or in tension with the first, a criticism of criticism and controversy over the discriminatory trend of anti-Sharia laws in the United States. Numerous states throughout the U.S. have enacted such laws because of purported concerns about Sharia and Sharia courts enforcing Sharia law. Just to be crystal clear, I'm deeply skeptical of these laws. I think they're discriminatory. I think they have no purpose. I don't think they do anything useful. I think they're a solution in search of a problem. I can say more about that if anybody's curious. But for now, let me just simply say that they have generated criticism of religious arbitration more broadly. And so what I thought I'd do this afternoon is just briefly sketch, maybe in response, thinking a little bit about a conference on American law and Jewish law, maybe say a little bit about the pros and cons of religious arbitration and Beit Din arbitration more broadly, why it's important, what the pros are, what some of the concerns are on the horizon, and maybe a ever so gentle sketch of some solutions. Okay, pros and cons of arbitration. What do I have in mind? So when you think about what it would mean to have a pro or a con of religious arbitration, Beit Din arbitration, what I want to do is take 2 different perspectives. I want to talk a little bit about the pros from the perspective of the state, which is enforcing arbitration agreements and enforcing arbitration award. And I also want to take a brief view of the pros from the perspective of the religious community itself. What might that look like? So if you think about what the pro of religious arbitration is from the perspective of the state, meaning why would the United States want to enforce religious arbitration agreements and religious arbitration awards, to my mind, the most important role that these institutions play is solving the adjudicative gap created by constitutional law, or more specifically, the Establishment Clause. And what I have in mind is religious arbitration in the United States, the way in which a wide range of disputes are submitted to third-party neutrals via the form of arbitration that courts themselves could not resolve under the Establishment Clause. So maybe one of the most well-known versions of this is the church autonomy doctrine, which prohibits courts from intervening in disputes that implicate the inner workings of religious institutions. And here you have a wide range of disputes, often employment disputes, where a court can't get involved in the dispute because it involves somehow a particular kind of religious employee in a particular kind of religious institution. And indeed, if that employee shows up in court for some sort of redress, a court will simply say at that moment, I'm sorry, we can't hear the dispute, we have to dismiss the case. And what dismissal of the case means in these contexts is the employee loses. There's nowhere for the employee to go in order to get legal redress. Let me give you an example. I just picked one at random. Friedlander v. Port Jewish Center, a case from 2009 where a synagogue terminates a rabbi, Ariel Friedlander. Ariel Friedlander says there was a breach of contract. The synagogue claims that the breach of contract, there was none. It was justified by claims of gross misconduct and willful neglect of her duties. And the court, instead of trying to figure out whether or not it was truly breach of contract or whether it was truly some sort of gross misconduct or willful neglect of duties, the court dismisses the case. Why? Because, quote, review of Friedlander's claims in this case would require scrutiny over whether she should have, inter alia, read more extensively from the Torah at certain services, prepared students for their bar or bar mitzvah more adequately, performed certain pastoral services that were not performed, or followed the temple's funeral service policies. And this, the court concluded, the Second Circuit concluded, would involve impermissible judicial inquiry into religious matters. Now let's think for a moment what this means for Ariel Friedlander. What it means for the rabbi is, very simply, the rabbi cannot walk into court and actually seek redress for a claim of breach of contract, because answering the questions underlying the breach of contract claim means that the court would have to enter into areas that are prohibited by the Constitution. So this is the church autonomy doctrine that puts certain kinds of claims out of the purview of courts. And it has kind of a cousin, depending on your theoretical view of these things, maybe it's the self-same rule, is the religious question doctrine. Certain areas that are prohibited by the Establishment Clause from courts trying to resolve those disputes. This often involves not just employment matters, but also the sale of religious sorts of goods. Here, my personal favorite example is the attempted class action lawsuit against Hebrew National for providing fake kosher hot dogs, or I guess they're real hot dogs, but they're fake kosher in any event. This is a form of kosher fraud, and the plaintiffs in this purported class action sought millions, if not maybe if they would have gone far enough, billions of dollars for all the fake kosher hot dogs that they had purchased and the markup from the kashrut standards. And the court ultimately, two courts, federal court and state court, ultimately ends up dismissing the dispute because the court determines it cannot be the arbiter of what is and is not kosher. Now, this is all somewhat amusing, especially given that Hebrew National answers to a higher authority, but evidently not a lower authority. But all told, it does mean that there's a purported class of plaintiffs that have been unable to secure legal redress in courts. And if they're right, if they're truly right that there has been some sort of fraud purported on them, they're out a lot of money, and there's nowhere for them to go in order to get legal redress. Now, what's interesting about all this is, I've said these are areas where in principle plaintiffs just automatically lose, and by which I mean the cases are simply dismissed. But religious arbitration from the perspective of the state, a state that presumably is interested in plaintiffs having a forum to seek legal redress, plaintiffs actually in these contexts can make use of religious arbitration. And this is because, simply put, the very types of claims that could not be submitted in court can be submitted through various forms of religious and more specifically baked-in arbitration. Parties can actually submit the very dispute that a court would have to dismiss. And this is because, simply put, First of all, arbitration is not considered state action, therefore arbitrators can't violate the Constitution. But more importantly, or more fundamentally, arbitrators may issue an award in a particular claim, whether or not Ariel Friedlander was or was not neglectful of her duties, whether or not hot dogs are or are not kosher, and a court can enforce the judgment of an arbitrator, in this case a religious arbitrator, without passing on the merits. Courts don't pass on the merits, don't relitigate the merits of a dispute when enforcing an arbitration award, but instead simply enforce the award if the parties agree to arbitration and thereby avoid the constitutional problem. In this way, religious arbitration, in terms of a pro number one, is the way in which that they provide certain types of plaintiffs with a forum for legal redress that could not be provided by courts. Let me give you, that's from the perspective of the state. From the perspective of faith communities, religious arbitration provides a very different kind of advantage. It allows people, individuals, members of faith communities, to resolve their disputes in accordance with shared religious values. And to give you a sense of what I mean by this, or the way in which, or how powerful this value can be, I want to compare two different kinds of numbers. So, any arbitration buffs out there? Students? No? Who loves arbitration? Okay, great. So let me tell you a little bit of something. There are two types of arbitration agreements. We call them pre- and post-dispute arbitration agreements. Pre-dispute arbitration agreements, that's like what you know, when you said, I agree for your iPhones and all that stuff, and they have arbitration provisions that are going to require you to adjudicate the dispute in some island that's terribly inconvenient for you to get to. But in any event, more seriously, pre-dispute arbitration agreements are agreements that you sign way before there's any dispute. Often in consumer contracts or employment contracts, you don't even know you have a dispute yet. Later on, something might happen, but for now, you just want to either become an employee or purchase a particular item. Post-dispute arbitration agreements, by contrast, are arbitration agreements executed once you know you have a dispute. Now, here's the kind of general rule of thumb. Pre-dispute arbitration agreements are very common. Always click an I agree on your phone. Post-dispute arbitration agreements are uncommon. The reason they're uncommon is because once you know the contours of a dispute, both parties go to their lawyers, and they say to their lawyers, is it a good idea for me to go to arbitration? And invariably, given the comparison of the two fora, one is better and one is worse. So one lawyer tells their client, arbitration's better. The other lawyer tells their client, arbitration is worse. It's not going to be better for both of them unless somebody's made a mistake. Right? Okay, and this strategic gamesmanship means you rarely can get both parties to agree to post-dispute arbitration agreements. So, in a famous study by Louis Maltby in 2003, he went through the American Arbitration Association records, and he determined that employer-employee, the number of post-dispute arbitration agreements in 2001 were 6%, 2002 were 2.6%, business-to-business, the number even lower, 1.8%. I was curious one day, and I do lots of free legal work for the Beth Din of America, so I said I'd like you to tabulate some numbers for me. What's the equivalent number from, I asked them from 2008 through 2014, how many of your disputes are pre-dispute and how many are post-dispute for the Beth Din of America? And so the number, again, employer-employee was 6%, 2.6%, 1.8%. What was it in the context of religious arbitration? The number should be low for the commercial docket, right? Because somebody found out from the lawyer it's a bad idea. And anybody want to guess? It's late in the day. Call a number out. 60%. Higher. Higher. 96.8%. Now this is odd. Maybe the answer is that Jewish lawyers just make tons of mistakes, but we heard about the merit and the Jewish lawyers, they do so well. Okay, great. So what's going on over here? And the answer, at least my best guess is an answer, that even though the strategic gamesmanship that animates most forms of arbitration ought to preclude these types of numbers when it comes to post-dispute arbitration, when it comes to religious forms of arbitration, or at least this is one indication, parties appears to be some sort of value proposition that presses people towards post-dispute arbitration, even though it may not be strategically a good idea. And this is one way in which you can see how the values of religious arbitrations for faith communities, how deeply held they are, to the extent that parties appear to forego strategic advantages in order to pursue religious forms of arbitration. So I've tried to describe to you two types of advantages of religious arbitration, ever so briefly. On the one hand, they improve or expand access to justice. On the other hand, they allow faith communities to pursue, even when it's at their strategic disadvantage, to pursue a dispute resolution that is in accord with their shared religious values. those are the pros, but the cons are also the same. And let me do the same thing from the perspective of the state and from the perspective of faith communities. From the perspective of the state, as I mentioned ever so briefly at the outset, courts police arbitration not by evaluating the merits of a dispute, but by making sure that there are procedural rules in place, captured in statutes, they enforce the terms of contracts, make sure that the terms of the arbitration agreement are in fact followed by the arbitrators. The challenge is, in the context of religious arbitration, it's often hard to police procedure. And the reason is for the very same reason I mentioned at the outset. Religious rules, courts can't evaluate them, and that's why they can't hear these disputes. But the challenge is the procedural rules that govern religious forms of arbitration, they're also religious rules. And sometimes, as a result, courts, when they have to ensure the procedural regularity of religious arbitration proceedings, they hit a little bit of a constitutional wall. For example, arbitration statutes, federal and state, generally allow courts to vacate an award if the arbitrators refuse, quote, to hear evidence pertinent and material to the controversy. Well, how do you know what evidence is pertinent and material to the controversy when that rule is interpreted through the prism of a Jewish law choice of law provision? One can imagine a claim that arbitrators didn't quite follow the rules as they should have under Jewish law, a claim that maybe some arbitrator excluded evidence wrongfully. A court, however, is in a bit of an odd position. While they normally can evaluate evidentiary rules when it's secular law, when it comes to religious law, how can a court figure out whether religious arbitrators did the right thing? To do so would invariably mire them in the very kinds of religious questions prohibited by the Establishment Clause. More complicated issues come up when it comes to policing neutrality through arbitrator qualification provisions. So there's been ongoing litigation for the past 3 years, a case Garcia v. Church of Scientology. The Garcias claim that the Church of Scientology took lots and lots of their money, but they signed agreements that say that they have to submit all disputes to arbitration. The arbitrators need to be, quote, in good standing with the mother church. Now you can imagine the Garcias' view on all this. They say that Church of Scientology doctrine prohibits people who are in good standing with the church from speaking to them, let alone hearing their claims. They say the whole process is rigged. And the Church of Scientology says, no, it isn't. Well, now we have a little bit of a question. How's a court to figure out whether or not the rules of the Church of Scientology will allow for the establishment of an arbitration panel in accordance with its rules that actually provides a neutral hearing for the Garcias? And courts, up and down, federal courts have said, we can't figure that out. And therefore, we can't hear your claim to refuse enforcing the enforcement of the arbitration agreement. Well, what does that mean? If we can't hear your claim to refuse enforcement, well, you know what we're going to do? We're going to enforce the arbitration agreement. And so the Garcias end up before an arbitration tribunal of members of the Church of Scientology hearing a dispute about the Church of Scientology, which has now ruled against them. One can see the ways in which, if the very purpose from the perspective of the state is to provide increased access to justice through religious arbitration, one of the ways in which that's undermined is by the ability to police religious procedural rules. On the side of the faith community, the challenges are similar. If the goal is to allow parties to secure some sort of forum for religious adjudication in accordance with their shared values, that kind of voluntary submission of a dispute to religious authorities they deem meaningful, helpful, useful, in keeping with what they believe, communal pressure presents a real problem for religious arbitration. Courts generally do not consider social sanctions sufficient in order to invalidate an arbitration agreement. Those forms of duress, courts generally say, do not rise to a high enough level in order for us to say that looks like duress because of the religious pressure you've faced, maybe religious pressure that comes with attendant economic or financial consequences. But if we're really committed to the notion that religious arbitration has value because it allows parties to voluntarily pursue their religious commitments, then the fact that courts do not police communal pressure represents somewhat of a counterpoint. And so let me conclude by simply saying the following. If I'm trying to present a picture of what the future of religious arbitration looks like, in particular Beit-Din arbitration, on the one hand, great pros. On the one hand, it has the ability to expand the amount of access to justice available to members of faith communities that otherwise might have their claims dismissed by courts. On the other hand, it allows faith communities to live out their lives in accordance with shared religious values and have their disputes resolved accordingly. Yet on the other hand, if it's going to be successful, we have to have a little bit of tinkering with the judicial treatment of religious arbitration. We need to find ways, maybe, ever so maybe, to roll back judicial reluctance to interrogate religious rules, find ways to maybe minimize our interpretation of the Establishment Clause and allow courts to evaluate whether or not religious tribunals are, in fact, adjudicating, both in terms of substance and process, are adjudicating in accordance with the provisions of religious arbitration agreements, and also to heighten judicial willingness to invalidate religious arbitration agreements on account of social pressure. If we want to make sure people can voluntarily enter religious arbitration as a forum, we need to make sure that that is truly voluntary. Embracing such changes will allow both the state and the relevant religious communities to unlock the full potential of religious arbitration. We can increase voluntariness, police procedural fairness, and thereby leverage religious arbitration to increase access to justice and allow those who so choose access to an adjudicative forum that tracks their own religious values and principles. Thank you. No. This is super complicated. So when Luis Garcia called me for the first time, there are a couple of odd things about it. So I told him to do a couple of things, but he didn't listen to me to, and then he lost, so he should have. Here we go. There are two ways that this litigation could have gone. I told him either embrace the provision or challenge it. So one way to embrace it would be for him to have tried to nominate people who he believes he wanted to claim were in good standing with the Mother Church, that the Church of Scientology would not have believed were in good standing with the Church, and force the court to adjudicate that. And then what the court would have done was realize it couldn't adjudicate the arbitrator qualification provision, would have had to either sever it or invalidate the entire agreement. So, and that's not just a strategic point. What I mean by that is I actually think enforcing the provision was impossible, and as a result, and since it was integral to the arbitration agreement, at least that's how I read the agreement, therefore the arbitration agreement should have been invalidated. So that's one way to think about the case. And there are other cases like that. I didn't mention it, but there's this New York case from 2007 where in a trust agreement, you have a provision that says the arbitrators need to be members of the Orthodox Jewish faith, and a court invalidates that provision because who can figure out who is a member of the Orthodox Jewish faith? To quote John Locke, each man is orthodox to himself. So yeah, you see the problem over there. So I think Garcia, they either got it wrong because they should have invalidated it for an inability to determine who is in fact in good standing with the Mother Church, or alternatively, I think you should have been able, absent constitutional challenges, to determine whether or not these particular individuals, if there was evident partiality, kind of under arbitration doctrine. But that might have been too wonky of an answer for you. I hope that was.
Yeah, thank you.
Yeah.
Anyone else? Okay. Thank you so much. Let me introduce to you now Roger Citron, whom many of us know quite well. He is a professor of law here at the law school and one of the associate deans. Before coming to Touro in 2004, he had a couple of jobs. He worked for more than a decade. He clerked. He worked for a large law firm. He worked for the Department of Justice. He worked for FindLaw and the Federal Communications Division. He bounced around a little. Here at the Law Center, he regularly teaches civil procedure and administrative law as well as complex litigation. And in addition to his administrative duties and his ongoing scholarship in the areas of law that he teaches, he also studies and writes in areas of law and literature, municipal law, jurisprudence, and constitutional law. He has organized and is an active participant in national and international conferences, including one in Paris on the Alfred Dreyfus affair and the Leo Frank case, and another in Shanghai on the history and legal aspects of Jews in Shanghai in the 19th and 20th centuries. Professor Citron's journalistic and scholarly writings often focus on matters of significance to the study of Jewish American law. And today he will be speaking about the work of Professors Robert Cover and Sam Levine. You have the mic.
I'd like to dissent from my biography. Because really I stand today, we're in the room with so many wonderful scholars of Jewish law, and I do not consider myself, anywhere close to that. And in fact, even we've talked a lot about, as I understand it, Professor Cover and nomos and narrative. I'm actually going to talk about justice accused. And so let me come into it this way. And it's Professor Helfand talked about telling stories, so I'll tell some stories. It seems only apt. First story is, to set the stage, right? We all know who Sam Levine is. That's why we're here today. All I want to say about that is, whatever errors and omissions I make in my following remarks, I got it right when we chaired, as the chair of the appointments committee, when we managed to persuade Sam to come here from Pepperdine. So, in the spirit of the day, we can agree to disagree. So, what about Robert Cover? And all I want to bring up is that for me, I entered Yale Law School in the fall of 1989. Professor Cover had actually passed away, had died several years before that. I think it was in 1986. But he hung over the law school, and he hung over in particular the experience that I had at the law school. My favorite course, what a shock, procedure. And that was the first, I think we were the first group to actually use the casebook. They'd used the materials, but in Professor Fiss's procedure class, we actually had the more than 1,000-page edition of Procedure by Fiss, Cover, and Resnick. And while, those of you who've had me for civil procedure and you want to decry, Penoyer versus Neff through God knows what next case is coming down from the Supreme Court on personal jurisdiction, right? You know what we were doing in the fall of 1989? The Coney Island school desegregation litigation that Judge Weinstein presided over. And a remarkable story of judicial innovation, a story about joinder and a dynamic and innovative reading of the rules. And yet the chapter concludes with Judge Weinstein ultimately not being able to bring about full desegregation on Coney Island and accepting a magnet school, right? The story, it's set out in wonderful detail and several hundred pages in the book, is a story of compromise because of the limits, the constraints on judges in terms of resources. So that was first year of civil procedure. I then, much to the dismay of my father, spent a lot of time in the clinic at Yale Law School. Do you know who else spent a lot of time in the clinic? Robert Cover. He moved his office into the clinic at Yale Law School because it was there that the combination of idealism and advocacy that characterized so much of his work, that is where he chose to reside. It was a very meaningful symbolic action by a full-time member of the faculty. Now, I did not come back to Professor Cover until I came here and began teaching jurisprudence. Now, so what I'm going to talk about is really the most basic sort of issue or question in jurisprudence. It's where the course begins, because it must. Natural law and positivism. And this is reflected in the title, right? Tragic choices and fidelity to law. Tragic choices, of course, the echo from, at least for me, the article by Calabrese and Bobbitt. Fidelity to Law, the title of Professor Fuller's article from the 1950s, in his dialogue with Professor Hart about natural law and positivism. That was also assigned in the reading. But before you could get to that, I had the students read some of Justice Accused. Now, and what's interesting here is that what I hope to show is that, and Professor Hollander, in the last panel session, did this quite well, right? That we see a lineage from Professor Cover to Professor Stone to Professor Levine, and you could say that, you you could even sort of articulate or see a mentor-protege relationship between Professor Cover and Professor Levine, because Professor Levine, as Professor Winter pointed out, and while he stands in that same tradition, he has, he comments upon it. He challenges it in certain ways at the same time that he affirms it. So I will talk about both Professors Cover and Levine, and as I say, in Justice Accused, Cover suggests that for Northern judges, prior to the Civil War, the decision to enforce the Fugitive Slave Act was, it's the phrase that I'm borrowing from Calabrese and Bobbitt, a tragic choice. And the book is about the agonized conflict between positive law or formal law and conscience or justice. However you want to array those opposing concepts, that's very much what the book is about. And here I want to say a little bit. I don't know how much of this was said in prior sessions today about the background. Justice Accused was published in 1975, and his decision to write about the dilemma of the anti-slavery judges before the Civil War, right? The dilemma of, do I, as a judge, enforce the Fugitive Slave Act? It grew out of what he described as a short polemic against judicial complicity in the crimes of Vietnam. And that's straight out of, those are Robert Cover's words from the introduction to Justice Accused. And the polemic that he's referring to is a book review that he wrote in 1968 in the Columbia Law Review. He decried the actions of federal judges who enforced the draft laws at that time. And Cover, in that book review from 1968, he discusses judicial civil disobedience, right? Calling on judges to disobey the law and dismiss prosecutions pending against draft resistors. Now, as Cover later explained, several of my colleagues at the Columbia Law School seemed more upset at the rather facile judgments passed upon the revered and honored dead for their part in slavery than at the attack upon the sitting bench for its part in Vietnam. And that is where Justice Accused springs from. And he begins the book, this is also in the introductory chapter, right, by noting the connections between Lemuel Shaw, the Chief Judge of the Massachusetts Supreme Court, and Captain Vere in Billy Budd. Shaw, of course, was Melville's father-in-law. And so Myra pointed out, I teach law and literature. Billy Budd, in the same way that Nomos and Narrative was a seminal text for Jewish law, Billy Budd, seminal text in law and literature. You can't, it's the granddaddy of them all, right? It's the Rose Bowl of novels on law and literature. And so if you haven't read it since 10th grade, right, the comparison that Cover suggests is between Captain Vere and Lemuel Shaw, Chief Judge Shaw on the Massachusetts court. And both are required to adjudicate a hard case. In the novel, Billy Budd, innocent Billy Budd, angelic Billy Budd, he's been conscripted to serve on the ship and goaded into striking his tormentor, Claggart. Claggart dies from the blow, and what Vere has to do is enforce the Mutiny Act. Now, under the Mutiny Act, Billy is subject to a court-martial. Vere serves as prosecutor and judge, and Vere recognizes there's no question as to Billy's fate. He must hang. Struck dead by an angel of God, yet the angel must hang. And that is what happens. Billy is pronounced guilty, sentenced to death, and Cover notes that, and this is really sort of wonderful literary interpretation, Chief Justice Shaw, like Captain Vere, confronted with the conflict between adhering to law or doing justice, notes that Shaw, like Vere, followed law, enforced the fugitive slave laws, despite personal opposition to those laws. And there's even further additional parallels. The fugitive slave was very Billy Budd-like in this way. You may recall, if you remember Billy Budd, right? What's the thing? Billy Budd at his trial stands mute. He can't speak. He's been throughout the novel. He's described as having difficulty with speech. Neither the fugitive slave nor Billy could assert any defenses That is, the fugitive slave in the proceeding stood mute in the same way as Billy Budd. Of course, the fugitive slave, that was as a function of law, right, a command of law. Now, it was similar, last similarity, last parallel, summary proceeding, no opportunity for appeal. Now, Cover points out, it would be remarkable if Melville in some way wasn't thinking about, writing about his father-in-law when writing Billy Budd. And Cover then goes on in Justice Accused to go through the Northern judges, abolitionists in their personal views, opposed to slavery. They by and large did not take into account their personal views when deciding a fugitive slave case. And what the brilliance of Cover's book is that he talks about this, he roots that decision in professional ideology. And you understand, right, for students here, a slave had made his way to the North under the Fugitive Slave Act. There was a legal proceeding if the slave was then captured, in which the relief sought was, under the act, you must return the slave, or the former slave, from the North to the Southern state, to the slave's prior owner. And so Cover talks about the 19th century judge inherited a tradition binding him to explicit sources of law, including laws that recognized and enforced the practice of slavery. Further, the professional ideology that I referred to was that judging requires, right, a disregard, to not take into account personal preferences when deciding a case. To quote Cover, the judge of this era ought to be will-less, right? W-I-L-L-less. And also, as part of his historical account, abolition was thought to be a, quote, personal or political view, not a legal view. So, Shaw, a judge such as Chief Justice Shaw, saw himself as unable to do anything other than follow the law. And the other sort of brilliant aspect of Cover's book is that he goes through and he parses the opinions. And he shows that, his analysis shows that judges in this situation, right, he talks about the concept of cognitive dissonance, and what the judges would do, they were often, expressed reluctance to make the decision. They showed an unusual reliance upon precedent, and they often invoked the Constitution in ruling against the fugitive slave. And especially for someone like Shaw, who decided other cases in a very different style, in a very different judicial style, this approach was notable and pronounced. So as Cover elaborates, they found themselves confined by the Fugitive Slave Act of 1850. Now, someone like Shaw in particular, he's really sort of the case, the paradigmatic case here. In Massachusetts, he was subject to vicious criticism, right? He was pilloried as a Judas for enforcing the act. And nonetheless, at great personal cost, it really engaged in the agonizing decision of deciding to enforce the act. So, this is how I chose to introduce, right, the conflict between natural law, conscience, positive law, or formal law, like fidelity to law. Now, there's a couple things before I move on to Professor Levine. This is, in its own way, we're very familiar with this account of the conflict between natural law and positive law, right? Between conscience or morality and the duty to obey or fidelity to positive law and the conflict that creates. Think of Dr. Martin Luther King, Letter from a Birmingham Jail, the film Judgment in Nuremberg. Law and literature, right? In law and literature, we almost always see this as, right, this is the conflict, the central conflict in the novel, right, that Vere faces. What do I do when torn between these? What I was struck by, now moving to Professor Levine, and I have to credit, he's not here today, but he's certainly with us here in spirit, Dean Avi Sophir, right, from Hawaii Law School, someone who was a colleague of Robert Covers, a colleague of Sam's, who's written about Jewish law and American law. And Dean Sophir said, you should look at, and this is chapter 21 of Sam's book, which is where the tragic choices phrase, Sam employs it there to talk about in the Holocaust, tragic choices that had to be made during the Holocaust. And he does this by talking about exploring the published responsa of Rabbi Ephraim Oshry. And the first story that Sam tells, right, is that in 1941, Rabbi Oshry, survivor, right, in Lithuania, lived through the Nazi occupation and the atrocities of that, and was asked in 1941, there is another rabbi. Sam tells the story, right? Rabbi David Itkowitz. He has contacts with Lithuanian authorities from professional relationships prior to the war. What to do? Can he be asked, should he try to intervene on behalf of Jews at that time who had been captured? And that was the question put before Rabbi Oshry, and he starts from the premise, under the Jewish law, that there is an obligation to act when the life of another is in danger, right? And Sam, in his chapter, says, quotes Leviticus, do not stand idly by the blood of your neighbor. And there's very few exceptions, right? The duty to aid. And as Sam points out, as we all know, it isn't the same in American law. But what to do when you're attempting to save the life of another person could put you, right, in danger, or put you in danger. And so Rabbi Oshry adds to this, right, also that there is no obligation to put one's self in danger. Quoting from Sam's article, quoting Rabbi Oshry, who is to say that a third party's blood is redder than yours? And so we have these sort of countervailing considerations, and as Sam points out, Rabbi Oshry said that in this situation, Rabbi Itkowitz would not be standing by idly if he declined to act because of facing even possible danger. And he also cited, Rabbi Oshry, the position among some legal authorities that although there is no obligation to do so, it is deemed admirable to risk possible danger in an effort to save a life. What happened? Sam concludes the story in his chapter, right, that Rabbi Itkowitz did approach the Lithuanian authorities and did succeed in gaining the freedom of a number of those who had been captured and were not harmed, and he was not harmed in that process. Now, what I love about this story, right, and sort of thinking back of, through two prisms, right, jurisprudence, positivism, natural law, also the prism of, Cover, Stone, Levine. What I love about this story is that it illustrates that when confronted with a tragic choice, fidelity to law, right, following the law, may produce a just result, a moral result. And I'm going to stop there. I'm actually going to stop there. There's more I could say about both of them, but as they say, I'll save that for rebuttal. Thank you.
Let me introduce to you our final speaker for the day, Judge Louis Kornreich, who is one of Northern New England's top reorganization specialists. He served as Chief Judge of the Bankruptcy Court for the District of Maine for 14 years, and even during his tenure on the bench, the judge was a sought-after mediator in the Bankruptcy Court and in the U.S. District Court, due primarily to his multifaceted approach to mediation and his skill at helping parties achieve comprehensive and pragmatic solutions in difficult cases. Since leaving the bench, the judge has been providing mediation services in the private sphere and is a registered mediator in the Southern District of New York, the District of Delaware, and the District of Massachusetts. His mediation work covers bankruptcy matters and all aspects of civil litigation. The judge also currently serves as a co-chair of special projects for the Mediation Committee of the American Bankruptcy Institute. Today, he will be discussing alternative dispute resolution under American law and Jewish law. Judge?
Thank you.
You're welcome.
I know it's the end of the day, and I have to confess that I'm having as much trouble staying awake as the rest of you, so we'll try and make this as painless as possible. I want to narrow my topic. It says ADR. I was just introduced as going to speak on ADR. ADR is rather large. It encompasses mediation and arbitration and judicial neutral dispute resolution and other aspects. I would like to concentrate on the trend that we are now seeing in the federal courts, and we have been seeing in state courts for many, many years, of mandatory mediation. And I'd like to look at mandatory mediation through the lens of Jewish law to see if there's anything that Jewish law might assist us with in entering this new realm, particularly in the federal courts. What's going on? Many of you may subscribe to an online publication called Law 360. Anybody? Okay. About a week ago, there was at least one article, and perhaps second or third over the course of days, about overworked federal district courts, trial courts in the federal system, and the increasing use of mandatory mediation as a means of clearing dockets. I want to emphasize that, as a means of clearing dockets. So the motivation for having mandatory mediation is because there aren't enough judges, or there isn't enough time, or there are too many cases, or there isn't enough money, or there isn't enough space in the courthouse. Whatever composes that is causing a crisis. And therefore, there is a need to move cases outside of the courthouse as quickly as possible. We often say in the federal system that the district courts are slow to follow the bankruptcy courts. The bankruptcy courts have been engaging in this type of shift now for probably 15 years or more. Many local districts in the bankruptcy courts have mandatory mediation rules where a judge may order parties to participate in mediation. One of my colleagues said that mandatory mediation is an oxymoron. You can't have a mandatory voluntary procedure. So how is it that we can have mandatory mediation? Well, the excuse that's given is that the mandatory portion is only getting the parties into the mediation room, but that the process remains voluntary. Well, that's really not true. Because if the mediator is a judge, or a retired judge like myself, there is a certain pressure that is put upon the parties to arrive at a settlement. Moreover, some of the rules in the bankruptcy court and some of the rules that are now developing in the district courts allow the mediator, whether that mediator is a judicial officer acting as a mediator or a private mediator, to determine an absence of good faith in the mediation room. Meaning that if party A comes in and makes an offer that the mediator thinks is reasonable, and party B doesn't think it's reasonable, the mediator is empowered by local court rule to send a note to the judge that party B is not proceeding in good faith, and party B may be held in contempt of court. In other words, a party may be compelled into a voluntary settlement. A year ago, I was asked to testify before the Commission on Consumer Bankruptcy of the American Bankruptcy Institute. It's a large panel of about 15 scholars and judges and practitioners on instituting mediation in consumer bankruptcy cases. There's a little history, some personal history, which I'll share with you. The court in Maine has a very simple mediation rule. If parties would like to mediate, they may mediate, and the court will permit mediation. But after the financial crisis in 2007, the consumer bar came to the local rules committee. The local rules committee came to the court and said, we need mandatory mediation to force the banks to mediate mortgage foreclosure disputes. Now, that wasn't so terrible if you think about it in a Chapter 7 context. Chapter 7 is a liquidating bankruptcy. But in a Chapter 13 context, it was problematic because Section 1325B of the Bankruptcy Code prohibits a forced moderation of a mortgage facility. You cannot reorganize or rewrite your mortgage in a Chapter 13 consumer case. It's prohibited by law. So an end run was attempted to have judges forcing lenders and consumers into mediation to modify what couldn't be modified at law. I resisted that at the time, and we never instituted that procedure in my jurisdiction, but it became a very, very common procedure, and it helped, I put that in quotes, courts relieve the burdensome dockets at that moment in time between 2007 and perhaps 2012, to relieve the courts of these dockets of foreclosures. Last year, coming back to the Consumer Commission, I testified before the Commission and was asked a question as to whether or not mandatory mediation would be helpful, and I said it might have its uses, but I don't think that it's necessarily helpful. And one of the judges on the panel indicated that he had sat in Los Angeles, where they have a mandatory mediation procedure in consumer bankruptcy cases. And he was required to do his visiting judge duty as the mediation judge, and was appalled because unrepresented debtors were being forced into compromises in consumer matters simply to get it over with. To reduce it to its simplest terms, a bank would come in and say, you have a non-dischargeable debt for $1,000, and we'll take $500. And the mediator, anxious to move the case along, would say to the debtor, just give him the $500 and move on. And the debtor would feel compelled to agree to the $500 when there was absolutely no obligation at law to pay that $500. And these cases just kept moving along. In other spheres, in state courts, where I have little familiarity, but I'm aware of what goes on, in domestic relations, you don't get to see the judge in a divorce matter unless you've first gone to mandatory mediation. In small claims, you don't get to see the judge unless you've first gone to mandatory mediation. So people are forced into voluntary compromises. I say voluntary with a smile because there's nothing voluntary about it. Now, is there something that we can learn from Jewish law in this area? The Gemara in Sanhedrin I think it's from Hay to 7, from 5 to 7. There's a whole discussion of mediation. And it's very interesting how it arises, because the discussion begins with the number of judges that are required to sit on a commercial loan case. Must it be 3? Can it be 2? Can it even be 1? And if it's a mediation, a judicial mediation, can the parties agree to 3, 2, or 1? And is there judicial immunity in such a mediation, where there might be immunity in strict justice? And may a judge, even with the agreement of the parties, insist on implementing a compromise in mediation? And will that compromise be enforceable, even if the parties have agreed? And the Gemara goes on to discuss whether or not a kinyan is required in order to effect a settlement in a mediated compromise. A kinyan, in simplest terms, it's a form of taking ownership in Jewish law. So must the parties actually take ownership of their settlement so that it can be enforced? In civil law, for the kinyan, what is done is that the judge immediately puts the settlement on the record, so that there is no way from a party who questions his voluntariness the next day can ever withdraw from it. Or the parties are forced into executing an agreement on the spot, which would be a form of kinyan, if you will, to enforce the settlement. This is what's going on, and it's what the federal district trial courts are attempting to do in very, very sophisticated intellectual property cases, in patent cases, in complex litigation, is forcing parties to mediate disputes. So the question is, can Jewish law inform the federal courts on an appropriate way to deal with this conundrum? How do we solve the judicial resources crisis? How do we get people to go to mediation, which is a very effective way of dealing with problems? How do we support the very concept of conciliation, which is something that Dean Balin and I have been talking about for years? In an adversary system, how do we foster the idea of conciliation? Can Jewish law help us solving these issues? And my suggestion is that it can, because there are very specific rules that we've developed in Jewish law. As to the timing of a settlement, the parties may invite the court. Now remember, we're talking about judicial mediation, not an outside voluntary mediation outside, nothing extrajudicial. This is the court-sanctioned mediation. When can a court mediate? Well, a Beit Din can mediate before the litigation begins. Some say it may mediate even after the litigation begins, but before the judge has arrived at a notion of who the prevailing party will be. Can there be mediation after a judgment? I spoke with Judge Drury last night about Justice Alon and a ruling that he made on this very aspect of Sanhedrin as to the inappropriateness of a post-judgment settlement. Now, what is the concern with timing? It's very interesting. The concern with timing in the Gemara has to do with judicial ethics. It has to do with conflicts of interest. It has to do with the appearance of conflicts of interest. How can a judge give an indication to the parties and direct them towards settlement because he believes party A will prevail over party B? How can that occur without party B feeling that he has to concede because party A has already won the case? And isn't party B entitled to a din, to a judgment? Well, these are issues that we have dealt with in Beit Din for over 2,000 years and have some experience. And there is a great concern about the tension between forcing a compromise and allowing a compromise to happen. We often make the mistake that Jewish law deals with justice and in the sense of extrajudicial justice and mercy, and we think that justice and mercy might be better than strict judgment. That's one view. Another view is, and the Gemara is very, very precise with its language, is that anyone who supports compromise over strict justice is a blasphemer. Why? Because the judicial process is emulating the Almighty and emulating a judicial determination to our best lights, and that if we say we know a better way, what we're doing is rejecting the idea of God's law. Which brings me to my closure. What motivates this in Jewish law is the concept of Yirat Hashem, of awe of the Almighty. The judge is to be imbued with this awesome idea of his responsibility. Now we would say his or her responsibility. Making a judgment causes trepidation. Making a judgment is extremely scary. And if a judge believes that it is a terrifying event, the judge will be most careful in rendering a judgment. And that forcing a compromise is a way of escaping, if you will, from the responsibility of formulating an actual judgment. Forcing a compromise is a way for a judge to say, I don't have to have that fear of the Almighty because I can convince the parties to do thus and such for their own mutual benefit. Now, we cannot tell the folks around the corner to have Yirat Hashem. We can't say that if you're going to engage in developing a mediation process, it has to be based on fear of the Almighty. But what we can do is take a very, very strong look at the ethical implications of forcing parties into a settlement. Thank you very much for your time at the end of the day.
Harry is on the agenda for some brief closing remarks.
I want to say first thank you to the members of this panel for 3 outstanding presentations, 3 very stimulating presentations. I want to make an observation about what we've done today and the context in which we've done it. The body of law, and I began the day and we discussed last night the question, what we mean by Jewish law. Is it a defined or limited corpus, and what is in that corpus are codes in the sense we understand them. Is the Code of Maimonides a code in the same sense that the U.S. Code is a code? We covered some of these issues throughout the day. They are issues that are difficult to talk about without regard to the religious commitment or commitments of the participants. What is most often the case is that conversations about Jewish law and the ways in which it might relate to, be different from, be similar to American law take place perhaps in a yeshiva context. There is an outstanding podcast for those who are interested. Those who are interested probably already know about it, called Headlines, which looks at, on a weekly basis, issues of American law from a strict, what we would call yeshivish perspective, typically, so that you have the heads of yeshivas considering legal and policy questions from a strict Jewish law point of view. This outstanding podcast is directed by David Lichtenstein, who is on the board of the Touro Board of Governors. So that's one kind of conversation. Another kind of conversation that I associate with the explosion of Jewish law articles and scholarship begun by Robert Cover and Nomos, a Narrative, is a conversation that looks to principles of Jewish law, procedures of Jewish law, tries to derive inspiration primarily from the prophetic strain, but as well the methods and traditions and texts down through the ages, and does not require of its participants or its admirers any sort of religious commitment. And here we stand between two groups of people, both of which I think are represented in this room, who seldom speak to one another, because those who feel a very strong religious commitment, and perhaps Suzanne Stone, whom I know quite well, is speaking from this perspective to some extent in her response to Robert Cover. In other words, Suzanne, who grew up in an Orthodox environment, one of her classmates is here today, and reports discovering when she arrived at Princeton as a freshman that there was a world of texts beyond those that she'd been exposed to in seminary, devours that world and still sees the world from a perspective of a very deep religious commitment. So the perspective is a theological one, and that is in part an explanation of her reaction to Robert Cover. She and others who try to sit in between the camp of the religiously committed, and Sam has done a magnificent job, a person with smicha from Yeshiva University who is able to write about Jewish law and American law in a way that not everyone from the yeshiva world would necessarily appreciate, because of the tremendous intellectual curiosity and openness that made it easy for Sam to recruit large numbers of students at Pepperdine who did not share his faith commitment, but who are fascinated by Jewish law. And Keith, who was here earlier today, regularly teaches large numbers of Catholic students who experience a different religious commitment. So Sam and Keith, and actually Suzanne Stone, and we today have tried to bring together in a conversation that began last night, people who do not often speak to one another or, more importantly, listen to one another with a kind of respect and openness that all of you in this room exhibit and contribute to, and this conference contributes to, and the publication of these articles by the Touro Law Review will contribute to. I want to thank Sam for the stimulus of his 2 volumes and his many years of articles, which have helped us to be in a place. And I think those of you who have attended conferences on Jewish law and who have taught Jewish law know it is not an easy thing to bring together a group that is as diverse as the one we have brought together, and to do the intellectual work that has been done here today with genuine respect and openness. And I think in doing that, we emulate the Almighty, Lou, Judge Kornreich. And in a way, I think it is a tribute to the robustness of the tradition. And I think it is actually what we call a Kiddush Hashem, a sanctification of God's name, that we can talk about these texts in this way to this audience and those who may be watching the live stream or may watch it in recorded form. Jewish law is for the ages. I said this morning, I hadn't planned to say it, in talking about the way in which Miranda relies upon Maimonides, and I hope you'll forgive me for repeating it. Miranda may have been gutted by the Supreme Court in 2010 in any case, but whatever one's view of the law on evidence and confessions and voluntary confessions, coerced confessions, and so on, that Miranda addressed itself to, I think that the Rambam, Maimonides, to whom Judge Warren reaches 900 years in the past, will be read and studied by Jews and non-Jews long after Miranda is forgotten. And I think that the sense, the shared sense in this room, that the texts and traditions we're dealing with belong to us, are our property by a kind of kinyan, if I may, is a sense that each of us has and that brings us to this room. I'm deeply appreciative of it. No one gets away with a meeting with me, and we're meeting together, without a substantive discussion. So last night, I put some text on the table, very difficult discussion of agency from Tractate Kedushin, very controversial passages from Justice Menachem Elon about the role of Jewish law in the state of Israel. And we had a conversation that Keith described as electric, and I'm very grateful for that. But I think if you have the right texts, you really don't have to do anything. So I have, to continue the conversation over dinner, I have 2 texts that I'm going to put on the table, and those of us who are staying for dinner, I hope, will find a way of engaging those texts. One of the texts, interestingly, and I didn't know what Judge Kornreich was going to say, speaks to this very question, that a judge must experience the terror of judgment. A judge must have a fear of the Almighty. And there are a few Mishnayot from a couple thousand years ago, located in the first chapter of Tractate Pirkei Avot, that discuss the requirements of a judge, that discuss the requirements of a judge. And I'd like to put those on the table, a Hebrew facing English translation, and see what we can derive from them. And alongside that, I would like to put an essay whose anniversary is today, from April 1st, 1940, composed by our favorite Supreme Court Justice, April 1st, 1940, our favorite Supreme Court Justice, who was Attorney General of the United States, who was at Nuremberg, who did not go to college, who went to 1 year of law school, and that is Robert Jackson. Robert Jackson. His essay on the federal prosecutor, which has a passage towards the end. And you'll find the passage where he talks about, he uses the word gentlemanly. He uses the word gentleman to describe prosecutors. So we have to find a gender neutral term for that. But he talks about the attributes of a prosecutor, the prosecutor's humility, sense of fair play, and so on. And I want to put out these two texts, the Mishnayot from Pirkei Avot that talk about judicial temperament, and I would direct your attention in particular to the end of the essay by Robert Jackson. And I think you can parse my own feeling is, you'll come to your own conclusion, you can parse every word of what Justice Jackson says, each clause, and you can find a source for it in a Jewish text. But I leave that to you, and I will put out the texts, and we will never stop learning together. Thank you.
Spencer Tracy. Yes. I know. I use Jackson because I use Spencer Tracy. From judgment.